Quote, Frederick B. Wiener. Briefing and Arguing Federal. Appeals 125 Reverend ed. 1967. Preface. In law, the quality of writing matters. Good writing can win cases, and bad writing can lose them. To some, this notion is self-evident, but to others it's dubious at best. What explains these markedly divergent views? Ultimately, the disagreement hinges on the extent to which a given lawyer understands how language molds every human thought. Language is embedded in the very way we perceive the world, so it's impossible for a lawyer or a judge to focus exclusively on the merits of a case without being affected by the language used to express those merits. When you write a brief, your implicit promise is that you'll give the judge good reasons for ruling as you request. This is all that matters, successfully persuading the judge to rule in your client's favor. Brief writers tend to pity themselves and complain about judicial readers and their shortcomings, not reading closely enough, not allowing you enough pages, delegating study to law clerks, etc. But good brief writers turn their complaints into challenges to mastering the writer-reader relationship. An objective observer would probably sympathize with some degree of self-pity because of the immense challenges you face. But an objective observer would probably pity your readers, too. Until you understand why brief readers should be pitied, you can't possibly write good briefs. Think of the judge's reading life. An endless stream of paper passes before the judge's eyes, with too little time to study each case and searching detail before the stream stagnates, becomes a massive stack of paper, and then becomes a fire hazard. And what does the stack consist of? Lots of rote phrases at the beginning and end of each document, loads of boring sameness, with everything spread out gradually through the middle, because the writers either can't or won't summarize. Sometimes law clerks read the briefs, not judges. It doesn't matter, whoever the reader is, one thing is certain, run-of-the-mill brief writing is pretty bad. It's slow and dull and abstract and digressive. It's sobering to think that bad briefs can lose strong cases. But this surely happens all the time. Judge Thomas M. Reevely of the Fifth Circuit convincingly cites a case in point, a case that was very nearly decided wrongly because of bad briefing. It was a wrongful death case against the federal government, involving a patient who had been negligently misdiagnosed by Veterans Administration doctors. They told him he had a hernia that couldn't be operated on until he first lost weight. Actually, though, he had a tumor in his colon, which soon burst. He underwent emergency surgery and survived, but his blood transfusion infected him with HIV, and he eventually died of AIDS. At trial, the decedent's family was awarded a judgment of $700,000. The VA appealed, filing what Judge Reevely called a 28-page hide-the-ball brief. In it, the government lawyer danced around the real issues and made various irrelevant arguments. The plaintiff's lawyer responded with a 32-page brief that didn't uncover the ball. It too was cluttered with fuzzy fact summaries and unconnected legal points. Neither side's brief accomplished what it was supposed to do, focus the appellate court's attention on the issues. And this in what Judge Reevely called a very simple case. The judgment found clear support in the evidence, but you would not know it from reading the briefs. And the appellate judge who got the case on the summary calendar wrote an opinion reversing the judgment. Fortunately, the next judge on the summary panel chose to let the case be argued. I was on the oral argument panel. The argument shed no more light than the briefs did, but I read the record and, seeing ample support for the findings, affirmed. It was an excellent example of what ails us, and I assure you that this is not an unusual story. Asterisk. If not for the careful judge on the summary calendar panel, and then for Judge Reevely himself, the plaintiffs would have lost $700,000. Stories like that one are played out in appellate courts throughout the country. When the plaintiff ultimately prevails, the plaintiff's attorneys regale each other about how wonderful their briefing was. When the defendant ultimately prevails, the defense attorneys do the same. But the truth in many cases, certainly in far more than the lawyers would care to acknowledge, is that the briefing was poor on both sides. It's just that somebody had to win. You can't say, of course, that superb briefs will always prevail. The merits of the case surely have something to do with winning. But statistically a good brief will improve your chances. It will help you highlight the merits for your side. It will entice judges by asking less of them, less elbow grease and less brain sweat. All this can be pursued methodically. This book tries to chart the path. Blank. This book, and the CLE course for which it was developed, resulted from 3 proximate causes. One was my nagging observation that, as writing is generally taught, even the most recurrent tips often surface merely by chance. They're part of the oral presentation but aren't to be found in the written materials. Or if they are there, they aren't in black letter form. As one writing teacher has well said, the means by which a person can gain help from the writing experience of others are not obscure, they are merely scattered. A second impetus was my continuing dissatisfaction with both the literature and the practice of brief writing. Rarely does the literature relate the brief writer's special concern, persuading judges, to the larger field of rhetoric. And a large percentage of briefs are so poor that judges find them a grave disappointment, failed attempts at persuasion. Something must be done. Third, my friend Jordan Cherrick of St. Louis urged me repeatedly to develop a CLE course designed exclusively for brief writers. True, my Advanced Legal Writing and Editing course has long dealt with brief writing. But it also deals with letters, memos, and reports. Jordan suggested in 1995 that I do a full day on nothing but briefs. And so, with his prompting, I decided to collect the 100 tips that I most commonly give to brief writers. The chief difficulty wasn't in reaching 100 tips. Hardly. As I had suspected, the chief difficulty was in narrowing the list down to 100. I could easily have made it 150. Notice that I call them tips. They're guidelines, not dogmas. Although I feel strongly about the advice here given, you are sure to encounter situations in which you'd be better off ignoring it. Not all the tips are equal. Some are intellectually challenging, such as number 8 and number 88, and some are quite easy, such as number 55 and number 65. Brief writers should work on the challenging points and assimilate the easy ones. In June 1996, we made our first national tour with the program, holding it in 8 cities: Chicago, Dallas, Houston, Los Angeles, New York, San Francisco, Seattle, and Washington, D.C. At each of those cities, the seminar proved quite popular. In 1997, we added Cleveland and Columbus. And in 1998, we added Minneapolis, New Orleans, and San Diego. Since then, we've occasionally added Boston, Detroit, Kansas City, and Sacramento to our June schedule, as well as a few other cities. This book, like its earlier incarnations, owes much to the extraordinary skill and industriousness of my law pros colleagues, Tiger Jackson, Jeff Newman, and David W. Schultz. Also, the book shows the strong influence of 2 other law pros colleagues, both English professors at the University of Texas, Drive. Betty S. Flowers and Dr. John R. Trimble. Flowers, of course, laid the groundwork for the Flowers paradigm, tips number 1 to 7. And Trimble's aura as an editor and teacher has greatly influenced me. Not only is he quoted in various tips, but his seminal ideas pervade the book as a whole. I also thank Karen Magnuson for her excellent help in copy editing. Finally, I continually learn from the participants in this and other seminars. I'm still collecting good examples of brief writing, and I'm always grateful to participants who send me their work. So if you try to follow the principles in this book, or if you have an opponent who flouts them laughably, send me more stuff. Brian A. Garner. Dallas, Texas. November 2003. Part A. Composing in an orderly, sensible way. 1. Plan every writing project by breaking it up, and carry it out in stages. Quotable quotes. Lawyers are inclined to act too quickly and to think too little, if they ever think at all. A brief is not written even by a brilliant lawyer in a single afternoon. If it is, the product is unworthy both of the client and of the court. Before writing a brief, it is necessary to plot out the exact line of attack or defense fully. The brief should contain only one key point with possibly 2 or 3 material but subordinate points of attack or defense. Gene Appleman, The Written Argument on Appeal. 41 Notre Dame Law. 41, 1965. How does one manage this feeling of being overwhelmed? It's like eating an elephant. You do it one bite at a time. Sit down and spend a few minutes breaking the project into logical bite-size units. Check your deadline. If it's a big project, figure out how far along you want to be with the job by when. Then mark these stages down on your calendar. Karen Mack and Eric Skye, Overcoming Writing Blocks 57, 1979. Breaking down the various decisions involved in writing into separate stages reduces panic by making the job less awesome. It also makes writing a routine. No longer are moods of inspiration needed, no longer is writing only possible when you are exceptionally awake and fresh. The various stages can be worked through even when you are tired, or simply not feeling like concentrated creative thought. All professional writers learn this early in their careers. You probably use writing as an adjunct to professionalism in other spheres, but learning the divide and conquer techniques of the professional writer is still a valuable career asset. Christopher Turk and John Kirkman, Effective Writing, Improving Scientific, Technical, and Business Communication 43, 2D ed. 1989. Before actually beginning to write, do 2 things. First, ensure that you have a strong thesis. There's a good way to tell if you have one, but it takes courage. Write on some notepaper, I contend that, and complete the sentence. Second, have on hand a list of concrete details and apt quotations, and be ready to use them. Remember, if you lead off with a string of abstract generalizations, your reader may impatiently mutter, sheesh, and tune you out. John R. Trimble, Writing with Style 29 to 30, 2D ed. 2000. Explanation. Most writing advice focuses on the end product. But we shouldn't neglect the process by which writers produce their words, because, in important ways, the process determines the product. Now, I can't tell you what type of pen to use or what to sip while you're working. You can't teach the physical aspects of writing, but it's quite possible to teach the mental aspects of writing. Before we get to that, though, think of the ways in which legal writers so frequently get mired. By starting to write in earnest before they fully understand what they're writing about, and then treating that draft as something sacrosanct. By sidestepping the creative stage altogether, so that the brief isn't nearly as imaginative as it could be. By writing and sharpening sentences before knowing what the overall structure will be, and thereby wasting valuable time. When structural changes later emerge, as they inevitably will, this early work will have to be changed. By allowing their critical side to interrupt throughout the process. How can you avoid these pitfalls? The Flowers Paradigm. Madman Architect Carpenter Judge. Several years ago Dr. Betty S. Flowers, a law prose instructor who teaches in the University of Texas English Department, devised a method that dramatizes the writing process. Her method helps minimize the problems and maximize both efficiency and effectiveness. It's called Madman Architect Carpenter Judge. It breaks down the writing process into 4 steps, each one based on a character or personality that we all have within us. The madman is full of ideas, writes crazily and perhaps rather sloppily, gets carried away by enthusiasm and desire, and if really let loose, could turn out 10 pages an hour, p. 7. Typically, the legal writer doesn't really write at all during this stage, but instead takes copious notes, jotting down ideas and possible approaches to a problem. The madman's nemesis is the judge, your critical character who really needs to be reined in until the final step. But many legal writers have an out-of-control judge, who is easily recognizable. As Flowers describes the judge. He's been educated and knows a sentence fragment when he sees one. He peers over your shoulder and says, "That's trash," with such authority that the madman loses his crazy confidence and shrivels up. You know the judge is right. After all, he speaks with the voice of an English teacher. But for all his sharpness of eye, he can't create anything. ID. The secret to diffusing this battle between madman and judge is to keep the judge at bay until the end of the writing process. Otherwise, the judge will stifle the madman altogether. But what about the other steps? Once the madman has generated lots of ideas, the architect takes them, makes connections between them, and starts planning their structure. In the first instance, the architect's work is nonlinear, but it will end up in the form of a linear outline. This means that the outline will finally have the form that seems obvious to most people today but was a great insight when Aristotle devised it: a beginning, a middle, and an end. And if the architect functions satisfactorily, ultimately producing a linear outline, you'll know each intermediate point, step by step, through the middle parts of the brief. In fact, the more detailed the architectural plans are, the better. Then comes the carpenter, who starts building the draft. At this stage, the writing begins in earnest. And because you've planned the draft, the carpenter's work is greatly eased. It's more or less a matter of filling in the blanks. That may overstate how easy the carpenter's work is. But the process of building is greatly simplified when you have the architect's specifications laid out in front of you. Charles Allen Wright makes this very point in the Scribe's Journal essay in which he describes his writing process. For my kind of nonfiction, it is necessary first to have a complete grasp of whatever subject it is I am going to be writing about. This we can take for granted, though the research is often long and tedious. The next stage, and to me the hardest of all, is organization. I never sit down to the keyboard. In the old days it was a typewriter, then an electronic typewriter, and in recent years it has been a computer, until I am clear in my mind how I am going to organize whatever it is that I am doing. That's why, earlier in his essay, Wright says that writing is easy, the preparation is the difficult part. The most important thing about the carpenter stage is to write rapidly, without editing along the way, simply filling in the details according to the architectural specs. If you edit, then the judge starts getting active, and this is just the type of interference your carpenter doesn't need. If you get stuck in a certain part, then move to the next section, you may have to leave a little hole here and there. You'll notice, too, that the carpenter has some discretion, deciding how to finish off a corner, how to build the passage from one room to the next. Some architectural details, in other words, are left to the carpenter. Once your carpenter has built a draft, the fun begins for your judge, who can start looking for ways to improve the draft. The judge will check many of the things that the rest of this book is devoted to, whether there are transitions between paragraphs, whether you've used passive voice where you really shouldn't have, and so on. And the judge will check many things that aren't mentioned in this book, from comma splices to misplaced modifiers to subject-verb agreement problems. The judge is a quality control inspector. Each of these characters needs time on stage, at the forefront of your brain. If you neglect any of them, your writing simply won't be as good as it might be. 2 qualms answered. But is it possible, in the hurly-burly of a busy law practice, to go through these 4 steps with every writing project? Of course, even in the space of an hour-long writing project, you can spend 10 minutes on Madman, 7 on Architect, 20 on Carpenter, and 10 on Judge. What about the rest of the time? Well, you need breaks in between, both to get away from the project momentarily and to shift your focus to that of another character. But isn't it true that we all approach problems differently? Isn't that the lesson of Myers-Briggs and other personality tests? Yes, and Flowers designed the paradigm with this in mind. Everyone is most comfortable working in a particular compartment of the brain. This approach ensures that you benefit from all that your brain has to offer, not just from the mental realm you're most comfortable with. I, for example, spent years neglecting the architect. I wrote highly polished sentences and paragraphs, and people who read my stuff generally thought of me as a good writer. But when I now look at what I wrote in those days, some of it appears to be a highly polished mishmash. The organization was unpredictable. Now that has changed, and writing has become relatively painless for me, and much quicker. I do what Professor Wright mentioned. I plan my writing better than I used to. Advantages of the Flowers paradigm. In her original essay, Flowers pointed to 8 advantages of her paradigm, rewritten here with my glosses. 1. It's easy to remember. 2. It stresses the sequential nature of the writing process, that you're likely to get better results if you work through the Madman stage first rather than going back to the idea stage after you've spent 3 hours crafting sentences. 3. It dramatizes the need for rewriting and gives a sense of individual purpose to every draft. 4. It breaks the writing task down into manageable stages and allows you to enjoy each stage, that is, it shows you how to do one thing at a time. 5. It diffuses the conflict that often arises when you try to write for an authority figure. 6. It offers a way to deal with self-image problems that sometimes interfere with the writing process. That is, if you see yourself as a creator, you might be impatient with the polishing and careful proofing that the judge can provide, and that every draft needs. And if you see yourself as a consummate critic, you may have a highly repressed style characterized by dry and unmemorable but technically correct prose. 7. It gives a new language for critiquing drafts, one that doesn't shove the editor exclusively into the role of judge. Now, an editor can look at a brief and say, try playing the Madman more with this section, rather than just picking up a red pen and marking away. 8. It clarifies what you can and can't teach about writing. The Madman stage is personal and subjective, a private area left almost exclusively to the writer. The judge can be taught from good writing texts. But in the architect and carpenter stages, where many writers are least experienced and usually least well trained, a teacher can be very helpful. Many writers need more help with the writing process than with anything else. For those who do, the Flowers paradigm can be invaluable. You'll likely find that you can most readily apply the rest of the tips on process, number 2 through number 7, if you capitalize on the paradigm. 2. When first working on a writing project, let the madman run loose for a while. Quotable quotes. Ordinarily, not always, but more often than not, writing proceeds like this: collecting material, trying to find a good approach, spending some time on something else, getting a sudden bright idea, planning and organizing, writing, revising. The most mysterious, and most fascinating, part of the whole process is the one you don't read about in the handbooks: the search for a good approach, the period when you abandon the search, and the moment when, out of nowhere, an idea pops into your mind. Maybe you won't believe me when I say that this is common experience. Alright, I'll cite chapter and verse. This is the way the human mind works in creating anything, whether it's the mind of a poet or a mathematician, a philosopher or a historian, a scientist or an advertising man. Rudolf Flesch, The Art of Readable Writing 55, 1949, Reaper. 1967. The attorney must allow his ideas to develop over a period of time. He should jot down ideas as they come to him, even developing ideas in their entirety but taking care not to write the full argument. As he does research upon the facts or the law, more and more ideas will come to him so that his notes should begin to grow and even overlap each other, but it will be simple to organize the material at the proper time. Until this meditating process is complete, a lawyer should not attempt to write his brief. Gene Appleman, The Written Argument on Appeal, 41 Notre Dame Law. 41, 1965. The point is that a deeper level of thinking can go on when you relinquish your conscious grip on your material. A kind of letting go is necessary for this deep cooking. Having a beer, taking a walk or a bus ride, taking a nap or a shower, these all serve some people as ways of letting go. Peter Elbow, Writing with Power 40, 1981. Your subconscious mind is more writing than you think. Often you'll spend a whole day trying to fight your way out of some verbal thicket in which you seem to be tangled beyond salvation. Frequently a solution will occur to you the next morning when you plunge back in. While you slept, your writer's mind didn't. To some extent a writer is always working. Stay alert to the currents around you. Much of what you see and hear will come back, having percolated for days or months, or even years, through your subconscious mind, just when your conscious mind, laboring to write, needs it. William Zinsser, On Writing Well 126 5th ed. 1994. Explanation. Few legal writers seem to think of their work as being essentially creative. They often think that writing well is simply a matter of finding the law and getting it down. In fact, though, every brief presents opportunities for creativity, for imaginative approaches that will convey the point most effectively. In example below, Mike Hatchell of Tyler, Texas, begins a motion for rehearing with a play, in which the lawyer tries to make sense of an intermediate court's holding. Not only did Hatchell succeed in persuading the court to accept the appeal it had earlier rejected, he also succeeded in having the lower court's decision altered. Asterisk. Example B, by Neil Goldfarb of Washington, D.C., also contains a prologue, but it's not in the form of a play. Instead, he uses a series of hypotheticals to open an amicus brief on behalf of 3 victims' rights organizations. In doing so, he takes a difficult constitutional issue and frames it favorably for his clients. All of this is not to suggest, of course, that you should start writing fictional prologues in your briefs. Instead, you should think hard about how best to get your point across. You may think of apt illustrations, analogies, diagrams, and other devices. Don't stop when you've thought of the most obvious approaches. Delve more deeply. Example A. The prologue follows a listing of points of error, which were required in Texas appellate practice until 1997. The Court of Appeals erred in failing to reach and sustain Collar Times point of error number 13, because there is no evidence to support Triad's tortious interference claim, as submitted and determined in questions numbers 7 to 8 trail. 113, 125 to 127, 129 to 130, 153 to 154, IVSF. 113 to 114, versus SF. 113 to 114, 120, MFR assignment no. 50. 9. The court has erred in failing to grant Collar Times' application for writ of error and to reach and sustain Collar Times' conditional assignment number 2, which reads as follows. If it is determined there is a scintilla of evidence to support questions numbers 7 to 8, the cause should be remanded to the Court of Appeals to rule on Collar Times' conditional point of error number 14, which is in the exclusive jurisdiction of that court, reading as follows. The trial court erred in failing to grant defendant's motion for new trial, because the jury's answers to questions numbers 7 to 8 are not supported by factually sufficient evidence or are against the great weight and overwhelming preponderance of the evidence. MFR assignment no. 51. Prologue. Well, apparently not in Texas. Scene, corporate boardroom of Widgets and Surfboards Plus, Inc., a manufacturer of widgets, surfboards, and gadgets with a major share of the Corpus Christi market and minor facilities in El Paso and Texarkana. Players, the chief executive officer, 3 directors, and the corporate counsel. Staging, a conference table, a Black's Law dictionary, a Webster's dictionary, a telephone, a newspaper, and a large bottle of Tylenol. Blank, blank. CEO, gentlemen, I got good news and bad news. The bad news is that sales have been soft this quarter and, with the payment of our retainage to settle that injury suit against one of our truck drivers, profits are, zilch, this quarter. In fact, we've sustained about a 10% loss. Now, we've got to do something to turn this around. Director 1, what do you suggest? CEO, well, I think the price of our widgets is at the limit, and, if we lower it about 20%, we ought to be able to increase sales, reduce our per product overhead by using up some idle plant capacity, and, maybe, even permanently increase our market share. That ought to turn profits around real quick. Director 2, great, let's do it. Counsel, not so fast. That may be illegal. Director 3, come again. Counsel, yeah, there's this new case out of the Corpus Court construing the Texas Antitrust Act, Collar Times versus Triad. It says, if a business tries to increase its market share, in other words, if it takes business away from its competitors, by cutting its prices and the price is cut by a % greater than the business's profit margin, that's evidence of what's called predatory pricing, and we can be sued by a competitor for treble damages. CEO, you've got to be kidding. Counsel, I'm dead serious. And, you see, since we have a zero profit margin, we can't lower prices. In fact, this case is so dangerous, I was prepared to suggest we raise our prices 10% on all products, because, under that case, if we maintain our present prices in the face of this loss, that might be considered a de facto cut and our present prices might be illegal, or might become illegal even as we speak. The court didn't distinguish between product lines in that case, either, didn't seem to make any difference. So, even if the price of our widgets is way over what it costs to make them, especially with higher production, we still run the risk of predatory pricing, because, you see, the evidence in that case was just overall profit margin. Director 3, but, look, to raise our prices now when we need to lower them, and we can lower them and still make money, that's economic suicide. It's just insane. Director 2, now, wait a minute. Look at today's paper. Here are all these businesses advertising 25% off, 33% off, 50% off, here's one even 75% off. You know, Oriental rugs are 50% off all the time. Now, I know none of these businesses have that kind of profit margin, except maybe Oriental rugs. Are you telling me they're all violating this law? Counsel, well, let me put it this way. No one can say they're not, that's because you can't say what their profit margin is when these cuts are made. I bet they don't have a clue about what their profit margin is during these sales. They're all at risk under this case. Director 1, let me get this straight. I can understand why someone might say we can't lower our prices to a point that we consciously take a loss on that product just to increase our market at a competitor's expense, but what does profit margin have to do with that? It's just some balance sheet deal, a function of overall operations, bookkeeping transactions, maybe bad investments, off-the-wall accounting theories, like FASB 38, and all that, none of which has anything to do with whether we make money selling a product, like widgets. My gosh, you just heard that our profit margin, or the lack of it, is due to stuff that doesn't have anything to do with making money from sales, especially widgets. This is crazy. Counsel, I know, but it's the law. Director 1, well, at what point in time do we compute this profit margin test? Is it today's or last month's or last quarter's? Gosh, we might actually have a favorable profit margin next quarter after we lower prices, especially if we can increase cash flow and we don't have these extraordinary expenses unrelated to production. Are we stymied because we didn't make money this quarter? Counsel, that's a good question. This Collar Times case doesn't really say. The testimony they used didn't identify if it was today's margin or last year's or just some historical average. As I say, it was just profit margin. There were just a couple of lines of testimony about it. Director 2, well, can't we just refigure our profit margin under some other theory? Is it cast in stone how you compute that? I mean, how did the Corpus Court figure it? Counsel, they just took a definition from Black's Law Dictionary. Here it is. Sales minus all expenses is a single amount, frequently used to mean the ratio of sales minus all operating expenses. Director 1, they define an economic concept from a law dictionary. Counsel, yep. CEO, but I still don't understand what all operating expenses has to do with the profitability of the price of one product. Is Black's definition related to antitrust law? What reference does Black's give for that? Counsel, it doesn't, no texts, no cases, no nothing. You can't tell what they're talking about. Director 3, look, Webster defines it differently. The minimum return or reward, barely covering the costs of production. Now, that seems to me to be more what we're talking about here. The cost to produce one product. Which dictionary definition do we use? Counsel, don't ask me. CEO, well, if the lawyers don't know, I certainly don't. Counsel, don't get mad at me. I didn't write the silly thing. Director 3, call the accountant. Maybe he can help. CEO, after dialing Charlie, this is Mac over here at Widgets and Surfboards Plus. We need some help. How do accountants figure profit margin? Offstage voice. Well, that's not an accounting term. We don't recognize it in any official way. It can mean just about anything. In the eye of the beholder, so to speak. I can give you a bunch of textbook definitions, but they're all different. CEO, oh, great. Offstage voice. This must be about that Collar Times case. Everybody in town has been calling me about that. You seen today's paper? All the guys running sales are in a sweat. Nobody believed this case was for real. Pretty weird, huh? CEO, yeah, and scary, too. Makes you wonder if this is the USA or the Twilight Zone. Well, thanks. Hangs up phone. Terrific. The lawyers can't tell us what we can do or what test to follow, the accountants can't tell us. What did the trial court tell the jury in that Collar Times case? Counsel, that's an interesting question. In fact, in that case the plaintiff said there wasn't any test other than intent to target your competitors' customers with low prices, even if they were profitable, and Caller Times said you should use a test out of the Federal Fifth Circuit that asks whether the price is below average variable cost. That's a complicated economic term, but at least you can figure it out using standard economic data. So, what happened? The court didn't tell the jury anything. This profit margin business was invented in the appeals court. CEO, alright, what you're telling me is that this case was, what do you lawyers call it, affirmed, on some theory that neither party said applied, that the judge didn't tell anybody about, and the jury didn't know anything about. Counsel, precisely. Director 2, is that legal? Counsel, well, it happened. Now, fair, or, logical, is another matter altogether. CEO, is it correct to say, then, that the only way we can know if our prices today are legal or illegal is to get ourselves sued? Then some months or years down the road, a jury tells us, but they don't have any rules to go by, other than maybe big guys versus little guys. And, that jury finding can be upheld by looking at some law dictionary and, then, figuring out what our profit margin was sometime, doesn't make any difference when. Counsel, that's about the size of it. Director 3, this Caller Times case, is that the last word? Counsel, well, at least here in corpus it is. Now, I don't know what the other courts of appeals will do. Director 1, well, what can they do? Counsel, they can adopt some different test and different evidence rules. Director 2, get serious. You mean if our prices here in corpus are illegal, still, the same kind of prices under the same circumstances can be okay in Texarkana or El Paso? Counsel, that's exactly right. Corpus decisions just bind corpus. There could be as many as 14 different tests. In fact, it's pretty certain there will be other tests. The federal circuits, and our act is supposed to be construed in line with federal precedent, have adopted various definitions of predatory pricing, but they all use an economic test based on cost of the goods versus price. There isn't any case anywhere that's allowed profit margin to prove cost to make one product. And, for obvious reasons, you can see, our profit margin says very little about what it costs to produce and sell our widgets. In fact, it may be terribly misleading in that regard. We make good money on widgets. Director 3, tell me this is just a bad dream. I mean, won't the Supreme Court just straighten this thing out? Counsel, well, you would think so. The specialist antitrust lawyers are in an uproar about the case. Really, it's so ludicrous, they just laugh at it. There was this speech in Dallas last week about it, pointed out that even the test corpus purports to adopt makes, mincemeat out of its reasoning and result. So, everybody has just assumed the case will be reversed or sent back because it was tried on the wrong theory, or something. But, bad news, the Supreme Court dodged the issue. It denied writ of error on September 6. CEO, what did it say? Counsel, nothing. Director 1, what's the basis for that? Counsel, well, about all you can tell is that the court thinks this just isn't important to the jurisprudence of Texas, that's their test for hearing cases. CEO, you mean, stating a test for predatory pricing under this statewide act? And saying how we can figure out whether or not we're violating the act today so we can stay out of court and stopping all these different tests from being created for different parts of the state. And keeping businesses from being dragged through the courts maybe with different results in different parts of the state for the same conduct, all because nobody knows what the test is. That's not important. Director 2, yeah, I thought the whole purpose of law was to have one place you could go look and tell what the rules are so you know how to stay out of court, so we can obey the law and avoid all this litigation expense. What's more important than that? Results. Why do we even have a Supreme Court, if they won't speak on those kinds of problems? Counsel, good question. These are hard cases, murky economic concepts and all that, they're really tedious. CEO, I'm not sure that really explains anything. I mean, it's the Supreme Court, isn't it? Silence. All stare into space. CEO takes Tylenol. Anybody got any bright ideas? Counsel, well, I do have a couple. This is the good news Mac was referring to. Let's try to make the best out of a bad situation. We've just learned that our principal competitor that has the lion's share of the market out in El Paso, since it had to pay a big fine to EPA last and used some loss carryovers, didn't show a profit last year. Now they're offering a 25% discount on widgets this quarter. On the other hand, since we just collected on these big open accounts claims we had to sue on, plus a lot of prejudgment interest, that gives us a profit margin of about 45%, at least this quarter. So, I say we lower our prices on widgets out there about 40%, at least to our competitors' customers. Now we may actually have some losses on that, but it's clearly legal to do it. That's what happened in the Caller Times case. At the same time, we write them a letter claiming their prices are predatory. One of two things will happen. They have to jack their prices back up under this corpus case, and, then, we ought to be able to run them out of their market pretty quick. Then, we will raise our prices back to super profitable levels. Or, if we fail, and that might actually be the better thing to happen, since El Paso is marginal anyway, we close down the plant and sue them for treble damages. Director 2, good thinking. All we've gotta do is prove their profit margin, last year, some price cut greater than that and the fact they want us out of the way, right? Counsel, right, and, that's a cinch. Then, we get the right jury and it's, Katie, bar the door. Director 2, well, sounds pretty unsavory to me, but the way I look at it, what's sauce for the goose, and all that. Director 1, yeah, if these laws work that way, there's no reason we shouldn't play the game. Director 3, Now, this just sounds like another tort theory to me. And another thing, it pretty much allows us to control our competitor's business, kinda creates a reverse monopoly, so to speak. CEO, one thing is curious to me. The customer gets the short end of the stick in all this. They pay our competitors higher prices if we force them up. Or, they pay our higher prices if we force our competitor out. And, they pay higher prices that now have to be maintained because of fear of these suits under this corpus case. But I was always told these antitrust laws were supposed to benefit the public with more competition and lower prices. Counsel, well, apparently not in Texas. Brief of the argument. This portrayal is not a figment of the imagination. It is already being played out in the offices of the financial advisors and legal counselors to businesses all across the state. Sadly, apart from the derision and ridicule to which the corpus court's opinion has been subjected, it has yet to find a scholarly champion. Only critics, e.g., Appendix A. The most common response is frustration and disappointment with the system. Frustration because legal advisors who genuinely wish to give their clients sage advice on how to properly price products under the Texas Antitrust Act have no tools with which to do so. They have no definitive test from the court of last resort. They have no certain evidentiary standards. They only have a result that has no analog in antitrust law anywhere, that resorts to bizarre, worthless criteria, and that is so internally inconsistent, it actually repudiates itself. Example B. Prologue. 3 cases. 1. Consider the hypothetical case of Peter Allayden and John Powell. Allayden was an enforcer for the mob. Powell was a small-time hood who aspired to move up in the criminal pecking order. Powell heard that there was a contract out on Thomas Hope, and he wanted to be the one who did the job. Since he had never before killed anyone, he went to Allayden for advice. Allayden spent an hour with Powell, giving Powell the benefit of his experience. Allayden told Powell what kind of gun to use, how to alter the gun to make it untraceable, where to aim the head, preferably the eye sockets, how many shots to fire, at least 3, and many other helpful hints. Powell followed Allayden's advice. He used the kind of gun Allayden had recommended, he altered the gun as Allayden had recommended, and he shot Hope 3 times in the head as Allayden had recommended, killing him instantly. After an investigation, the police arrested Powell and charged him with Hope's murder. At the police station, Powell broke down and confessed. He told the police about the advice he had gotten from Allayden. The next day, Allayden was arrested and charged with aiding and abetting murder. When Allayden was arraigned, his lawyer moved to dismiss the charges. Your Honor, he said, the charges against my client are barred by the First Amendment. The First Amendment protects freedom of speech, and the only charge against my client is that he spoke to John Powell, Mr. Allayden isn't charged with doing anything other than speaking. Since speech is protected by the First Amendment, the charges have to be dismissed. In the back of the courtroom, several lawyers tried to stifle their laughter. The prosecutor approached the lectern, but the judge waved her away. I don't need to hear from the state, he said. The motion is denied. 2. Now consider a variation of the first case. The facts are the same, but with one change. When Powell went to Allayden for advice, Allayden didn't have an hour to spare. So he gave Powell a book, Hitman, a technical manual for independent contractors, written by Rex Farrell and published by Paladin Press. Read this, Allayden said. It will tell you how to do it. Powell read the book and followed its instructions. He killed Hope, he was arrested, he confessed, and he told the police about the book he had gotten from Allayden. Allayden was arrested and charged with aiding and abetting. His lawyer made the same motion to dismiss. The only charge against my client is that he gave someone a book, he said. Books are protected by the First Amendment. This motion, too, was denied. 3. Finally, consider the case now before this court. The facts are similar to those of the hypotheticals, except that the killer was not John Powell but James Perry, that he obtained the book Hitman not from Peter Allayden but directly from the publisher, and that the victims were not imaginary Thomas Hopes but 3 real human beings. Those differences aside, the 3 cases are in all important respects identical. Paladin acted with the same knowledge and intent as Peter Allayden. Paladin stipulated for the purposes of its summary judgment motion that in publishing and selling Hitman, it intended and had knowledge that the book would be used, upon receipt, by criminals and would-be criminals to plan and execute the crime of murder for hire. Moreover, the result in all 3 cases was the same. Both Powell and Perry followed the instructions in committing murder. And Paladin's motion in the district court was the same as Allayden's motions in the hypotheticals. But while Allayden's motions were denied, Paladin's was granted. Paladin apparently agrees that in the circumstances of the first 2 hypotheticals, Peter Allayden could not hide behind the First Amendment. The question raised by this appeal is whether the hypothetical case of John Powell and Peter Allayden is any different from the real-life case of James Perry and Paladin Press. 3. Begin the architectural planning by stating the issues. Before writing in earnest, figure out how many issues there are, and what they are. Quotable quotes. It is impact not dead pull that drives a pile. Oliver Wendell Holmes, 1 Holmes Losky Letters 684, Mark D. Howe ed. 1953. The basic admonition to the lawyer who is sitting down to write the argument is simply this: never start to write until you have thought the case through and have completed your basic research. That doesn't mean every citation or footnote, but it does include a reading, and, whenever required, a rereading, of all the important cases, because the basic authorities are always full of suggestive leads for further development. Ellipsis. Concentrate on your problem, turn it over in your mind, think about it in tub or shower, try out your hypotheses on associates, live with the case in every spare waking moment, but don't start to write until the sequence and direction of your points have fallen clearly into place in your mind. Frederick B. Wiener, Briefing and Arguing Federal Appeals 136-37, Reverend ed. 1967. Ask yourself the 2 most important questions. Do I understand this? Can I explain it to my readers? Don't be satisfied until the answer to both is yes. George Kennedy et al. The Writing Book 36, 1984. Before any portion of the brief is drafted, the brief writer must be completely familiar with the record and generally familiar with the relevant law. This familiarity should enable the brief writer to ascertain those issues he wishes to raise and to prepare an initial draft of them. These draft issues can then give focus to the preparation of the other sections of the brief. As these other sections are written, it may develop that some modifications should be made in the statement of an issue to reflect a more accurate reading of the record or assessment of the state of the law. The writing of the brief should begin, however, with a draft of the statement of the issues. Robert J. Martineau, Fundamentals of Modern Appellate Advocacy. Section 7.30, at 142, 1985. Here is a useful rule for beginning. Know the story, as much of the story as you can possibly know, if not the whole story, before you commit yourself to the first paragraph. Know the story, the whole story, if possible, before you fall in love with your first sentence, not to mention your first chapter. John Irving, Getting Started, in Writers on Writing. 98 Robert Pack and J. Perini eds. 1991. The most important analytical step in the appellate process, in fact in most aspects of litigation, is framing the issues. Brian A. Garner, The Language of Appellate Advocacy, in Appellate Practice. Manual 188, 189 Priscilla A. Schwab ed. 1992. M. Ost Legal writers who write a lot are weakest in architecture because that's the most subtle, it's the organization. That's where the argument comes in, through the organization, and that's the hardest part of writing to teach because they don't get it in high school. Betty Sue Flowers, The Salt Interview, Betty Sue Flowers, 2 Salt J, November Dec. 1999, a 10-17. Explanation. This tip counteracts what is probably the most significant fault in the way lawyers write briefs. Advocates often seem to think they're knocking out some of the preliminaries before they think much about the core of the brief. Then they go ahead and knock out the first section because they have in mind what it deals with. And then what's left to do but the final section or two. With this kind of start, they're feeling as if the draft is virtually done. For these writers, the issues come as an afterthought. The problem, of course, is that a brief written in this way will simply talk around the issue without ever piercing to its center. And the writer will think that everything has been covered when in fact some key links are likely to be missing. If you're serious about writing good briefs, you shouldn't compose sentences and paragraphs until you have a good working statement of the issues. That's the proper starting point, not, as so often seems to happen, the ending point. How does the issue sometimes turn up at the end of a writing project? You see it in the flash of insight that somebody has the night before a brief is due. Suddenly, everything has to be reworked because the issue has finally emerged in the writer's mind. This is a prime symptom of starting to write too early. If you find that you have written too early, that is, the issues crystallize only after you've been writing for some time, you'll have to be ruthless with everything you've written before that crystallization occurs. Don't become wedded to sentences and paragraphs just because you've invested time in them. Be willing to discard them. So precisely where in the writing process should the issue framing come? In the madman phase? In the architect phase? Although there's no final answer to this question, the best practice is to write the issues before the outline. But when you're working with co-counsel, this isn't always possible. Your colleagues might have outlined the topics without stating the issues in the meaningful form of the deep issue outlined in number 8 to 12. If so, it's still not too late. Draft the issues before writing anything else. If you don't, the writing will probably end up being highly diffuse. How common is the problem? My guess is that more than half of all briefs suffer from this fault. And it's typified in the first of the two examples below, the second having been written by a lawyer who firmly grasps the issue. Example A is the opener from a party's brief, example B from an amicus curiae's brief. But many judges who have looked at these openers say there's no reason why the party's brief couldn't read the way example B does. A bad and a good example from the same case. Example A. This is an appeal by plaintiff, Dobbins Medical Center, under Section 19 of the Administrative Procedure and Register Act, from an order of the Maryland Health Facilities Commission granting a certificate of need to charter Fenton, Inc., a wholly owned subsidiary of Ackland Medical Corporation for Fenton Hospital, Baltimore, Maryland. On December 10, 1994, the Commission accepted and dated the application of Fenton for a certificate of need to construct, equip, and operate an 80-bed psychiatric and addictive disease facility containing 43,410 square feet to be located in Baltimore. Fenton originally proposed 60 psychiatric and 20 addictive disease beds but later amended its application to 64 psychiatric and 16 addictive disease beds. Plaintiff filed a notice of intent to become a party to the application of Fenton, which request was accepted by the Commission on January 11, 1995. Defendant, Pearly Hospital Group, also filed and was accepted as a party to the application of Fenton. Example B. This case involves two contradictory decisions by the Maryland Health Facilities Commission concerning 3 applications to build new 80-bed psychiatric hospitals in Baltimore. The hearing officer who heard all the evidence found a proven need for 2 of the 3 new hospitals. The Commission voted 3-0 to adopt her report but voted 2-1 to deny as unnecessary one of the 2 hospitals she recommended. Neither the Commission majority's stated findings of fact nor substantial record evidence supports this illogical result. The majority's action arbitrarily violated the Commission's own rules of procedure. The result, if not rejected, would prevent elderly psychiatric patients in Maryland from receiving care that neither the newly approved hospital nor any existing hospital will provide. 4. Once you've drafted issue statements, read more law and take plenty of notes. Tweak or even rewrite the issues. As you continue researching, then organize the issues from Most important to least important. Quotable quotes. You seek an arrangement that will keep the reader intensely reading and make a clear and memorable impression. Hang on to the underscored phrase, for it has the virtue of making your mental muscles pull hard. Gorham Munson, The Written Word 109, Reverend ed. 1949. Key arguments in many appellate briefs are wholly without any recognizable form or shape. They begin nowhere, proceed along meandering lines, and end nowhere. They quote a sentence or two from a court opinion, make a couple of collateral remarks, posit a general principle, refer to a fact or two, quote some more, and end with a conclusion that the trial court was in error. The judge reads such a brief, rereads it to make sure he did not drowse the first time, and then tosses it aside as useless. When a lawyer prepares the argument in a brief, he ought to recognize in his own mind what the nature of the argument is, and then he ought to cast it in that form. Barrett Prettyman, Some Observations Concerning Appellate Advocacy. In Advocacy in the King's English 259, 266-67, George Rossman ed. 1960. Organizing thoughts before writing is pleasant and profitable, but organizing after writing is wasteful, irritating, and inefficient. Planning is not the second, third, or fourth step, it must be the first. H.J. Tichy, Effective Writing for Engineers, Managers, and Scientists 9, 1966. The question will naturally arise, how does one know when the case has been thought through, or when the basic research has been completed? The only answer is, you come to sense it. There isn't any gauge or instrument, it is just a feeling. How do you know when you have had enough to eat? It's the same sort of thing, an instinctive reaction that develops after a time. You will recognize it, never fear, and when you do, then you can safely start writing, but not before. Frederick B. Wiener, Briefing and Arguing Federal Appeals 136-37. Reverend ed. 1967. Let us assume you have the information all ready to assemble. Some of it is in your mind, some of it in charts or other reports in front of you, some of it in rough notes on a piece of scratch paper. The ideas you want to put across are clear enough to you, but expressing them will take at least a couple of pages, and maybe much more. You have lived with these ideas, you are literally steeped in them. How in the world, you wonder, am I to put the gist of them in a short opening paragraph or section? They're just not that simple. You need to do the same thing that practically every good writer has done since the first cogent stone tablet was delivered by a caveman messenger, step back mentally from the details and try to see just the essence of the message. Admittedly, this is easier said than done, but any writer of any message, no matter how complex, can do it if he or she wants. David W. Ewing, Writing for Results in Business, Government, and the Professions 56 1974. A.L. Ways Take Notes in Your Own Words. Jacques Barzin, Simple and Direct 170 1975. Experience shows that you must take notes in a uniform manner, on paper or cards of uniform size. Some researchers favor notebooks, bound or loose leaf, others prefer ruled or blank index cards, 3 x 5 inches, or 4 x 6, or 5 x 8, but one size only for the main materials. Those who use notebooks, large or small, copy out facts or quotations as they come, regardless of subject. They leave a wide margin straight down one side to permit a keyword or phrase to be put opposite each note as a guide to the eye in finding and classifying that note. Jacques Barzin and Henry F. Graff, The Modern Researcher 22, 5th ed. 1985. For most of us, uncertainty about which words to use stems mainly from uncertainty about what we want to say. Usually, if we have the underlying framework of our ideas straight, the writing of the first full prose draft can go ahead much more confidently and rapidly than if we are still trying to work out what sequence of statements we should make. Christopher Turk and John Kirkman, Effective Writing, Improving Scientific, Technical, and Business Communication 39, 2d ed. 1989. Explanation. During research, go through several Madman architect cycles before you begin to write in earnest. Sketch out the big points you need to cover, and supplement this list throughout the process. The Madman and the architect work closely together, and during your research, you'll likely find yourself shifting from one to the other. This collaboration often works in either of two ways. There's the research mode and the intuitive mode. Most brief writers probably use the research mode. That is, they do book research first and write later. If you're working in this way, then every time you read a case, for example, you ought to be thinking creatively about how it fits into what you're writing. And at nearly the same time, you should be tying it with the other cases that relate to your subject. As you fill in the configuration of these cases, you'll be using your imagination as well as your spatial sense. Some excellent brief writers, though, work in the intuitive mode. They've worked in law for many years, typically, and know its contours pretty well. They are capable of organizing and even drafting a brief without any prior research, confident that there are cases in the books to support what they're saying. If you work in this mode, you'll conceptualize the brief and then write it, and you'll find the cases later, often tweaking what you've said about the law depending on what you find in the cases. Now a word about taking notes on case law. Make your note-taking systematic, not just for one brief, but in case after case. It's not enough to print off cases and highlight them. That's passive. You'll need to write case briefs that look something like this. Front. In Ray Banks, 299 F3D 296 4th CIR 2002, per Baldock, J. Facts. Banks filed for Chapter 13 bankruptcy. His reorganization plan would prevent his non-dischargeable, federally guaranteed student loans from accruing interest before Banks was discharged by the bankruptcy court. Sallie Mae, which held the student loans, was told of the plan and given the opportunity to attend hearings but never did so and didn't object to the plan before the court confirmed it. 5 years later, Banks was discharged. He then learned that interest had continuously accrued on the loans. The bankruptcy court agreed that Banks's request to bar the accruals was improper under the bankruptcy code but held that Sallie Mae had had an opportunity to object before the court confirmed Banks's reorganization plan and did not do so. So the bankruptcy court held that the post-discharge complaint was barred by res judicata. The district court reversed, holding that the reorganization plan had not given Sallie Mae adequate notice. Back. Question. The bankruptcy code and rules require a debtor to bring a special adversary hearing to prove that exempting from discharge any student loan debts or interest on the loans would impose an undue hardship. Banks did not do this. Can the bankruptcy court's approval of his plan serve as res judicata against Sallie Mae? Holding. Number. A general reorganization plan cannot be used to discharge a non-dischargeable debt when a special hearing is required on what is ordinarily a non-dischargeable debt. Affirmed. Reasoning. A creditor must be given specific notice of an attempt to discharge a student loan or interest and the opportunity to object in a special hearing. Because Banks did not request such a hearing, Sallie Mae never knew about the provision barring the accrual of interest. So Sallie Mae is not bound by the court's confirmation of the reorganization plan, and res judicata does not apply. Many lawyers haven't done this type of case brief since their first semester of law school. Yet the skill is worth carrying into your daily work. Until you acquire such a habit, you'll never really master the case law to the extent you should. Be sure, in writing these case briefs, to record similar categories of information in the same part of the page or note card, case after case. One way or another, you'll end up with a constellation of cases. And they'll be configured around issues. Let's say you have 3 issues. If so, you'll have 3 parts in the body of the brief, typically proceeding from the strongest to the least strong. Forget the lame arguments. Each part will be organized more or less as follows. Elaborate the legal premises embedded in the issue statement, see number 11. Show how the factual points fit into the legal premises, see number 12. Deal with counter-arguments, see number 88. Drive the point home with an additional reason or set of reasons, see number 97. That's the basic way of organizing the discussion of each issue. 5. Outline your brief, but start with nonlinear outlining. Quotable quotes. Few write the way an architect builds, who first sketches out his plan and designs every detail. Rather, most people write only as though they were playing dominoes, where the pieces are arranged half by design, half by chance, and so it is with the sequence and connection of their sentences. Arthur Schopenhauer, On Style, 1851, in Theories of Style in Literature. 251, 269, Lane Cooper ed. 1923, translation modernized. If the pre-writing stage has been thorough, it will usually happen that there's little rewriting to do. Gorham Munson, The Written Word 157, Reverend ed. 1949. Key form and organization of a brief ought to conform to 2 rules. First, it should be so complete within itself that reference to extrinsic sources will not be needed to learn anything that needs to be known about the case, but only to confirm the accuracy of the presentation. Second, the presentation should be such that it may be grasped and understood by the court without the expenditure of unnecessary effort or time. Herman F. Selvin, The Form and Organization of Briefs, in Advocacy in the King's English 405, 406, George Rossman ed. 1960. A working outline, made to serve as a guide for a future composition, can prevent the sort of obvious muddles of ideas and grammar that often occur when we do not think something out before we formally deliver it, as a piece of writing. James William Johnson, Logic and Rhetoric 20, 1962. If the outline is faulty, the thinking is faulty. Consequently, if the draft outline won't wash, your case needs further and clearer analysis, and you will have to labor over it some more. Work over it, slave over it if need be, turn to other matters to clear your head if the deadline allows you that luxury. But keep at it until the outline is sound. Then, and only then, are you ready to write. Frederick B. Wiener, Briefing and Arguing Federal Appeals 201, Reverend ed. 1967. Oh, nay, of the only virtues of linear outlining is that it looks neat, and that very virtue is its downfall. By working hard to make sure the outline is neat, we effectively cut off any additions or insertions, any new idea. After all, we do not want to mess up our neat outline. When we move sequentially in the world of ideas, we proceed to the next concept under the assumption that we are finished with the idea before it. The fallacy of this method is believing that the concepts we leave behind have been thoroughly thought out and need no extension. Branching, on the other hand, which starts from the center and radiates outward, is an expansive approach to organizing material. By its very nature, it allows you to retrace your steps for easy additions and afterthoughts. And often the afterthoughts are the most valuable aspects. Henriette Ann Clouser, Writing on Both Sides of the Brain 48, 1987. A brief must be carefully and thoroughly organized before it is written. There is nothing worse than a rambling document that sounds as if it had been dictated off the cuff and filed virtually without change. That kind of brief is difficult to follow, frequently repetitious, often internally inconsistent, and always unpersuasive. Daniel M. Friedman, Winning on Appeal, in Appellate Practice Manual 129, 131. Priscilla A. Schwab ed. 1992. Except for simple correspondence, I would rarely begin any writing without an outline, however cursory it may be. Think how much easier exam paper grading would be, and how much higher the grades could be, if students would outline their answers before launching into whatever comes to mind on subjects suggested by the question. Thomas M. Reevely, How I Write, 4 Scribes J. Legal Writing 51, 1993. I like to read a brief that reflects a carefully constructed outline. I can feel the effects, even if the outline is camouflaged by the text, one point leads to the next with the minimum number of words. Just as I salute the discipline of outlining for a judge, so I commend it to a writer of briefs. The attorney who outlines well is invoking the sense of order to which the judge gravitates in crafting an opinion. Frank M. Coffin, on Appeal, Courts, Lawyering, and Judging 119, 1994. Explanation. When it comes to outlining, most people think of Roman numerals, capital letters, and the like, and of old Schulmarmish rules about not having only one or two items under a heading, at least three being required. Some people gravitate toward outlining, but many are repelled at the thought. And even if you're good at it, you're going to be less good if you lock yourself into a linear structure early in the process. That is, as an outline writer, you might start out with something like this. I, A, B, 2, A, B, C, 3, I, B. If you did begin this way, you'd be unlikely ever to see it if there really should be a C, a D, and an E under heading I. They might end up being V, V, and 7. In other words, as your architect works, your later thoughts might need to be integrated with your earlier ones, and you don't want to forestall this possibility. An excellent way of improving this process is to use a nonlinear outline. I routinely create whirlybirds in this process. A whirlybird is a whirl of ideas resulting from the Madman architect collaboration. This gives the Madman an opportunity to develop ideas, while the architect decides what's a major wing and what's just a feather on that wing of the whirlybird. Essentially, you start a whirlybird by putting a smallish circle in the middle of the page, perhaps an inch in diameter. Then draw 4 gently arcing lines or wings off that circle, like this. Image. In the middle of the circle, write a shorthand name for your writing project, e.g., Martin Ada Brief. Think of one major point and write it on one of the wings. Then think of 2 or 3 others and put them on other wings. Then list, as feathers, hanging off the wings, everything you can think of that relates to these points. Examine documents to gather more ideas. Read cases. Do whatever it takes to develop copious thoughts. If you need to add more wings straight off the circle, do so. This process may take only 10 minutes. It may take days. You're brainstorming. Whenever you think you're finished, force yourself to think of at least 4 more items, things you haven't yet recorded. When you've done that, force yourself to add 2 more. You need plenty of ideas. Challenge yourself to be creative. Once you've truly exhausted your imagination, take a little rest. Turn to something else for a while, anywhere from a few minutes to a few days. Now, having let the Madman take the lead in getting abundant ideas down, you'll need to let the architect take over. Although the Madman will still be present to fill in gaps, the architect will now be in charge. Study your whirlybird carefully to see which point will be your lead. Then start translating your whirlybird into a more traditional-looking, hierarchical outline. Think about what order best suits the subject matter, especially from the viewpoint of a stranger to your case. You'll probably find that a sensible order will emerge fairly quickly. Your architect will choose from among the items on your whirlybird, maybe rejecting several ideas, maybe collapsing 2 wings into one part of the outline, and maybe breaking 1 wing into 2. The point is that the architect can work almost exclusively on arranging the material. There's no real pressure at this stage to develop material. Although I was skeptical at first about this type of outlining, in fact, I refused to try it for more than 2 years, I now use it for almost every writing project. And I teach it to thousands of lawyers every year, many of whom are just as surprised as I was about how extremely useful it is. Here are the most common reactions. I thought of things I would probably have missed. I saw the interconnections between ideas. I discovered what was really most important, an idea or theme that I might have otherwise buried. I found out that I really know more about the subject than I thought. The project seemed more manageable. It was a relief to see everything on one page without having to worry about order. I'm amazed at how much progress I made in a very short time. The progression of steps is illustrated in the example that follows, an 11th Circuit brief that I contributed to an ABA mock appellate argument in 1996. It's a plaintiff's brief in an ADA case. My fictitious client is Martin, an in-house lawyer who was dismissed after being diagnosed with a depressive psychological condition. The doctor prescribed a limit on his working hours and a limit on his travel. You'll see how the brief shaped up in the stages that follow. The Whirlybird Nonlinear Outline of Issue 1. Image. The Linear Outline of Issue 1. Outline of Appellant's Brief. Issue 1. As the result of his supervisor's harsh criticism, Martin, an in-house attorney and lifelong overachiever, developed an adjustment disorder with anxiety and depression, and is suffering from sleeplessness, short attention span, intemperate behavior, and loss of appetite. His employer summarily fired him after learning his psychologist's opinion that for the indefinite future, he cannot travel, work a 40-hour week, or appear in court. Is there a genuine fact issue under the ADA about whether Martin, 1. has an impairment that substantially limits 1 or more major life activities, or 2. has been treated as if he has such a disability? 102 words. A. Martin has a disability under the ADA, an impairment that substantially limits major life activities. 1. A mental impairment qualifies as a disability. Section 121012, Mental, 29 CFR Section 1630.2, Mental Impairment, Overton Case, Stradley Case. 2. Martin's condition substantially limits major life activities. A. Martin's condition affects several major life activities: sleeping, speaking, learning, eating, traveling, interacting with others, Section 1630.2 I, list not exhaustive. B. Martin's condition substantially limits 1 or more of those life activities. 1. The general meaning of substantially limits. Means of determining, case-by-case basis. Total inability to work not necessary. 2. The factors indicating that Martin is substantially limited in major life activities, 29 CFR Section 1630.2 J. 1. 3. The considerations for determining whether an individual has been substantially limited in his work. B. Martin is regarded as having a disability under the ADA, an impairment that substantially limits major life activities. The brief on Issue 1. Argument and authorities. Introduction. The purpose of the ADA is to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities, a group of Americans that Congress has estimated at 43 million and growing. 1. The ADA prohibits an employer from discriminating against a qualified individual with a disability because of the disability. 2. Martin stated a case under the ADA by alleging that 1. He suffers from a disability, 2. He is a qualified individual, and 3. He was fired from his job because of his disability. 3. Congress intended that relevant case law developed under the Rehabilitation Act of 1973 would generally apply to analogous inquiries under the ADA. 4. The employment provisions of the ADA merely generalize to the economy as a whole the duties, including that of reasonable accommodation, that the regulations under the Rehabilitation Act imposed on federal agencies and federal contractors. 5. As this court has recognized, Congress enacted the Rehabilitation Act because it decided that federal contractors and grantees should bear the costs of providing employment for the handicapped as a quid pro quo for the receipt of federal funds. 6. Congress intended that federal contractors shall take affirmative action to employ and advance in employment qualified handicapped individuals. 7. As a federal contractor receiving federal funds, then, Atlantic Coast had a long-standing legal obligation to advance qualified persons with disabilities, an obligation entirely ignored by Attila when he abruptly fired Martin upon learning of his disability. 8. Also useful in interpreting the ADA are federal regulations and guidelines, including those issued to implement Title I of the ADA. 9. Issue 1. Fact issue on impairment. Martin, a lifelong overachiever and in-house attorney with Atlantic Coast, developed an adjustment disorder diagnosed by his psychologist as involving anxiety, depression, sleeplessness, and other physical symptoms. When Martin divulged his psychologist's opinion that he should not travel, work over 40 hours a week, or appear in court, Atlantic Coast summarily fired him. Under the ADA, is there a genuine fact issue about whether Martin has an impairment that substantially limits one or more major life activities? Issue 2. Atlantic Coast's action. In firing Martin because of his psychologist's diagnosis, has Atlantic Coast treated Martin as if he does in fact have such an impairment? Under the ADA, the term disability means a physical or mental impairment that substantially limits one or more of the major life activities of the plaintiff, b. a record of such impairment, or c. being regarded as having such an impairment. 10. The record contains evidence on which a reasonable jury could conclude that Martin has a disability under either the first or the third prong of 42 U.S.C. Section 121022. Martin produced evidence that would support such a finding, and thus raised a genuine fact issue on the element of disability. A. Martin has a disability under the ADA, an impairment that substantially limits major life activities. 1. Martin's mental impairment qualifies as a disability. Under the first prong of Section 12102, a disability includes a physical or mental impairment that substantially limits one or more of the major life activities. 11. Federal labor regulations specifically include emotional or mental illness in the definition of mental impairment. 12. Depression and other mental conditions can thus qualify as disabilities under the Act. 13. Martin has been diagnosed with adjustment disorder with anxiety and depressed mood, described in Section 309.28 of the Diagnostic and Statistical Manual of Mental Disorders, 4th ed., 1994, commonly known as DSM-IV. 14. A diagnosis is relevant in determining whether a party has a disability. 15. Although an adjustment disorder, by definition, is said to resolve within 6 months of the termination of the stressor, the symptoms may exist for longer than 6 months if the condition is diagnosed as chronic. 16 is drive. Freud has testified Martin would require accommodations for the indefinite future, an opinion that indicates a long-term or chronic disability. 17. Moreover, drive. Freud has also testified that Martin suffers from depression, a condition that is more severe and more permanent than an adjustment disorder. 18. As the Seventh Circuit has explained, depression is a misleadingly mild term for an extraordinarily debilitating illness. 19. Major depressive disorder is present when a patient has suffered from one or more major depressive episodes, which are characterized by at least 2 weeks of depressed mood nearly every day, accompanied by at least 4 additional symptoms of depression. 20. Drive. Freud's affidavit reveals that more than once, Martin has been depressed for at least 2 weeks, nearly every day for most of the day. 21. Further, drive. Freud has testified that Martin's symptoms include 1. Sleeplessness, 2. Loss of appetite, 3. Difficulty concentrating, and 4. Irritability. 22. These 4 symptoms are typical symptoms of depression. 23. Finally, drive. Freud has testified that he initially provides the least severe diagnosis possible for a patient because he believes that labeling a patient with a chronic illness may actually worsen the condition. 24. This phenomenon is especially true for depressed patients, whose depression often worsens upon being labeled as chronically depressed. 25. In light of Dr. Freud's testimony that the condition will probably continue for the indefinite future and Martin's testimony about his symptoms, there is, at the very least, a fact issue about whether Martin has a disability under the ADA. 26. 2. Martin's condition substantially limits major life activities. The determination whether a person is substantially limited in a major life activity is uniquely factual and must be made case by case. 27. Some impairments may be disabling for some people but not for others, depending on the stage of the impairment, the presence of other impairments that combine to make the impairment disabling, or any number of other factors. 28. Because the inquiry is highly fact-specific and because Martin has at least raised a fact issue that his impairment and the associated symptoms are disabling to him, summary judgment was inappropriate. 29. A. Several of Martin's major life activities have been affected. Major life activities specifically include learning and speaking, both of which have been affected by Martin's condition. 30. His short attention span may limit his ability to learn. 31. And drive. Freud has recommended that he not make any more oral arguments, suggesting at least an indirect effect on his ability to speak. 32. Mental and emotional processes such as thinking, concentrating, and interacting with others are also major life activities. 33. Martin's short attention span probably limits his ability to think and concentrate. 34. And because he suffers from irritability, short temper, and proneness to intemperate behavior, Martin may be limited in his ability to interact with others. 35. Further, the list in section 1630.2(I) is not exhaustive. 36. Major life activities include any activity that an average person in the general population can perform with little or no difficulty. 37. Martin has been impaired in 4 such activities: sleep, eating, travel, and work. First, drive. Freud has testified that Martin's mental disability has caused him to suffer from sleeplessness. And sleep, not surprisingly, has been held to be a major life activity. 38. Second, as Martin and Dr. Freud have testified, Martin's mental disability has also affected his eating, another major life activity. 39. Third, drive. Freud has testified that Martin's disability precludes him from traveling, another activity that the average person can perform with little trouble. 40. Finally, Martin's condition may limit his ability to work, and working is specifically listed as a major life activity. 41. B. There is a fact issue about whether Martin's life activities have been substantially limited. A person is substantially limited in major life activities if the person is significantly restricted in the manner and duration of performing these activities, as compared to the average person in the general population. 42. The evidence in this case certainly raises fact issues about whether Martin can learn, think, concentrate, or interact with others in the manner and for the duration that the average person can. And as the evidence establishes, Martin is significantly restricted in the manner and duration of his eating, sleeping, and traveling. 43. In determining whether there is a substantial limitation, the fact finder must consider whether the impairment is severe and long-lasting. 44. Martin is afflicted with a severe impairment, entailing both anxiety and depression. This impairment has affected not only his work but also his sleeping, eating, and other ordinary activities of life. 45. An example in the EEOC compliance manual reveals that if an employee sustains a concussion resulting in a short-term memory deficit, inability to concentrate, and difficulty in learning and assimilating, then the employee's condition is substantially limiting. 46. As Martin and drive. Freud have testified, Martin suffers from similar thinking and learning problems. 47. Moreover, a fact issue exists about whether Martin's impairment will be long-lasting. As Dr. Freud has testified, accommodations will be necessary indefinitely, suggesting that Martin's impairment is chronic. 48. Although drive. Freud diagnosed the 6. Write a draft straight through, without stopping to edit. Let it sit a while before editing. Quotable quotes. P. Polishing at an early stage usually is a waste of time. George J. Miller, On Legal Style, 43 KY. L.J. 235, 239, 1955. When you have found your idea, write it down as nearly as possible as you would express it in speech, swiftly, unself-consciously, without stopping to think about the form of it at all. Revise it afterwards, but only afterwards. To stop to think about form in mid-career, while the idea is in motion, is like throwing out your clutch halfway up a hill and having to start in low again. You never get back your old momentum. David Lambeth et al. The Golden Book on Writing 4, 1964. Poor writers are inclined to scorn revision and to assume incorrectly that good writers do not need to revise. Poor writers believe that articles, stories, and poems should pour forth in their complete and final forms. Until writers are disabused of this error, they are at best half-hearted about revising and at worst unwilling to change a word they have written. H.J. Tichy, Effective Writing for Engineers, Managers, and Scientists 10, 1966. What you must do, as a writer, is think about what you want to say and then let it flow in your usual way. Afterwards you will need to go over it and do some fixing, but, just as with the football play, that will not be hard if there are the right makings to begin with. David W. Ewing, Writing for Results in Business, Government, the Sciences, and the Professions 212 2D ed. 1979. Convince yourself that you are working in clay not marble, on paper not eternal bronze. Let that first sentence be as stupid as it wishes. No one will rush out and print it as it stands. Just put it down, then another. Your whole first paragraph or first page may have to be guillotined in any case after your piece is finished. It is a kind of forebirth. Jacques Barzin, A Writer's Discipline, in On Writing, Editing, and Publishing 8 2D ed. 1986. Explanation. Mentally speaking, the writing function and the editing function are largely separate. That's why, in writing courses, the students who are the best editors are almost never the best writers, and vice versa. And ultimately, the most accomplished writers keep the judge separate from the carpenter, who needs to work unimpeded. The judge is a kibitzer, a second-guesser. For the carpenter, the judge is a nuisance. For those with a well-developed judge, the great secret of writing is keeping the judge out of the way while the carpenter works. Writers with an overbearing judge will find writing especially painful. They're the ones who squeeze out the draft word by word. They won't move on to a new sentence until the preceding one is perfect. If you cheerfully acknowledge, though, that the judge will have time to work, that whatever you write at first will be subject to thorough revision and that the most important thing for now is to get a draft on paper, then you'll probably be able to let the carpenter work without distraction. And as just about everyone knows, the more time you can put between the draft and the editing, the better your judge will work. In any event, the very switch in personality from Carpenter to Judge will function as a way of sleeping on it, even if you allow only 15 minutes to pass between writing and editing. As Judge, you'll look at your words through different eyes, those of a different personality. As Alexander Pope (1688–1744) once said, compose with fury and correct with phlegm. Learn to write rapidly, without stopping to revise. For that matter, don't even take time to pick the right words. Just get your thoughts down by expanding on the outline that your architect has created. That's the way professional nonfiction writers typically work, at least the most productive ones. When you learn to write this way, the prose itself takes on a different quality. The judicial reader will probably sense greater swiftness within your paragraphs. They won't be laborious reading. 7. Proof carefully. Have several others proof carefully. Learn and use standard editing marks. Quotable quotes. No one can expect to write a finished essay in a single draft, and no one except the green beginner or the newspaperman who is short of time ever tries. Although students have been told the virtues of second and third drafts from the time they learn to write, they are still reluctant to take the trouble. The results are scandalous. Sentences don't parse, verbs are written in the wrong person and tense, the style is jerky, the order disconcerting, very frequently even the sense is gone. The only way to iron out the manuscript is to read it aloud if possible, correct it, revise it, and rewrite it. Sherman Kent, Writing History 69, 1941. I do not believe that the brief can be proofread too often or too carefully. Raymond S. Wilkins, The Argument of an Appeal, in Advocacy and the Kings. English 277, 281, George Rossman ed., 1960. Too often briefs that lawyers have dictated in part and handwritten in part and sent in that condition to the printer are filed without having been proofread and corrected. We attorneys have no right to criticize physicians who leave sponges in the bellies of patients if lawyers are equally cavalier of the rights of their clients. Gene Appleman, The Written Argument on Appeal. 41 Notre Dame Law. 40, 41, 1965. Check every citation, quotation, and record reference. Check every citation, quotation, and record reference. Check every citation, quotation, and record reference. Frederick B. Wiener, Briefing and Arguing Federal Appeals 202, Reverend ed. 1967. Suppose that after making many small but painstaking corrections and improvements, you receive the manuscript back with a huge black comment scribbled in the margin, nitpicking. What to do? Respond neatly below in the margin and circle the whole thing so it won't be set in type but will remain for the author to see when reading proof, but who wants nits? Elsie Myers Stainton, The Fine Art of Copy Editing 25, 1991. Explanation. Like many other essential things, proofing can be deathly dull, especially if you've already proofed an earlier version of the brief. That's one reason why most writers can benefit from a fresh pair of eyes. If you've seen the page several times, you're likely to assume that things are as you expect them to be, not as they actually are. So enlist the help of support staffers, paralegals, or other lawyers in proofing. Meanwhile, you'll be building an organizational culture in which everyone appreciates getting things right. That will improve not only your document preparation, but also the many other tasks that you're involved in carrying out. You'll save time in the process if people have a shared knowledge of editing marks. The legal secretary needs to know, for example, not only what an M- is but that the handwritten mark image means that an M- should be inserted. See number 57, and there ought to be some similarity in how readers mark text to be omitted, text to be inserted, and the like. Because lawyers are professional writers, they and their staffs ought to feel at ease with editing marks. A well-edited page ought to have a familiar look. Editing marks. Image. A well-edited page from a brief. Image. Part B. Conveying the big picture. 8. Frame the deep issues at the outset, so that you meet the 90-second test. Quotable quotes. The best argument on a question of law is to state the question clearly. Rufus Choate, 1799–1859, is quoted in Harley N. Crosby, Mistakes Commonly Made in the Presentation of Appeals, in 3 Sidney C. Schweitzer. Trial Guide 1546–1945. Your business is to give the reader something of value he does not already possess. Do not bore him by putting in material he knows already, nor confuse him by including material that has no relation to your real point. Plunge in. An abrupt beginning is better than a dull one. James Weber Lynn, The Essentials of English Composition Section 11, at 1916. J. Ust. After being admitted to the bar, Ike was shocked when advised by S.S. Gregory, an ex-president of the American Bar Association, a man more than ordinarily aware of legal realities, that the way to win a case is to make the judge want to decide in your favor and then only, to cite precedents which will justify such a determination. You will almost always find plenty of cases to cite in your favor. All successful lawyers are more or less consciously aware of this technique. But they seldom avow it, even to themselves. Jerome Frank, Law in the Modern Mind 111N.2, 1930, Reaper. 1963. In law the right answer usually depends on putting the right question. Estate of Rogers vs. Kummer, 320 U.S. 410, 413, 1943, Frankfurter, J. The wise man knows what the questions are. The alternatives to asking answerable questions, and then making honest attempts to find answers to them, are clear, and disgraceful. We can ask no questions at all, either out of stupor or as a display of arrogance. We can ask questions that are misleading, or vague, or meaningless, to be answered, respectively, by mountebanks, the confused, and the very naive. Or, we may ask questions and then refuse to acknowledge them, as a gesture of fear, smugness, or irresponsibility. Wendell Johnson, Verbal Man, The Enchantment. Of words 36, 41, 1956, Reaper. 1965. A lawyer who has never held a judicial office does not, I think, fully appreciate the importance of getting the principal facts and the main contention between the parties firmly fixed at the outset in the mind of the court. When he has done this, his labor is half over. Alfred C. Cox, as brief making a lost art, in Advocacy and the King's English. 338, 341, George Rossman ed. 1960. The difficulty with the average advocate is that he succeeds primarily in confusing the court rather than clarifying the issues. Anonymous Judge is quoted in Frederick B. Wiener, Briefing and Arguing Federal. Appeals 29, Reverend ed. 1967. The question presented in any case can be clearly and appealingly stated, or, contrariwise, unclearly and unappealingly. Frederick B. Wiener, Briefing and Arguing Federal Appeals 77, Reverend ed. 1967. It may be argued that an essay involves so many complicated thoughts that no one sentence can be expected to summarize them all. But in most cases, and certainly in most brief essays, a failure to isolate the most important idea is usually an indication of sloppy thinking, not profundity. Stuart Lacasse and Terry Belanger, The Art of Persuasion. How to Write Effectively About Almost Anything 13, 1972. It is unwise to allow the court to read a factual statement without first having presented the issues involved. The court should not be forced to guess, even for a moment, what questions it is asked to decide. Edward D. Ree, Brief Writing. And Oral Argument 117, 4th ed. 1974. Issues are the most important information attorneys give an appellate court. The courts decide issues, and determining what to decide is the sine qua non of any decision, an important truism. Rulings on the various issues in a case total up to a decision for the plaintiff or defendant. Thomas B. Marvell, Appellate Courts and Lawyers 119, 1978. The issues should be stated so simply and so clearly that the judges will grasp them at once. Nowhere in the brief is clarity more important. Because the judges will normally examine both statements of the issues first, reading one after the other and comparing them, it is here that the brief writer makes an invaluable first impression. Gervin Peck, Writing Persuasive Briefs 10304, 1984. Efficiency does not mean the paper with the shortest length, rather, it means the paper that takes readers the shortest time to understand. Michael Alley, The Craft of Scientific Writing 15, 1987. Unfortunately, the judge does not possess the luxury of time for leisurely, detached meditation. You'd better sell the sizzle as soon as possible, the steak can wait. Ruggiero J. Aldizert, Winning on Appeal, Better Briefs and Oral Argument 142, 1992. Start in the very first sentence with the problem in this case. Put it right up front. Start early, don't bury it under a lot of verbiage and preliminaries. Nathan L. Hecht is quoted in Brian A. Garner, Judges on Effective Writing, The Importance of Plain Language, 73 Mich. B.J. 326, 326 1994. I like to see the most important issues framed up front. Of course, I expect to see what the writer considers her adversary's most vulnerable point. What I rejoice to see is a writer candidly recognizing what appears to the reading judge as her own most vulnerable issue and dealing with it. Frank M. Coffin, On Appeal, Courts, Lawyering, and Judging 120, 1994. Readers are impatient to get the goods, and they resent having to work any harder than necessary to get them. John R. Trimble, Editing Your Own Prose forthcoming. Explanation. Every brief should make its primary point within 90 seconds. But probably only 1% of American briefs actually succeed on this score. The ones that do are spectacular to read. Within 90 seconds, the judge understands the basic question, the answer, and the reasons for that answer. These briefs are quick reads. How does the brief writer accomplish this? By cultivating a knack for framing issues well. To frame a good persuasive issue, you must put it up front. Break it into separate sentences, following a premise-question form. Weave in enough facts so that the reader can truly understand the problem, and write it in such a way that there is only one possible answer. To do these things well, most lawyers must forget everything they ever learned in law school about framing legal issues. Forget the idea that you should begin with whether. Forget the notion that you should load all your points into one sentence, a format that ensures an unchronological presentation. Forget making the issue as abstract as possible. What does a good persuasive issue look like? Take the following example. As Hannacutt Corporation planned and constructed its headquarters, the general contractor, Lawrence Construction Company, repeatedly recommended a roof membrane and noted that the manufacturer also recommended it. Even so, the roof manufacturer warranted the roof without the membrane. Now that the manufacturer has gone bankrupt and the roof is failing, is Lawrence Construction jointly responsible with the insurer for the cost of reconstructing the roof? Some briefs would take at least 10 pages to deliver that information. And you wouldn't find this concise statement on page 10. Instead, you would find the tidbits within it strewn amid other facts throughout the first 10 pages. To glean the issue, the judge would have to read slowly with intense concentration. That's quite a demand to impose on busy judges. And yet brief writers seem to make this imposition routinely. A big part of the problem seems to stem from fear that if the judge doesn't see the issue in the same way as the advocate is sunk. How do I know what the judge will latch onto? The diffident advocate asks. I won't state the issue in a single way. I'll talk about the case and the parties in a way that gives the judge several handles on the case. But I'm not going to marry myself to a single issue or set of issues. The result of this understandable fear, unfortunately, is that the advocate has no clearly framed issues, no theory of the case. And the judge becomes frustrated. Only one thing matters to the judge: what question he or she is supposed to answer. If I can figure that out, thinks the judge, I'll be ready to decide the case. But until I find out what that is, I'm just groping for it. Framing the deep issue at the outset is a way of capturing the judicial imagination. Whoever does that in a given case is most likely to win. I'm not much inclined to formulas, but if there's a good formula for beginning a court paper, I think it's this: in deciding this motion, etc., the court need address only the following 2, 3, or whatever number issues. What comes after the colon will be the most challenging thing you'll have to write, the deep issue. What, precisely, is a deep issue? I've now used the term 3 times without defining it. Essentially, a deep issue is the ultimate, concrete question that a court needs to answer to decide a point your way. Deep refers to the deep structure of the case, not to deep thinking. The deep issue is the final question you pose when you can no longer usefully ask the follow-up question, and what does that turn on? The best form it can take is that of the syllogism, see number 11. The first example below typifies the lead-in, slow, unduly complex style of so many modern briefs. Try reading it for just 90 seconds to see what you can glean. Certainly you'll get something from it, a subject matter, but unless you're a rare genius you probably won't understand the issue. Then turn to page 68 to see how the brief might have begun. There, the issue is fully comprehensible in less than a minute, probably much less. This example shows just what it means to spill the beans on page 1. The example beginning at page 69 shows the deep issue at work in a summary judgment reply brief. This example had an interesting result. Both sides had moved for summary judgment, but only Fireman's reply brief had showcased a deep issue up front. When the lawyers appeared for oral argument, the federal district judge announced that he felt prepared to rule already. Having read the briefs, he would rule for Fireman's unless the FDIC's lawyers could show him why he shouldn't. They tried but failed. The judge then ruled for Fireman's, without any argument from Fireman's lawyers. The judge essentially adopted the deep issue on page 69 as his own. When you're framing your issues, remember the great Herbert Wechsler of Columbia University. As his former student Jim Damas recalls, Wechsler said this about his U.S. Supreme Court briefs: half my time in writing a brief is spent framing the issue. A typically bad example. In the Supreme Court of Indiana. Appeal from the Court of Appeals. 3rd Appellate District. Marion County, Indiana. PLEBINOL Corporation. Plaintiff Appellee and Cross Appellant. Versus. The Tull Group Inc. And. Tull Aerospace. Defendants Appellants. Brief of Defendants Appellants. The Tull Group Inc. and. Tull Aerospace. Statement of the case. This lawsuit concerns an action for breach of warranty and/or fraud which was commenced in the Court of Common Pleas of Marion County, Indiana, in August of 1985. The plaintiff sought to recover certain specific damages from the defendants arising from an admitted breach of warranty. The plaintiff asked the jury to return a verdict in its favor in the amount of $1,076,347.64. Decision dated December 9, 1981 at p. 19. This figure, $1,076,347.64, consisted of the following specifically enumerated items of damages. 1. $257,000, the amount paid by plaintiff to a third party in settlement of its claim related to the defective vinyl film. 2. $3,474.98, incidental expense incurred in the rental of a color meter. 3. $9,015, incidental expense incurred by hiring accounting firm of Ernst & Winnie. 4. $5,794, incidental additional salary expenses. 5. $2,596.43, incidental additional hourly costs. 6. $306,998, adhesion losses claimed to have been caused by breach of warranty. 7. $185,096.82, interest expense incurred by plaintiff. 8. $178,268, lost profits claimed by plaintiff. 9. $119,506, loss incurred by plaintiff on roll goods. Decision dated December 9, 1981 at pp. 20-28. The jury ultimately returned a general verdict, untested by interrogatories, in the amount of $854,500. The defendants were permitted a credit of $15,500 and final judgment was entered in favor of the plaintiff in the amount of $839,000. On appeal, the Court of Appeals for the 3rd Judicial District unanimously determined that items of damages totaling $262,532.84 were erroneously submitted to the jury by the trial court. Because there was no mathematical means to ascertain the extent to which the items totaling $262,532.84 were included in the jury's verdict, the Court of Appeals ordered a new trial. In its decision dated December 9, 1981, the Court of Appeals noted, "In light of the general verdict, we cannot speculate as to what elements of damages made up this differential. Therefore, we must reverse the judgment and remand the case for a new trial." Emphasis added. Decision dated December 9, 1981 at p. 34. Then, in an abrupt turnabout, the same Court of Appeals, ruling on a motion for reconsideration filed by the plaintiff appellee, over the dissent of Judge Bell, affirmed the judgment of the lower court in the amount of $813,814.80. After first determining, in its decision of December 9, 1981, that it was impossible to ascertain the extent to which the erroneously submitted items of damages were included in the jury's verdict, the court subsequently determined, in its decision and journal entry of December 23, 1981, that only $40,685.20 of the erroneously submitted items of damages, $262,532.84, not from the verdict, $854,500, but from the total damages sought by the plaintiff, $1,076,347.64. The court thereupon affirmed judgment in favor of the plaintiff in the amount of $818,840 after ordering a remittiture of $40,685.20. Finally, in its third decision and journal entry, the Court of Appeals, realizing that it had failed to credit the defendants the sum of $15,500, entered final judgment on February 2, 1982 in the amount of $798,314.80. Argument. Proposition of law no. 1. A new trial, or a remittiture of the full amount of possible excess damages, is required where the extent of prejudicial error in a verdict cannot be determined. Short of resort to speculation, which the Court of Appeals had specifically rejected in its decision of December 9, 1981 when it determined that a new trial should be granted, it is impossible to determine the precise extent to which the erroneously submitted items of damage totaling $262,532.84 were reflected in the jury's verdict. Having once determined that the trial court erred to the prejudice of the defendants by submitting to the jury items of damages totaling $262,532.84, the Court of Appeals' choices were either 1. To reverse the judgment of the lower court and order a new trial, or 2. Grant a $262,532.84 remittiture from the verdict which, of course, the plaintiff had the option to refuse. Unfortunately, the Court of Appeals did not recognize that its options were so limited. A remittiture is designed to correct prejudicial error and thereby eliminate the time and the expense involved in a new trial. However, if the amount of the error is determined to be as much as 30%, $262,532.84, $839,000, of the verdict, as in the instant case, how is the error corrected? If the court awards only a 4%, $40,685.20, $839,000 reduction of the verdict. When a remittiture fails of its essential purpose, it cannot be deemed to be effectual. To the contrary, a new injustice, an appellate injustice, has been done. Where the jury verdict was infected by prejudicial error to an unknown degree, it was held that a new trial must be granted in Powell v. Montgomery, 27 Ind. App. 2D 112 Court. App. Allen County, 1971. Powell involved a personal injury action in which the plaintiff recovered a general verdict against the defendant in the amount of $6,500. The defendant appealed on the ground, among others, that the court erroneously instructed the jury on future medical expenses, future pain and suffering, and impairment of earning capacity. The Court of Appeals determined that there was no evidence to warrant such an instruction and agreed with the appellant that this constituted prejudicial error. The plaintiff appellee, while denying the existence of error, urged the Court of Appeals to cure the error by granting a remittiture. The Court of Appeals rejected this offer and held that only a new trial could cure the error created by the erroneous submission of items of damages viz. Future medical expenses, future pain and suffering, future loss of earnings and loss of earning capacity to the jury, where the jury had returned a general verdict not tested by interrogatories. The verdict in this case was general, and the error is in the charge and not the reception of evidence. We do not know, nor do we have any means of ascertaining, what sum, if any, the jury allowed as to future damages. No doubt exists that this court could order a remittiture if, in our view, the judgment was excessive. We are not prepared to so hold. Without the error, we would have affirmed. Both parties were entitled to a jury verdict based upon proper instruction. The general rule which we believe applicable here, is that where the amount of the remittiture is not clearly ascertainable and such amount can only be reached by speculation and by substituting the judgment of the court for that of the jury, entry of remittiture is not proper. 5 Am. Ewer. 2D 366, Appeal in Error, Section 939, et seq. 4 Ind. Ewer. 2D 358, Appellate Review, Section 1036. In Tuttle vs. Furry, 22 cc. NS 388, the sixth paragraph of the syllabus provides. Where the court has erroneously permitted the jury to include certain items of damages in their verdict, the error is not cured by a remittiture where there is nothing to show that the amount remitted was the amount which the jury may have awarded because of those items. This court finding error having intervened to the prejudice of the appellee below, the judgment must be reversed and the cause remanded to the trial court. Powell, Supra, p. 124. The Powell standard, which is the correct rule of law, appears to be widely applied. Courts of other jurisdictions have held, where it is impossible to ascertain the extent of the impact of prejudicial error upon a verdict, that only a new trial will cure the error. Holding that remittiture was an inappropriate remedy where improper testimony as to the value of land was admitted by the trial court, the Supreme Court of Indiana stated. We are, therefore, at a loss to understand why the Court of Appeals determined that $28,662 of the jury award was motivated by properly admitted evidence and only $16,338 thereof by the improperly admitted evidence, when from all that appears from the record, the entire award may have been based upon the evidence improperly admitted. State vs. Church of Nazarene of Logansport, 377 NE 2D 607 S. Court, Ind. 1978. The Supreme Court of Missouri arrived at the same conclusion where the plaintiff had erroneously introduced the element of punitive damages in a medical malpractice case. In the instant case, there is no method by which this court can know how much of the verdict represented the jury's response to plaintiff's appeal for a punitive sum. It may be argued that this assumes the jury included a punitive sum in its verdict. The answer to that is that we do assume that the jury did what it was invited to do by plaintiff's argument and included some sum of money in its verdict to deter others from like conduct, but as noted supra, we do not know how much of the verdict represented punitive damages and, therefore, the remitter solution is not available to correct the error. Smith vs. Corder, 531 SW2D 743, 748 S. Court, Mo. 1976. A remitter was also held to be an inappropriate remedy in Vic vs. Tisdale, 324 So. 2D 279 Allah. App. 1975. There the Court of Appeals determined that the plaintiffs, who had recovered a verdict of $5,090, were not entitled to recover any damages by way of a statutory penalty. Because only $2,500 had been sought by the plaintiffs as compensatory damages, it was determined that, at least, $2,590 of the verdict was allocable to a statutory penalty. The Court of Appeals was then confronted with the issue of whether remitter would correct the error committed at the trial level. The plaintiff requested that the court affirm the judgment of $2,500, upon their agreeing to a remitter of $2,590. The appellate court, however, rejected this offer because it was unclear as to exactly how much of the verdict was attributable to the penalty vis-a-vis compensatory damages. Able counsel requests this court to order an affirmance conditioned upon a remitter of damages over $2,500, and as much as ample evidence exists to support the jury's finding that the fair market value of the timber cut was $2,500 as prayed for in Appley's complaint. While we are not unsympathetic to counsel's request, which is based upon considerations of judicial economy and expense to the parties involved, we cannot issue such an order. As our original opinion points out, the evidence was conflicting as to the number of trees actually cut and their fair market value. It therefore cannot be ascertained how to apportion the $5,000 general verdict between compensatory damages and statutory penalty. Accordingly, the remitter requested by counsel is too speculative to be granted. Vic, Supra, pp. 283-284. In Grand Trunk Western R. Company vs. H.W. Nelson, Inc., 118 F2D 252, 6th CIR 1941, the plaintiff claimed contract damages of $1,294,307.79. The jury awarded $871,000. However, an interest claim of $431,870.39 was improperly submitted at the plaintiff appellee's request. In rejecting the remedy of remitter and ordering a new trial, the court stated, 3. Appellee urges on us that, excluding the question of interest, all other matters in dispute were settled in its favor by our original opinion, and it now offers to remit such portion of the judgment in its favor as is represented by interest. In writing the original opinion, we seriously considered whether the error as to interest, although prejudicial, might be cured by permitting appellee to remit a portion of the damages and thereupon affirm the judgment. We recognize the desirability of bringing litigation to an end and the lessening of expenses of retrial, which a remitter may accomplish, but before such desirable procedure may be resorted to, there must be a mathematical basis in the record by which the reduction may be computed or at least closely approximated, otherwise it would be no more than a guess. New York, C. and Street, LRP, Company vs. Niebel, 6th CIR, 214 F. 952. There is no such basis in this record and therefore appellee's offer must be denied. ID. P. 254. For the same rule announced in other states, see Williams vs. Safeway Stores, Inc., 515 P2D 223 S. Court, Okla, 1973 Montgomery vs. Tufford, 437 P.2D 36 S. Court, Colo, 1968 Rubner vs. Kennedy, 417 SW2D 860 Tex. App, 1967 and Chesbro vs. Woodworth, 195 F875 6th CIR. 1912. In this case, in its second decision, dated December 23, 1981, in which it ordered a remitter of $40,685.20, the Marion County Court of Appeals, over the dissent of Judge Bell, cited Chester Park Company vs. Schulte, 120 Ind. 273 1929 and Laracy vs. Norwalk Truck Lines, Inc., 155 Ind. 207 1951, as providing a legal basis for the granting of a $40,685.20 remitter. These cases do not provide a legal basis for the action of the court in ordering a remitter of only 1/6 of the prejudicial error. In each case, Chester Park, Supra, and Laracy, Supra, the Supreme Court considered the role of remitter where it was argued that the verdict was excessive. In each case it was determined that there existed no prejudicial error affecting the verdict unlike the circumstances of the instant case and that the verdict was not tainted by passion or prejudice. Under these limited circumstances, the Supreme Court determined that remitter might properly be used by a court to reduce the verdict to amounts supported by the evidence. 3. If a verdict in an action for unliquidated damages is, in the opinion of the trial court, excessive but not appearing to be influenced by passion or prejudice, the court may with the assent of plaintiff reduce the verdict by remitter to any amount warranted by the evidence. 5. The Court of Appeals has the same unlimited power and control of verdicts and judgments as the trial court and may weigh the evidence and exercise an independent judgment upon questions of excessive damages, and when no passion or prejudice is apparent may modify and affirm the judgment by ordering a remitter with the consent of the prevailing party. Chester Park Company, Supra, paragraphs 3 and 5 of syllabus. In explaining Chester Park, this court in Laracy stated as follows. However, it has long been the rule in Indiana, and it is the majority rule in the nation, that if a verdict in an action for unliquidated damages is excessive, but not appearing to have been influenced by passions or prejudice, the court may, with the assent of plaintiff, reduce the verdict by remitted or to any amount warranted by the evidence. Lara C. Supra, p. 219. Plaintiff appellee has suggested that Chester Park Company, Supra and Lara C. Supra, are authority for the action taken by the Court of Appeals in this case and for the proposition that it is entitled to a maximum recovery. Because neither of these cases, viz. Chester Park Company and Lara C. concern the appropriate use of a remitted where a prejudicial error has intervened, neither is dispositive of the issue now before this court. Furthermore, these cases do not even support the proposition that the plaintiff is entitled to the maximum recovery allowed by the evidence. In each case, the Supreme Court, acknowledging that the court granting a remitted or substitutes its judgment for that of the jury, stated that the court may, with the assent of plaintiff, reduce the verdict by remitted or to any amount warranted by the evidence. Lara C. Supra, p. 219. Contrary to what has been urged by plaintiff appellee, this court did not, either in Chester Park Company or Lara C., provide complete guidance to the lower courts of this state with respect to the use of a remitted. Most specifically, it did not provide guidance for those cases where prejudicial error has intervened and its full impact upon a verdict is uncertain. The federal courts, like many of the state courts that have addressed themselves to these issues, approach the use of remitted differently in situations where a verdict is deemed to be merely excessive and in the situation where prejudicial error has intervened. Where there has been no error but where it is argued that the verdict is excessive, some circuits apply what is known as the maximum recovery rule. On the other hand, it has been held that the remitted amount should reduce the verdict only to the maximum that would be upheld by the trial court as not excessive, apparently on the theory that the jury intended to award the plaintiff the maximum legal damages and the court should not invade the province of the jury except to reduce the amount of the verdict to that point. 6A Moore's Federal Practice, par. 59.0503 pp. 595659582 ed. 1982. However, this maximum recovery rule has no application where prejudicial error has intervened. In fact, the federal courts apply what may be termed the maximum effect rule where error has been found to intervene. Remitted is not only used by the trial courts, but also by the appellate courts in two general areas, one particularly applicable to the function of the appellate court, the other quite similar to its use by the district courts. In the first area, where reversible error is found in proceedings below, such as erroneous admission of evidence or erroneous instructions, and the effect of the error can be reasonably approximated to a definite portion of the amount of the verdict, the appellate court may condition its affirmance on the plaintiff remitting that amount of the verdict which is apparently traceable to the error below. Even when the effect of the error cannot be allocated to a distinct portion of the verdict, remitted may still be used if the maximum effect of the error can be established. In this way, the defendant cannot complain as the maximum effect of the error is avoided, and the plaintiff has his choice of electing to remit or to suffer a new trial. 6A Moore's Federal Practice, par. 59.0503 pp. 596459662 ed. 1982, emphasis added. Hence, remitted may still be an appropriate remedy where prejudicial error has intervened if it is used in such a way that the maximum effect of the error can be purged from the verdict. Applying the maximum effect rule to the instant case, the Court of Appeals, if it deemed remitted appropriate, could have offered the plaintiff appellee the opportunity to accept a remitted in the amount of $262,532.84. Instead, the Court of Appeals adopted the plaintiff appellee's argument that it was entitled to a maximum recovery, and offered the plaintiff the opportunity to accept a remitted of $40,685.20. The net result, of course, is that the maximum effect of the prejudicial error has not been purged from the verdict, and the plaintiff, after having interjected error into the case, is now permitted to reap the financial fruits of that error. Such a result is intolerable. Such a result frustrates the purpose of a remitted, which is to guarantee both sides a fair trial by eliminating error and at the same time avoiding the expense and time necessarily involved in retrying a case. State courts from sister jurisdictions which have addressed our issue have uniformly required that the maximum effect of the prejudicial error be cured before a verdict infected by error is permitted to stand. As the Texas Supreme Court noted in Employers, Insurance Assen vs. Lightfoot, 139 Tex. 305, 162 SW 2D 929, 1942. It is the law that where the portion of a jury's verdict tainted with misconduct, or improperly arrived at, is capable of definite and accurate ascertainment, and where the jury acted free from prejudice and passion, a remitted of the portion so tainted or improperly arrived at will cure the error, and the part of the verdict free from the taint of misconduct and properly arrived at will be permitted to stand. ID, 162 SW 2D at 931. And in Reserve Life Insurance Company vs. Gay, 213 GA. 904, 102 SE 2D 492, 1958, the Georgia Supreme Court, in reversing a court of appeals that had improperly used the remedy of remitted and therefore failed to correct the maximum effect of the prejudicial error, stated as follows. A verdict which is erroneous may be corrected by the writing off of the illegal part if the illegal part can be determined and is separable from the rest. ID, 102 SE 2D at 493. Under the facts of this case, it is not the excessive nature of the verdict which mandates reversal, but the presentation of improper items of damages for the jury's consideration. This error requires reversal and a new trial, or in the alternative, a remitted of $262,532.84, the amount of the prejudicial error, from the verdict. To award plaintiff final judgment for $798,314.80, where as much as $221,847.64 of the amount may well be damages for which it has already been held plaintiff is not legally entitled, is to commit an egregious injustice to defendants and to reward plaintiff hundreds of thousands of dollars in spite of the error plaintiff created. Had the Court of Appeals ordered a remitter of the full $262,532.84 from the jury verdict, the plaintiff might have complained, but the plaintiff had a right to refuse to accept the remitter. Likewise, if this court were to order a remitter of $262,532.84, the plaintiff would still have the option of accepting such a remitter or refusing the remitter and proceeding with a new trial. The defendants, however, have no option of assent. They were simply assigned a remitter of only $40,685.20 when, in fact, a much greater amount of improper damages may well have been included in the verdict. Thus, defendants have been twice wronged, once by plaintiff's prejudicial proofs at trial and again when the Court of Appeals recognized the first wrong, but failed to fashion an adequate remedy. Proposition of law no. 2. It is error to reduce a verdict by remitter to the maximum amount which a jury could have awarded where the jury, as a trier of fact, has not awarded the maximum amount sought by the plaintiff. For reasons which remain unknown, the Court of Appeals chose to subtract the sum of the erroneously submitted items of damages not from the amount of the verdict $854,500, but rather from the amount of damages claimed $1,076,347.64. The procedure adopted by the Court of Appeals in the use of remitter was erroneous not only because it fails to correct the total error $262,532.84, but also because it assumes, contrary to what the jury's verdict indicated, that the plaintiff was entitled to a maximum recovery and that all damage issues were resolved in favor of the plaintiff when clearly they were not. Where the jury fixes an award at a maximum level, here $854,500, it is error for a court, in granting a remitter, to assume that the plaintiff was entitled to more than the maximum sum determined by the jury. The Court of Appeals' failure to recognize this principle has caused the instant dispute. For if the Court of Appeals had subtracted the $262,532.84 from the jury verdict of $854,500 rather than from the $1,076,347.64 claimed damages, the use of the remitter would have been appropriate. Under the facts of this case, there is absolutely no way for the Court of Appeals to divine the jury's deliberations with respect to damages. However, by ordering a remitter of $40,685.30, the Court of Appeals has in essence usurped the jury's function and sub silentio ruled as a matter of law that the plaintiff was entitled to a full and complete recovery of all disputed items of damages properly before the jury. A case which carefully considers this problem is Forgettable vs. Duffy Mott Company, Inc., 263 NY. 95, 188 NE. 266-1933. In that case, the Court of Appeals of New York had occasion to consider whether the appellate division had properly used the remedy of remitter in a suit for breach of an employment contract. The verdict of $118,762.53, determined by the trial court to be excessive, was reduced to $113,484.75. The defendant appealed the amount of that judgment to the appellate division. The intermediate court determined that a wage loss item, $106,900, should have been discounted to present day values. The intermediate division, however, offered to affirm the judgment in favor of the plaintiff if the plaintiff agreed to accept a remitter which represented the difference between the future payments reduced to present day value less only the sum of $5,800. New York's highest court, the Court of Appeals, held that the granting of a remitter in this situation was wrong. The appellate division has held that the future payments should be discounted to their value at the time of the breach. From that value they deducted only the amount concededly earned by the plaintiff, and, on condition that the plaintiff stipulate to accept the modification, they affirmed the judgment as modified. In that they erred, the damages thus recovered were, so the appellate division said, the maximum amount of the damages recoverable under the evidence. 238 App. Div. 468, 471, 264 NYS. 745, 748. Thus, they eliminated the allowance of $35,000 which the jury might have found, and, as appears did find, upon the evidence represented the probable earnings of the plaintiff during the part of the term which had not expired at the time of trial. An appellate court may correct errors due to erroneous rulings, but it cannot usurp the province of a jury nor upon the consent of the plaintiff reduce a judgment to the maximum amount recoverable by the plaintiff under the evidence unless the jury verdict has established such amount. Forgettable, Supra, p. 270, emphasis added. In the instant case, the Court of Appeals failed to recognize that the amount of the recovery set by the jury, $854,500, not $1,076,347.64, represents the maximum the plaintiff was entitled to recover under the evidence produced at trial. By deducting the sum of the erroneously submitted items of damages from the total claim of the plaintiff $1,076,347.64, the Court of Appeals has failed to properly credit the defendants for the sums which were resolved in their favor by the jury. This prejudiced defendants to the extent of $221,847.46, and constitutes a blatant usurpation of the jury's function by the Court of Appeals and prejudices the defendants. Instead of remedying the error by granting a new trial, the Court of Appeals aggravated an injustice by first finding an error prejudicial to the defendants and then choosing a remedy, which failed to correct it. Conclusion. In its decision in Chester Park, Supra, this court was concerned with offering guidance to lower courts with respect to the permissive use of remitter. It is likewise very much to be desired that some very definite rules be laid down by this court for the guidance of the trial courts and the courts of appeals, as well as for the bar of the state, in order that there may be uniformity of action in the trial courts and in the courts of appeals. Chester Park Company, Supra, p. 286. The specific facts of Chester Park, however, did not require this court to address itself to the use of the remediator where prejudicial error has intervened to contaminate the verdict. It is respectfully submitted that this case now affords the court of the opportunity to complete its analysis of the permissible use of the remediator and to provide very definite rules for the guidance of the trial courts and the court of appeals. Fairness and justice dictate that where error has intervened to the prejudice of the party against whom a verdict has been rendered and where the possible maximum impact upon the verdict is ascertainable, a court should 1. Order a new trial or 2. Affirm the judgment of the lower court if the plaintiff agrees to accept a verdict reduced by that sum which represents the maximum effect of the error. In this case, then, this court should do what the Court of Appeals failed to do. 1. Grant the defendant appellants a new trial or 2. Affirm the judgment if the plaintiff consents to a judgment in the amount of $567,467.16, $839,000 less $262,532.84. To proceed in this fashion is to ensure a fair verdict, and to eliminate any prejudicial effect of the error upon the verdict. If the plaintiff does not assent to the remediator, the matter should be retried. To do anything less is to deny the defendant's appellants a trial free of prejudicial error and to sanction a verdict which may consist of damages in excess of $250,000 which were improperly submitted to the jury. Respectfully submitted. How might that brief have begun? In the Supreme Court of Indiana. Appeal from the Court of Appeals. 3rd Appellate District. Marion County, Indiana. PLEBINOL Corporation. Plaintiff appellee and cross-appellant. Versus. The Tull Group Inc. And. Tull Aerospace. Defendants appellants. Brief of defendants appellants. The Tull Group Inc. and. Tull Aerospace. Issue presented. Plebinol's jury demand was for damages of nearly $1.1 million. But after the jury returned a verdict of $839,000, the intermediate court unanimously decided that $263,000 of the $1.1 million demand had been improperly submitted. Instead of offsetting this amount against the actual verdict, however, the court offset it against the inflated demand, as if the jury somehow knew to reject the improper portion. Shouldn't the improperly submitted amount have been offset against the verdict actually rendered? Statement of the case. In August 1985, Plebinol sued the Tull defendants collectively, Tull, alleging that, etc. An unusually good example. In the United States District Court. For the Southern District of Texas. Houston Division. Image. Fireman's reply to FDIC's summary judgment brief. Preliminary statement. The issue facing this court boils down to a straightforward question of contractual interpretation. Fireman's Insurance Company insured USAT against losses occasioned by real estate documents that are defective by reason of the signature thereon of any person having been obtained through trick, artifice, fraud, or false pretenses. Couch engaged in massive fraud when, with valid documentation, he sold USAT grossly undervalued mortgages. Does the mere fact that the mortgages were worth less than USAT thought mean that the sale documents were defective by reason of the signatures? That is the overarching question that swallows all the sub-issues. In this reply, Fireman seeks, in light of the FDIC's earlier brief, to develop this major issue and to treat the sub-issues as succinctly as possible. Fireman's reply to FDIC's summary judgment brief, page 1. 1. The language of the rider supports coverage only for fraud in the factum. A. USAT doesn't claim that the instruments are defective by reason of fraudulently obtained signatures. There are two types of fraud. Fraud in the factum is fraud as to the nature of the writing that one signs. 2. As when a blind person signs a will when misleadingly told that it's just a letter. Fraud in the inducement refers to all other types of common law fraud, that is, fraud that induce S1 to make an agreement, 3 such as lies that a given piece of land is arable when in fact it's marshland. In mentioning fraud, the writer refers to defective instruments, i.e., defective by reason of the signature thereon of any person having been obtained through trick, artifice, fraud or false pretenses. No court has ever had any difficulty in deciding which type of fraud this writer refers to. 4. Fireman's reply to FDIC's summary judgment brief, page 2. USAT suffered a loss from fraudulently obtained real estate loans based on Couch's misrepresentations about lien priority fraud in the inducement. The rider purchased by USAT covers only those losses resulting from real estate loan documents that are defective because the signatures were fraudulently obtained. Fraud in the factum. The FDIC stretches the language beyond recognition in claiming that the rider covers USAT's loss. For 3 reasons, it is difficult to take seriously the FDIC's view that the rider should have used the phrase, fraud in the factum, in order to provide clear notice to the policyholder of any limitations the insurer wished to impose. 5. First, few people, few lawyers, even, would know what the phrase, fraud in the factum, means. Second, as a drafting matter, the better practice is to say, in the plainest language, with the simplest, fewest, and fittest words, precisely what it means. 6. Third, the writer itself admirably captures the definition of fraud in the factum, so the Latinism was all the more undesirable. Although the FDIC argues that the term, defective, should be interpreted broadly, it ignores most of the writer's language. The loss must result from a defective document, and the cause of the defect must be a fraudulently obtained signature. The FDIC has not pointed, and cannot point, to any such defect. Fireman's reply to FDIC's summary judgment brief, page 3. B. The language of the loan exclusion excludes a vast universe of fraud, whereas the writer revives coverage for the narrow, comparatively rare situation in which the fraud concerns the document itself and the signature. Rather than repealing the exclusion wholesale, the writer merely carves out a minute exception to the exclusion, an exception relating to documents that are defective as a result of fraudulently obtained signatures. 1. The language isn't parallel. The loan exclusion relates to fraud in an entire loan or transaction, while the writer relates only to fraud in obtaining signatures on documents. Although the FDIC argues that key phrase, trick, artifice, fraud, or false pretenses in paragraph 1 of the writer is identical to the phrase appearing in the loan exclusion 7, as of course it is, the point is entirely irrelevant. Although that part of the phrasing is the same, the critical point is the changes that occur in other words. Image. Fireman's reply to FDIC's summary judgment brief, page 4. The FDIC argues that the trick artifice phrasing, which has been used to define fraud ever since Samuel Johnson wrote his dictionary in 1755, should be construed consistently, giving it the broadest possible interpretation to include all types of fraud, not just fraud in the factum. 8. What the FDIC ignores, of course, is the uses to which tricks and artifices may be put, to induce someone to make an agreement fraud in the inducement or to deceive someone into signing a document that he or she believes to be something else fraud in the factum. By its terms, the loan exclusion embraces the former and more while the writer embraces the latter. Fireman's reply to FDIC's summary judgment brief, page 5. 9. Phrase your issues in separate sentences. Don't start with whether or any other interrogative word. Quotable quotes. The following example illustrates the problem of how to phrase an issue appealingly. 1. Whether the owner of coupon bonds should include in his gross income the amount of coupons which he detached and gave to his son several months prior to maturity. 2. The taxpayer owned coupon bonds. Several months before maturity of the interest coupons he detached them and gave them to his son, retaining the bonds themselves. Is he relieved of income tax with respect to these interest coupons? Both are well-formulated questions. The second is probably a shade better because it stresses that the taxpayer retained the bonds and then asks on top of that whether he is relieved from tax. Note also the change in the form of the question presented, from the one sentence, whether, form to the fact statement plus question form, all in the direction of adding appeal. Frederick B. Wiener, Briefing and Arguing Federal Appeals 74-75 Reverend ed. 1967. Such a formulation, i.e., the multi-sentence issue statement, has the advantage of being readable. It is just as concise as the one-sentence format and is much clearer. Gervin Peck, Writing Persuasive Briefs 103, 1984. The purpose of using separate sentences is to help the reader. A one-sentence issue of 75 or so words is difficult to follow, especially when the interrogative word begins the sentence and the end is merely a succession of when clauses, e.g. Can Barnes Insurance deny insurance coverage on grounds of late notice when Fiverr's insurance policy required Fiverr to give Barnes notice of a claim, immediately, and when in May 1994, one of Fiverr's offices was damaged by smoke from a fire in another tenant's space, and when 10 months later, Fiverr gave notice, and when Barnes investigated the claim for 6 months before denying coverage and did not raise a late notice defense until 18 months after the claim was filed. 81 words. That's a muddle. Readers forget the question by the time they reach the question mark. Part of the reason is that the time is out of joint. We begin with a present question, then back up to what happened, and then, with the question mark, jump back to the present. The better strategy is to follow a more or less chronological order, telling a story in miniature. Then, the pointed question, which emerges inevitably from the story, comes at the end. Fiverr's insurance policy required it to give Barnes Insurance notice of a claim, immediately. In May 1994, one of Fiverr's offices was damaged by smoke from a fire in another tenant's space. 10 months later, Fiverr gave notice. Barnes investigated the claim for 6 months before denying coverage and did not raise a late notice defense until 18 months after the claim was filed. Can Barnes now deny coverage because of late notice? 73 words. Instead of one 81-word-long sentence, we have 5 sentences with an average length of 15 words. And the information is presented in a way that readers can easily understand. Brian A. Garner, A Dictionary of Modern Legal Usage 473, 2D ed. 1995. Explanation. The one-sentence version of an issue doesn't seem to be required anywhere, but it's a widely followed convention. And it's ghastly in its usual form because it leads to unreadable issues that are deservedly neglected. Either they're surface issues, or else they're meandering, non-chronological statements that can't be understood on fewer than 3 close readings. Besides, the common, whether, version isn't really a sentence at all, much less a question, hence the question mark is odd. Although Wiener recognized even back in 1967 that the separate sentences had a way of adding appeal, he didn't seem to recognize that the only way for legal issues to be predictably good is to use the multi-sentence version. In my own example quoted above, how would most brief writers state the issue? A sensible writer wouldn't want the 81-word version, but instead might produce something like this. Whether Barnes Insurance can deny insurance coverage on grounds of late notice. That's certainly readable, but it's uninformative. A reader would need to plow through a whole brief to feel comfortable answering that question. It's a classic surface issue. But if the choice is between that one-sentence version and the 81-word version quoted above, most would probably take the more reasonable 12-word sentence. Anyone making that choice, however, ignores the true problem. We've simply started off with a miserably bad premise, that an issue must be cast in a single sentence. Where did we get this premise? It seems to come from a well-intentioned attempt to get issue writers to be succinct. By golly, the idea went, we'll just force them to say it all in one sentence. There are far better ways to enforce brevity, see number 10. We shouldn't choose a method that impairs our ability to convey information clearly. You'll inevitably need to break down the sentences within the issue. The Solicitor General's office, which produces some of the best briefs to be found anywhere, often uses the multi-sentence approach, but not consistently enough. When the SG or any other advocate balls the issue up into one sentence, the facts and the law often get jumbled illogically. And the subject often gets separated from the verb. Here, for example, is an issue statement as the SG presented it to the U.S. Supreme Court in December 2001, with 65 words between subject and verb. Whether an order of the National Labor Relations Board directing petitioner to pay back pay to an employee who was discriminatorily laid off for union organizing activity in violation of Section 8(a)(3) of the National Labor Relations Act, Act 29 U.S.C. Section 158(a)(3), but only up to the date on which petitioner discovered that the employee was an undocumented alien not authorized to be employed in the United States, is a proper exercise of the board's authority to remedy petitioner's violation of Section 8(a)(3) of the Act. Asterisk. Order is the subject, is the verb. With the wide separation, it's hard for even the most tenacious of readers to remember what the subject is by the time the verb comes around. See number 34. That's mostly a result of the straitjacketing one-sentence format. Notice what happens, though, when the same information is presented in two shorter sentences. It all unfolds more naturally. The National Labor Relations Board ordered petitioner to pay back pay to an employee who was discriminatorily laid off for union organizing activity, but only up to the date when petitioner discovered that the employee was an undocumented alien not authorized to work in the United States. Was this order a proper exercise of the board's authority to remedy petitioner's violation? That's an objectively worded issue because it includes only a factual premise and a question, without a legal premise. See number 11. Many believe this is the most appropriate way of wording an issue in the Supreme Court, that is, not suggesting the answer. The point of the example, however, is to show how much more appealing, and how much more succinct, the same information is when put into a multi-sentence format. You'll find, quite consistently, that the one-sentence format causes an issue statement to degenerate. Try writing any of the following issues in a single sentence. Either you'll be quite unhappy with the result, or else you'll be satisfying yourself with a statement that's less informative and less readable. Some uncommonly good examples. In 1973, Archway manufactured and sold to Feldspar a hoist designed for attachment to a free-swinging trolley system. 30 years later, without Archway's knowledge, Trubster acquired the hoist, added a new motor, pulley, and cable, and integrated the hoist into a fixed elevator dumbwaiter system. Is Archway liable for injuries resulting from integration of its hoist into a system defectively designed by Trubster? 64 words. George Ratliff asks this court to declare certain provisions of the Campaign Contribution Limits Act of 2003 unconstitutional or inapplicable to him. The act does not go into effect until January 1, 2004. The Registry of Election Finance, which has the authority to enforce the act, has not taken any action, or threatened to take any action, against Ratliff for violating the act. Has Ratliff presented an actual controversy that would make declaratory relief appropriate? 75 words. Maryland law prohibits the discharge of effluent to which a permit holder has added chlorine or chlorine-containing products. Zero Corporation, a permit holder, is discharging unaltered municipal tap water that contains chlorine added by the city. Are these discharges legal under Maryland law? 44 words. The attorney-client privilege protects from disclosure only those communications that are kept confidential within the strict confines of the attorney-client relationship. Eagle Company disclosed communications to a third-party insurance broker after learning of Rush Insurance Company's denial of coverage. Can Eagle Company now refuse to disclose these communications based on a claim of privilege? 57 words. Under New York law, a party to a contract may not bring a claim for fraud for unfulfilled promises of future performance made in the agreement. Forsyth Inc. and Stern Corp. entered into a buyout agreement. Forsyth alleges that representatives of Stern committed fraud by promising during negotiations and in the agreement that Stern would refer business to Forsyth after the buyout. May Forsyth recover for fraud in addition to its breach of contract claim? 75 words. Rule 25 requires a claim to be dismissed if an appropriate party is not substituted for a deceased party within 90 days after a suggestion of death is filed. Christine Black, the plaintiff, died on July 10, 2002. Western Company filed a valid suggestion of death 10 days later. No party has been substituted for Christine Black, and it has been more than 90 days since July 15. Should Christine Black's claim be dismissed? 75 words. In August 2002, the Enclave signed a multi-year lease with Woodhill. Unknown to the Enclave, however, Woodhill had fallen into default on past due assessments and, after the lease was executed, assigned its interest to the condominium association to avoid foreclosure on the building. Woodhill's successor now wants to cancel the lease even though the Enclave has fully complied with its obligations. May it do so, or is it bound by the lease terms? 74 words. Under Louisiana law, a corporation must include all debt in its corporate franchise tax base. Louisiana's highest court has long held that an advance is not debt if the borrower is not obligated to repay it. Bayou Boats receives advances on its corporate-owned life insurance policies, but it has no obligation to repay them. Must Bayou Boats include the advances as debt in its tax base? 67 words. In California, a parent may reduce a child support obligation by showing that the child earned money and that the extra money reduced the child's need for support. Ronald Borden proved that his daughter earned money on her paper route after school, but he did not show that it reduced his daughter's need for support. Is Borden entitled to a reduction in his child support obligation? 66 words. Every Michigan lease inherently imposes a covenant of quiet enjoyment on the owner. Easy Rentals has a 10-year lease on a building owned by James Yost. Under the lease's condemnation clause, the owner is not liable to the lessee if the building is condemned. Yost wants to rebuild on the site and has asked the city to condemn the existing building. Does Yost's request to the city breach the covenant of quiet enjoyment? 74 words. U.S. patent law protects only novel inventions and expressly bars protection for any invention that is offered for sale more than a year before the inventor applies for the patent. Stephen Phillips developed a prototype of a laser rangefinder and offered to sell it to Largent, Inc. More than a year later, Phillips applied for a U.S. patent on the rangefinder. Is Phillips barred from obtaining the patent? 68 words. A criminal defendant has the right to be present whenever prospective jurors are questioned on voir dire. During voir dire in this murder case, a prospective juror was questioned by the judge at the bench. Williams was present and positioned so that he could hear the conversation. He asked to approach the bench while the prospective juror was questioned, but his request was denied. Did that denial violate Williams's right to be present? 73 words. Under California and federal law, workplace conversation of a sexual nature is not sexual harassment if the plaintiff invited the interaction. Hannah Ferguson admitted that she routinely confided in Calvin Haskell, the only male among her 12 coworkers, and told him about her sexual activities. She took offense at Haskell's reaction to one story and sued the company for hostile environment sexual harassment. Is the company liable because of Haskell's conversation? 71 words. 10. Limit your issues to 75 words apiece. Quotable quotes. The way an issue gets to be stated can have fateful consequences. The attention of the judge, catalyzed by the striking written or oral phrase, must be held through to the critical issue. Here concentration and clarity of expression may well become decisive. Francis Bergen, Opinions and Briefs, Lessons from Lauren 6, 1970. It is the rare case indeed, in fact, I have yet to encounter it, in which issues cannot be framed in 75 words. The 75-word limit is the result of experimentation and informal testing. Once an issue goes beyond that length, it is likely to be rambling. You lose the rigor of concentrated statement. And you probably lose some readers. Brian A. Garner, A Dictionary of Modern Legal Usage 473 2D ed. 1995. Explanation. About 98% of the time, if you can't phrase your issue in 75 words, you probably don't know what the issue is. It's that simple. It takes hard work. I've seen people take a day to frame one question, but it's well worth the effort. Why? You're more likely to spot problems in your logic, and you're more likely to keep the judge's attention. More than that, you'll be satisfying a yearning that almost every judge feels by explaining what the question is in bite-sized form. You'll often be tempted to think that your case turns on issues that are too complex to be reduced to 75 words. Don't kid yourself. Even intellectual property cases are amenable to this treatment. Consider BN.com's winning appeal against Amazon.com. In the Federal Circuit, in 2000, that court had to decide whether BN.com had good defenses to Amazon.com's infringement claim on its one-click buying system. Here's how Stephen I. Wallach of New York, along with his colleagues William G. Pecco, Jonathan Marshall, Michael N. Rosen, and Mark J. Sugarman, all of New York, framed the 4 questions using the deep issue technique. 1. Consistency of construction. Amazon.com's patent claims ordering an item over the internet with a single action, such as a mouse click. While analyzing infringement, the district court construed single action as one action taken after descriptions of both the item and the single action are displayed simultaneously. But while analyzing validity, the court construed the claims differently, omitting the item description requirement when determining whether prior art disclosed a single action. Was this an error of law? 2. Prior art disclosures. The district court granted an injunction, concluding that BN.com's invalidity defenses lack substantial merit. But all the claim elements were admittedly old except single action ordering. And prior art online ordering systems disclosed an instant buy button, one-click ordering, a button reading, chart 50 cents for one-click ordering, and a web page link for one-click ordering. Expert testimony that these references invalidated the patent was unrebutted. Did the court err? 3. Non-infringement defenses. The district court also concluded that BN.com's non-infringement defenses lack substantial merit. But during its infringement analysis, the court construed single action, contrary to the doctrine of claim differentiation, the specification, and the prosecution history, and construed shopping cart, and fulfill, by impermissibly relying on extrinsic evidence. Under proper constructions of those claim terms, there is no infringement. Did the court err? 4. Underlying errors. The district court's findings on other factors that must be weighed on a preliminary injunction motion, irreparable harm, balance of hardships, and the public interest, are all based on the assumption that the 411 patent is valid and infringed. Given the legal errors underlying the court's analysis of the merits, did the court's analyses of those other factors themselves include legal errors? Notice how each successive issue builds on the previous ones. The third issue is probably the most difficult. It requires more background in intellectual property law than the others. Of course, in this as in all cases, the writer must consider what a generalist reader is likely to know already and avoid repeating it in full. So the phrase doctrine of claim differentiation is mentioned but not explained on the principle that any IP generalist, certainly one who sits on the Federal Circuit, knows something about this doctrine. And if not, it's fully explained in the body. The important thing for the writer is to convey as much as possible about each issue within the confines of a 75-word limit. The brief writers here did that in a hotly contested case. And they won. Asterisk. Some advocates make the mistake of thinking they need to put every citation and abbreviation in the issue statement. Doing so typically just clutters the statement and beclouds the thought. Consider this example, from a brief filed in the U.S. Supreme Court by the Solicitor General's Office in December 2001. The Food and Drug Administration Modernization Act of 1997 FDAMA 21 U.S.C. Section 353A, Sub P 1999 provides a limited exemption from the new drug approval and certain other requirements of the Federal Food, Drug, and Cosmetic Act FDCA 21 U.S.C. Section 301 et seq. For drugs compounded by pharmacists. The question presented is whether FDAMA's limitation of that exemption to pharmacists who do not solicit prescriptions for or advertise particular compounded drugs, 21 U.S.C. Section 353A and C. Sup. V. 1999 is consistent with the First Amendment. The citations need to be readily available in the brief, they just shouldn't be allowed in the issue statement. Even though the whole issue is only 85 words, the thought tends to get lost in all the numbers. Consider how much cleaner that issue is without all the citational volume and section numbers, and with some of the ideas reordered for enhanced readability. The Food and Drug Administration Modernization Act FDAMA exempts drugs compounded by pharmacists from certain requirements of the Food, Drug, and Cosmetic Act, including requirements for new drug approval. But the FDAMA limits that exemption to pharmacists who do not solicit prescriptions for or advertise particular compounded drugs. Is this limitation consistent with the First Amendment? Although the revised issue has only 57 words, a deep issue will typically have 60 to 75 words. But you may well ask, what about a complicated tax case? Is it really possible to do an issue within the 75-word limit? It's certainly easy to exceed the limit, as the Solicitor General showed in an August 2000 brief. Whose eyes wouldn't glaze over when trying to scale this 142-word obelisk? Petitioners are shareholders in an insolvent subchapter S corporation. During 1991, that corporation obtained a discharge of certain indebtedness. That discharge would have been treated as an item of income from discharge of indebtedness, 26 U.S.C. Section 61, 812, except that, because the discharge occurred when the corporation was insolvent, the item is expressly not include D in gross income, under 26 U.S.C. Section 108.81b. The question presented in this case is whether the amount thus expressly excluded from income is nonetheless to be treated as if it were an item of income, which, under 26 U.S.C. Section 1366.818 flows through to petitioners as the shareholders of the subchapter S corporation, thereby increasing their basis in the stock of the corporation under 26 U.S.C. Section 1367.81a and thereby allowing them to deduct losses they were previously unable to deduct because they had exhausted their basis by prior deductions. It starts with a fact, then adds another fact. Then it states a legal standard, followed by an exception to that standard. Then it begins to ask a question about that exception, but instead poses the question as if it had to do with an exception to the exception already mentioned, followed by one new fact and then another. Even if it were tighter, the organization of the issue is all but hopeless. Throw out the unnecessary detail, put it into logical order, and you have a respectable 71-word issue. Under Section 108.81b of the Internal Revenue Code, the discharge of a subchapter S corporation's debt isn't included in gross income if the corporation is insolvent at the time. In 1991, PVW&A, an insolvent subchapter S corporation, obtained a discharge of debt. Its shareholders claim that the discharge should be counted as income so that their basis in the stock will increase, thereby allowing them to deduct losses that they otherwise couldn't. Are they right? Even tax issues, you see, can be stated straightforwardly. Following are several more good examples. Some uncommonly good examples. Under Wyoming law, administrative agencies have only those powers provided by statute. No statute gives the Wyoming Natural Resources Commission the authority to impose any sanctions for discovery abuse. May the commission dismiss a permit application if it finds that the applicant has failed to respond to discovery requests. 49 words. Section 305 of the Government Code makes it a crime for a lobbyist to enter into a contingency fee lobbying contract. Smith has agreed to lobby for water legislation on behalf of the Guernsey Corporation. If the legislation passes, Guernsey will pay Smith $1 million. Has Smith committed a crime? 50 words. For over 30 years, Texas courts have held that the term, single-family dwelling, imposes a use restriction unless the term appears in a section of the restrictive covenants solely governing the architectural form of dwellings. The Beautiful Valley covenants contain the term, single-family dwelling, in a section containing both use and architectural restrictions. Do these restrictive covenants prevent Mr. Johnson from running a boarding house in his home? 72 words. To decide a parent's request to modify child support obligations, Virginia law requires a trial court to consider both parents' incomes. Mr. Smith requested a reduction of his child support obligations. The trial judge refused to hear testimony from Ms. Smith about her income and reduced Mr. Smith's obligation. Should this court vacate the order and remand for the trial court to consider Ms. Smith's income before setting the amount? 70 words. In 1981, Congress directed the HHS to replace the retrospective cost-based method of Medicare payments for kidney dialysis with a prospective payment method. In 1983, the HHS adopted regulations that included a retrospective cost-based limit on the bad debt component of the payment, providing no valid justification for this departure from the statutory requirement to use the prospective method. Is the HHS authorized to depart from the statutory requirement in this way? 74 words. The U.S. Supreme Court has mandated that lower courts must not accept as true a legal conclusion couched as a factual allegation in pleadings. Pantheon sued Panathen for trademark infringement but pleaded no facts in its complaint from which a court could determine ownership of the trademark asserted. Should this court dismiss Pantheon's complaint for failure to state a claim on which relief may be granted? 66 words. After Desert Storm, the United States imposed sanctions against Iraq. A regulation implementing those sanctions bars the import of goods in which the Iraqi government has any present, future, or contingent interest. The Iraqi government's interest in oil bought by Paladin oil traders ended 2 years before Paladin tried to import the oil. Acting under the sanctions regulation, the U.S. Customs Service seized Paladin's oil shipment. Was the seizure legal? 70 words. Under Utah law, to recover for fraud a plaintiff must prove detrimental reliance on a deliberate misrepresentation. In a meeting with Perkins, Dedman allegedly misrepresented the price of his goods, saying that they were competitively priced when they were not. Perkins sued for fraud, but in his deposition, Perkins testified that he had made no decision based on anything said at that meeting. Can Perkins recover against Dedman for fraud? 70 words. The U.S. Supreme Court has held that Title V of the Civil Rights Act of 1964 does not confer a private right of action under the statute or its implementing regulations. The plaintiffs here are a class of California schoolchildren who allege that the Department of Education has violated Title V and its implementing regulations. Can these plaintiffs sue the Department of Education for violating Title V or its implementing regulations? 71 words. Relevant evidence makes a fact of consequence more or less probable. In the sentencing phase of Gilkerson's trial, the state offered evidence about the length of Gilkerson's previous sentences. Gilkerson objected, saying that the length of past sentences is not relevant to his culpability for the current conviction. The state argued that the evidence shows that another short sentence would not deter Gilkerson from future crimes. Was the evidence relevant? 70 words. 11. Write fair but persuasive issues that have only one answer. Cast each issue as a syllogism. If you have several issues, give each one a concise, neutral heading. Quotable quotes. In almost all cases, we find that we draw our conclusions from two related statements, the one a general statement covering many cases, which we may call the major premise, the other a particular statement of fact, which we may call the minor premise. Samuel S. Seward, Rhetoric in Practice 67, 1906. Of course, the first thing that comes up is the issue and the first art is the framing of the issue so that if your framing is accepted the case comes out your way. Got that? Second, you have to capture the issue, because your opponent will be framing an issue very differently. And third, you have to build a technique of phrasing your issue which will not only capture the court but which will stick your capture into the court's head so that it can't forget it. Carl Llewellyn, A Lecture on Appellate Advocacy, 29 U. Chi. L. Rev. 627, 630, 1962. A good statement of the question or issue involved is fairly complete. It raises an issue of law based upon the concrete facts of the case. It is all-inclusive and aids an understanding of the argument. Mario Pittoni, Brief Writing and Argumentation 51, 1967. Key issue to be argued must be raised in a way that will establish a point from which the writer can lead his readers to the conclusion he wishes to urge. That is, the introduction must in some fashion lead to a step of the argument by which the writer hopes to secure assent to his thesis. William J. Brandt et al., The Craft of Writing 48, 1969. The rules of formal logic are invaluable to courts, and the fallacies of an argument may sometimes be most effectively exposed by casting it in the form of a syllogism. George W. Patton, A Textbook of Jurisprudence 200. G. W. Patton and David P. Durham eds. 4th ed. 1972. Questions should be shaped as far as possible to compel a desirable response, or at the very least avoid an undesirable one. William A. Rusher, How to Win Arguments 118, 1981. The way the issues are written will govern the court's first impression on the merits. Whatever the theme, each issue statement should incorporate specific facts and legal principles in a simple, concise, and accurate manner. The brief writer must try to put the issues persuasively, but must not lose credibility by being strident or overstated. Jordan B. Cherrick, Issues, Facts, and Appellate Strategy. In Appellate Practice Manual 73, 76 Priscilla A. Schwab ed. 1992. When presented with the properly framed major and minor premises of a syllogism, the human mind seems to produce the conclusion without any additional prompting. Moreover, the mind recognizes the conclusion to be of such compelling force that the conclusion simply cannot be denied. The power of syllogistic argument leads to the only significant rule about crafting legal arguments: every good legal argument is cast in the form of a syllogism. James A. Gardner, Legal Argument 6, 8, 1993. Explanation. A good issue statement generally mirrors a syllogism, the basis of all logical thought. You have a major premise stating the law, a minor premise presenting the facts that tie into that major premise, and a conclusion. But when cast as part of an issue statement, the conclusion becomes a question. Yes, the best issues end with question marks. Why? Because a bona fide question looks and sounds objective even when it's gently slanted. Rather than pushing your answer, you're putting a question on the table. You're also challenging your opponent to explain how the answer could be other than as you're suggesting. You're seizing the issue, and, as a rule, the side that successfully does that will win. See the Llewellyn quotation above. In any event, the judge won't accept any answers until he or she figures out the question. If you supply it ready-made, the chances are greater that the judge will see the question as you see it. If you don't supply an explicit question, the judge's formulation is more likely to differ from what you'd like it to be. And remember, this formulation is inevitable because judges typically want to begin by understanding the questions they're being asked to answer. There are essentially two types of issue statements: analytical and persuasive. An analytical issue is objectively stated, it doesn't suggest an answer. It's appropriate for a research memo or an opinion letter. A persuasive issue is subtly slanted toward an answer. It's usually intended for a brief trial or appellate. Each type has a predictable form, best analyzed by considering the elements of a categorical syllogism. All men are mortal. Major premise. Socrates is a man. Minor premise. Therefore, Socrates is mortal. Conclusion. These elements should be arranged in legal issues in this way. Image. The major premise is the controlling legal point. The minor premise is the factual point that ties into that legal point. And the conclusion is expressed as a question. Consider this example. Image. To a clear-headed thinker, the analytical issue precedes the persuasive one. This example shows how to turn a good research memo into a brief. Take the short answer, turn it into a major premise, the first sentence of a persuasive issue, trim the minor premises necessary to get everything within a 75-word compass, and then pose the logical conclusion as a question. You may wonder whether the elements must appear in this order. The answer is yes, although there may be rare variations from it. Putting the minor premise first, followed by the major premise and then the conclusion, isn't nearly as persuasive. It looks too pat when the answer immediately precedes the question, as here. All the transactions between Balancio Securities and Ellesmere before April 2001 occurred outside Delaware, in Kansas, Nebraska, and South Dakota. Delaware courts have consistently held that Delaware's blue sky laws do not apply to securities transactions that take place out of state. Should this court dismiss Ellesmere's claims under the blue sky laws for the transactions completed before April 2001? Besides, when the issue reads this way, the first sentence has no context. In the syllogistic format, the legal premise supplies the context for the more specific factual premise. You may also wonder whether the minor premise needs to be so specific. The answer once again is yes. Within the 75-word limit, you need to make the minor premise as specific as you reasonably can. See number 12. This will enhance your credibility. If you state a conclusory minor premise, readers aren't likely to believe what you're saying. Consider this variation. Delaware's blue sky laws do not apply to securities transactions that take place out of state. All the relevant transactions occurred outside Delaware. Should this court dismiss the claims? The writer is asking for a leap of faith. Too much is being held back for the middle part of the writing. Instead, the writer can do lots of good here with a greater level of concreteness. By the way, one of the several shortcomings of a one-sentence whether issue is that it leads to greater vagueness in the facts, as well as to an unchronological presentation. Consider one more variation on our blue sky laws issue. Whether this court should dismiss Ellesmere's claims based on Delaware's blue sky laws when the transactions at issue took place out of state, and the Delaware courts have already held that the blue sky laws do not apply to securities transactions that take place out of state. That's not horrible, but it's far from great, especially on a first reading. It begins in the present. Should this court dismiss, moves to the transactions several years ago, and then moves to precedent many years older. It's harder to get your mind around that sort of long sentence fragment. Oh, yes, the weather makes the issue an ungrammatical sentence fragment. Did you know that it's possible for every legal argument to be framed as a syllogism? Not only that, every legal argument should be framed as a syllogism. There's one other thing about the syllogism. Although you generally want a major premise stating the law, that's true only if the judge needs to be reminded about the law. You don't need a major premise that says, the First Amendment of the U.S. Constitution protects freedom of speech. Everybody knows that, and you shouldn't waste any of your precious 75 words on something that basic. Say in the first example below, you don't need to remind the reader about fundamental fairness in our criminal justice system. But in all the others, the legal premise needs an explicit statement. It's a helpful reminder. Some good examples. David Jackson will probably be convicted of capital murder and sentenced to death at next week's trial unless he can present evidence of his mental retardation. Jackson's expert on mental retardation must undergo emergency surgery to remove a cancer that his doctors have just discovered. Should the court grant Jackson's motion for continuance to allow him time to find a new expert? 62 words. Under Mississippi discovery rules, computer-stored information is as freely discoverable as tangible, written materials. Even though the defendant's second request for production asked for computer-stored information, the state refuses to search its computers. Given that a search for this computer-stored information would not entail any more effort than searching for tangible, written materials, should this court compel the state to produce it? 68 words. Florida rules allow deposition testimony to be used at trial only if the witness cannot be located after a good faith attempt to serve a subpoena or if the witness is more than 100 miles from the court. Judge Hand, in Miami, barred the use of the deposition of Jack Throckmorton, an Orlando resident, because the proffering party did not show a good faith attempt to serve a subpoena. Was Judge Hand's ruling erroneous? 74 words. Under Washington law, county commissioners may not appoint a civil servant for a term that is longer than the commissioners' own elective terms. The Schoolaleah County Commissioners, who serve 3-year terms, appointed Bartleby as county manager. In a tight labor market, Bartleby was able to negotiate a 5-year employment contract. The commissioners accepted and signed the contract. Is Bartleby's contract enforceable? 63 words. Under Missouri law, permanent total disability benefits are awarded in a workers' compensation case only if the worker cannot return to any employment in the open labor market. John Shepelwich was injured on the job and applied for permanent total disability benefits. Doctors and vocational experts who treated or evaluated him all reported that he could work at available lighter sedentary jobs. Should Shepelwich have been awarded permanent total disability benefits? 72 words. The Immigration Act lets the Attorney General grant permanent residency to an undocumented alien who has lived in the U.S. continuously for at least 10 years and can show that deportation would cause extreme hardship to an immediate relative who is a U.S. citizen. Laura has lived in Texas since 1980 and has a 3-year-old U.S.-born daughter who depends on her for support. May the Attorney General grant permanent residency to Laura. 74 words. Federal Rule of Evidence 8 requires that a complaint give a short and concise statement that puts the defendant on notice of what issues the plaintiff will raise. Erickson filed a 203-page complaint against brokerage for fraud. The complaint consists largely of multiple-page quotations from brokerage research reports, followed by generic statements that the reports are fraudulent. Should Erickson's complaint be dismissed for failure to comply with Rule 8? 71 words. When a corporate executive communicates with in-house counsel, the attorney-client privilege protects only those communications made for the purpose of obtaining or rendering legal advice. Alan Jones, vice president of Widget Company, had a conversation with Jean Nine Meacham, in-house counsel for Widget Company, in which Jones sought both business and legal advice. Are the portions of that conversation pertaining to business advice protected by the attorney-client privilege? 69 words. Under California common law, a creditor can obtain an equitable lien on a debtor's property only if the debtor intended to grant the creditor a lien on that specific property. Pat Jones, a creditor of this bankruptcy estate, claims an equitable lien in escrowed funds based on an escrow agreement that does not expressly or implicitly grant Jones a lien on those funds. Does Jones have a lien on the escrowed funds? 72 words. The Americans with Disabilities Act protects a disabled employee who can perform the essential functions of the job if the company makes reasonable accommodations. Gail Duval, who became disabled, was terminated by Wyman Corp. And sued under the ADA. In her deposition, she testified that when she was terminated, her disability had rendered her unable to perform her job even with accommodations. Was Duval protected under the ADA? 68 words. Multiple issues with neutral headings. Scott P. Stoley of Dallas, an accomplished appellate practitioner, has developed a good method for naming issues by providing a neutral label for each one. Both examples below are from his briefs. In the actual briefs, each passage quoted below is followed by the statement of facts. Example A. Issues. The Borans appeal presents three main issues. Date of the breach or tort. When the precise date of the breach or tort is ascertainable, a medical malpractice plaintiff who sends the statutory notice must sue within 2 years and 75 days after the breach or tort occurs. It is undisputed that Dr. Kellogg examined Mrs. Boran only once and that the Borans did not sue until 2 years and 76 days later. Are the Borans' claims time barred? Waiver. At trial, the Borans argued that the limitations period was extended by a continuous course of treatment. On appeal, the Borans have abandoned this argument and have raised two new arguments, that the state constitution's open courts provision saves their claims, and that the limitations period did not begin to run until William Boran was born and became a patient 4 days after Dr. Kellogg saw Mrs. Boran. Have the Borans waived these new arguments? Open courts. The Borans' wrongful death and survival claims are statutory claims not recognized at common law. The open courts provision preserves only common law claims. Does the Borans' open courts argument therefore fail? Example B. Issues. The appeal by the Thompsons and Ms. Taylor Evans presents three main issues. Applicability of Chapter 38. Chapter 38 of the Texas Civil Practice and Remedies Code does not permit recovery of attorney's fees from an insurer whose policy is subject to Article 21.21 or 21.21-2 of the Texas Insurance Code. State Farm's policy covering the Colby family is subject to both of those articles. Did the trial court therefore properly deny attorney's fees under Chapter 38? Legal entitlement. Attorney's fees are recoverable under Chapter 38 only if a defendant fails to pay an amount owed. Uninsured motorist benefits are not owed until the insured satisfies a condition precedent, namely, that the insured be legally entitled to recover from the uninsured motorist. Did the trial court properly deny attorney's fees here, given that the claimants failed, until after judgment was entered, to establish a legal entitlement to recover from the Colbys? Presentment. As a further prerequisite to recovery of attorney's fees under Chapter 38, the claimant must also present the claim. Here, there is no evidence that Thompson's parents or Ms. Taylor Evans ever made presentment, and further, there is no evidence that any claimant ever made presentment after belatedly establishing an arguable entitlement to recover from the Colby family. Did the trial court therefore properly deny attorney's fees to the claimants? 12. Weave facts into your issues. To make them concrete. Quotable quotes. In the majority of cases the chief difficulties of the brief writer are not to prove certain legal propositions, but to show that certain legal propositions are applicable and controlling under the specific facts of the case in hand. William M. Lyle et al. Brief Making and the Use of Law Books 375 3D ed. 1914. An abstract style is always bad. Your sentences should be full of stones, metals, chairs, tables, animals, men, and women. Alain Delille is quoted in Rudolf Flesch, The Art of Readable Writing 83, 1949, Reaper. 1967. Writing should be concrete. It should evoke images and refer to something the reader can identify with particular experiences. A general concept like motion is interesting to a philosopher, but an ordinary reader wants to know what is moving, how fast, whether it is going toward him or away from him, and what effect the motion of this object will have on his income or his likelihood of getting a good night's sleep. Sumner Ives, A New Handbook for Writers 317, 1960. Writing too largely in abstract terms is one of the worst and most widespread of literary faults. It sounds learned, it saves the writer from having to use his eyes and ears, and it makes slovenly thinking possible because it does not require definiteness. David Lambeth et al. The Golden Book on Writing 32, 1964. Not in all, but in most cases, the issues can only be described by reference to the facts as well as the law. George W. Patton, A Textbook of Jurisprudence 214, G.W. Patton and David P. Durham eds. 4th ed. 1972. The more abstract your argument, the more you should lace it with graphic illustrations, analogies, apt quotations, and concrete details. These are aids not only to your reader's understanding but also to his memory. John R. Trimble, Writing with Style 79, 1975. It is inadequate merely to state the legal issue without any reference to the factual setting in which it arises, e.g., whether the defendant is entitled to judgment notwithstanding the verdict, or whether the trial court's instructions were erroneous and prejudicial. Gervin-Peck, Writing Persuasive Briefs 101, 1984. The most helpful statement of an issue is in terms of its facts, not as an abstract question of law. The statement should show the precise point of substantive law and its applicability to the facts at hand. Thus, was plaintiff guilty of contributory negligence? Does vaguely indicate the general issue, but how much more helpful to the court's concentration and understanding of the issue is, plaintiff's car struck the rear of a vehicle operated by the defendant, who had made an emergency stop without signaling. Where plaintiff admits that he could not have stopped his car within an assured clear distance ahead, is he chargeable with contributory negligence so as to bar his recovery? Albert Tate Jr., The Art of Brief Writing, What a Judge Wants to Read. In Appellate Practice Manual 197, 202 Priscilla A. Schwab ed. 1992. I spend a lot of time avoiding conceptual discussions or translating them, where possible, into Joe's six-pack language. You would be surprised how often abstract concepts conceal a failure to come to grips with the precise issues or facts in the case. Patricia M. Wald, How I Write, 4 Scribes J. Legal Writing 55, 59, 1993. Explanation. Unfortunately, some court rules actually require that advocates write a concise statement, not exceeding 2 pages, of the questions involved without names, dates, amounts or particulars, with each question numbered, set forth separately and followed immediately by the answer, if any, of the court from which the appeal is taken. Asterisk. If you're bound by such an unfortunate rule, which seems like an inarticulate warning against overparticularization, see number 27, follow it. You can still follow most of the advice given here about issue framing. You'll just be doing it more abstractly. The better approach is typically to weave concrete facts into your issue statements, so that you tell a story in miniature, with names and all. But remember that you want only the particulars that are important, the ones that help the reader understand the problem. In fact, when brief writers try to frame their issues in the syllogistic format outlined in number 11, they typically stumble, if they do stumble, on the middle part of the syllogism. That is, their facts are too abstract or conclusory, or else they're chronologically scrambled. Within your 75-word limit, try to be as concrete as you can helpfully be. And sustain the storyline as long as you can before asking a short, punchy question. Try not to bring up new facts in the question, as by including a when clause in the question. Avoid saying, is Putnam liable when? Instead, say what happened, and then end with, is Putnam liable? For those bound by a don't give us any particulars rule, it's probably worth citing a couple of winning issues before a state Supreme Court. William J. Conroy and Robert Tolan II of Wayne, Pennsylvania, along with Joseph A. Katerincik of Pittsburgh, used the multiple sentence approach with success before the Pennsylvania Supreme Court in 2002. In fact, they succeeded in getting the court to reverse on the briefing alone, a rare event in that state. Here are their winning issues, written under the constraint of minimizing particulars. 1. Waiver. Rule 227b provides that objections to the jury instructions may be made anytime before the jury retires. Here, defendants objected on the record during the charge conference, well before the jury retired. Yet the Superior Court ruled that defendants had waived their objections because they had not moved for non-suit or directed verdict. Does this ruling depart from Rule 227b and established case law to create a new waiver rule without foundation in law? 2. Crashworthiness. All the parties tried this case under a crashworthiness theory. Yet the trial court refused to instruct the jury on the elements that this court and the Superior Court have held must be established for crashworthiness liability. Instead, the jury instructions reflected the materially different standards of general strict liability. Did the court err in refusing to instruct the jury on the elements of crashworthiness? Those issues do a great job of showing syllogistic reasoning, and they passed the ultimate test. They won a reversal. Some good examples. At 7:31 morning last spring, Father Michael Prynne, a Roman Catholic priest, was on his way to buy food for himself at the grocery store when his car collided with Ed Grimley's pickup truck. The Catholic Church neither owned Father Prynne's car nor required its priests to buy groceries as part of their priestly functions. Was Father Prynne acting as an agent for the church at the time of the accident? 72 words. In New York, a person who knowingly purchases used goods cannot bring a claim for breach of implied warranty. Sandra O'Keefe admitted at her deposition that she bought her 2001 Acura, the vehicle that she claims the manufacturer impliedly warranted, with more than 11,000 miles on the odometer. Should O'Keefe's claim for breach of implied warranty be dismissed because the car was used when she bought it? 67 words. The Colorado Water Board lowered Cherry Creek's minimum stream flow from 12 cubic feet per second to 7. The board's decision, reached after 4 public hearings on the subject, was based on recommendations of both the Colorado Division of Wildlife and 3 independent aquatic biologists, all of whom concluded that 7 cubic feet per second was the optimal minimum for Cherry Creek. Was the board's decision arbitrary and capricious under the Administrative Procedure Act? 74 words. New York domestic law provides that a maintenance agreement is not binding if it was made under duress or is patently unfair. At the end of her 18-year abusive marriage, Sally, who has only a 9th grade education and no financial experience, agreed to a maintenance award so low that she cannot afford food for her children. Should this court invalidate Sally's maintenance agreement? 65 words. Under Prindine Corp's collective bargaining agreement, the company may fire an employee for good cause. Jane Smith, an employee at Prindine, was temporarily assigned by her immediate supervisor to a position she didn't want to fill. She then left the plant premises without authorization, as a result of which the company had to shut down part of the production line overnight. Did the company have good cause to fire Smith? 70 words. Pavemasters, a contractor, agreed to install a masonry surface at Lincoln Hospital. Before the work began, the hospital repeatedly asked about the design's drainage system, but Pavemasters did not answer. Only after installation was well underway did Pavemasters admit that the project included no drainage system. The hospital later sustained water damage because rainwater did not drain properly. Is Pavemasters responsible for the cost of repairing the water damage and installing a drainage system? 74 words. State bar conflict of interest rules prohibit an attorney from representing a party in a divorce action if the attorney has previously represented both parties in other litigation. Janie Wilson and her husband Bob hired attorney Ben Bailey when they purchased some property. 2 years later, Janie hired Bailey to represent her in her divorce from Bob. Is Bailey barred from representing Janie? 63 words. New Hampshire criminal procedure bars a defendant from withdrawing a guilty plea after being sentenced. In 1999, McNair agreed to plead guilty to petty burglary for a probated sentence. Now he has been charged with violating the terms of his probation and faces the probability of a prison sentence. McNair contends that because the sentence may still be changed, he retains the right to withdraw his guilty plea. Is he right? 71 words. In Georgia, an out-of-court conversation is admissible as evidence if it explains a person's conduct or state of mind. While visiting the Johnsons on April 2, Marshall watched as 1. Mr. Johnson accused his wife of adultery with his best friend, 2. She confessed, and 3. He slapped her. 2 hours later, after Marshall had left, Mrs. Johnson was murdered. Is Marshall's testimony about the conversation admissible in Mr. Johnson's murder trial? 74 words. A foreign national who has been firmly resettled in a third country is ineligible to apply for asylum in the United States. Before entering the U.S., Marla Simonik, a citizen of Bosnia-Herzegovina, spent 15 months in a refugee camp in the Netherlands. At the camp she was forcibly confined, had no access to education or employment, and was not eligible to apply for residence in the Netherlands. Did Marla firmly resettle in the Netherlands? 75 words. Federal jurisdiction under the Alien Tort Statute requires that the plaintiff allege a violation of the law of nations, such as acts of torture committed by government officials acting under color of state authority. Mueller Corp. is a defense contractor. Palmer alleges that Mueller employees, who are all private citizens, harassed, assaulted, and attempted to kidnap him. Has Palmer alleged a claim for torture in violation of the law of nations? 71 words. The Supreme Court has held that the Fourth Amendment is not violated when a police officer makes a custodial arrest after seeing the person commit a misdemeanor traffic offense in a public place. A police officer saw John Fillmore driving on Main Street without headlights after dark, a misdemeanor. The officer arrested Fillmore. Did the arrest violate Fillmore's Fourth Amendment rights? 61 words. Under New York law, a good faith purchaser for value cannot acquire valid title to stolen property. In 1939, Nazi troops stole the painting portrait of a woman from the Bronski family home in Poland. In 1956, Jane McConnell purchased the painting from a reputable New York gallery. McConnell died in 2002, leaving the painting to her daughter, Maeve. Does Maeve McConnell now have valid title to the painting as against the Bronski family heirs? 75 words. The First Amendment lets school districts regulate student speech only if the speech substantially disrupts school operations. McRae and Barnes were alone in a hallway of Eclipse Middle School. McRae asked to copy Barnes's homework. Barnes refused, and McRae threatened to hit him. A teacher in a nearby classroom overheard the threat and reported McRae, who was suspended. Can the school justify the suspension by asserting that bullying is always and inherently substantially disruptive? 74 words. Under Texas law, an attorney who has committed a crime of moral turpitude can be suspended from the practice of law. Phyllis Locke, a Texas attorney, was arrested for possession of illicit drugs. While her case was being investigated, but before she was prosecuted, much less convicted, the State Bar of Texas suspended her law license. Is an arrest without a conviction for a crime of moral turpitude sufficient to justify the suspension? 73 words. Leonard Slocum Jr., a mentally retarded minor whose father has physically abused him, has become the state's ward and begun a habilitation program that has helped him demonstrably. His father, Slocum Sr., petitioned to become Leonard Jr.'s guardian, but the court found him unfit because of the abuse and because he has sired 4 illegitimate children by a 25-year-old mentally retarded woman, formerly his ward. Did the court abuse its discretion? 73 words. 13. If you don't open with explicit issue statements, sum up the issues and your theme in a short introduction. Quotable quotes. Almost all reading matter in this country gets off to a false start. This is not an exaggeration, it is a statement of fact that I am going to prove. Let me first define my terms. What is a false start? It's a beginning that doesn't do what a beginning ought to do. Psychologists tell us that an effective piece of writing should start with something that points to its main theme. In other words, you must put your reader in the right frame of mind, you must start by getting him interested in what's going to come. Look around you and you'll find that most reading matter doesn't start that way. It usually starts in a routine fashion, with a stale, humdrum opening that does anything but whet your appetite for the main dish. Rudolf Flesch, The Art of Readable Writing 61, 1949, Reaper. 1967. The first thing that a certain Scots professor used to say to his students when they handed in their essays was, "Did it never occur to you to tear up the first page?" Without reading it, he could guess that it was bad, because beginnings are the most difficult things to manage successfully. It is there, said Chekhov, that we do most of our lying. Before we are properly warmed up, we run the risk of being flat and pedantic. André Mauroy, The Art of Writing 21-22, Gerard Hopkins Trans, 1962. Judges crave an immediate sense of overview. At the beginning of a brief, they are not interested in hearing all the details of the case. They want to know what kind of case this is and what issues the brief addresses. Ruggiero J. Aldizert, Winning on Appeal, Better Briefs and Oral Argument 182, 1992. A thesis statement that leaves readers in doubt about what the writer means will never change their views on an issue. For instance, the thesis that the federal government's farm policy must guarantee that economic aid to farmers will achieve desirable results will hardly change anyone's mind about farm subsidies since it is so vague that few people would disagree with it. A thesis such as, the federal government must subsidize small farmers to keep family farms from disappearing, is clear, precisely worded, and memorable. David I. Daniels and Barbara J. Daniels, Persuasive Writing 171, 1993. You can usually blame a bad essay on a bad beginning. If your essay falls apart, it probably has no primary idea, no thesis, to hold it together. What's the big idea? We used to ask. The phrase will serve as a reminder that you must find the big idea behind your several smaller thoughts and musings and drafts before you can start to shape your final essay. Thus your thesis is your essay's life and spirit. If it is sufficiently firm, it may tell you immediately how to organize your supporting material. But if you do not find a thesis, your essay will be a tour through the miscellaneous, replete with scaffolds and catwalks. We have just seen this, now let us turn to this, an essay with no vital idea. Sheridan Baker, The Practical Stylist 17-18, 8th ed. 1998. A good opener normally includes a good thesis, bold, fresh, clearly focused. And a good thesis tends to argue itself because it has a built-in thrust. John R. Trimble, Writing with Style 26, 2d ed. 2000. Explanation. Because issues are so very important, you shouldn't depend on a rule to tell you to put them up front. True, the better rules require them at the outset, as Rule 14 of the U.S. Supreme Court does, but many sets of rules, especially for trial courts, don't require them at all. And even on appeal, various state court rules merely require points relied on, or points of error. Even so, it's wise to open with an introduction, sometimes called a preliminary statement, setting out the deep issues. Most of your judicial readers, probably all, will be grateful. Some years ago, John Morris of New York opposed a plaintiff's motion to compel in a multi-party securities case. The motion began by citing Rule 26 and then droned on for 4 pages, listing every interrogatory number, every request for production, and every request for admission that was at issue against each defendant, information much better conveyed in a chart, see number 70. Even though Morris was opposing the motion, he pointed out that the opener could have been this: it has been a year since plaintiffs served their first discovery requests. None of the 15 defendants has produced a single document. Not all such opportunities are missed. Philip S. Beck of Chicago wrote a superb opening paragraph for the preliminary injunction brief in Amalgamated Sugar vs. NL Industries, in which his client Harold Simmons aka Amalgamated knocked out NL's poison pill and took over the company. Here's how the brief began. NL Industries is owned by its shareholders. The board of directors works for them. The shareholders want to sell their stock to Harold Simmons. The board won't let them. Though not always so succinctly, adept brief writers routinely provide a concrete overview. Examples A and B are by Stephen M. Shapiro of Chicago, the noted co-author of Supreme Court Practice. Although both of these openers come from briefs to the U.S. Supreme Court, they would fit well into briefs at any level. Notice how Shapiro begins with the larger context and moves quickly to a focused legal question. Example C is by Scott P. Stoley of Dallas. Notice again how his first sentence is a broad description, followed by a concise storyline that moves swiftly to the disputed point. A lesser brief writer would have been either much more vague in the factual narrative or else much more detailed and much slower in getting to the point. Examples D and E are by Stephen A. Hirsch of San Francisco, who begins with a startling aphorism or simile and then plunges into a well-worded summary of the argument. His openers are more expansive than examples A, B, and C. Example D comes from a brief to the California Court of Appeal, example E from a brief to the Board of Immigration Appeals in Falls Church, Virginia. After a dramatic start, they both carefully develop the points to be elaborated more thoroughly in the main body. 5 uncommonly good examples. Example A. Introduction. Like all other states, Pennsylvania requires funds to finance the construction, maintenance, and repair of its roads, bridges, and tunnels. Also like other states, Pennsylvania raises the funds largely through taxes and fees levied on the users of its highways. A substantial proportion of these taxes is paid by interstate motor carriers. Appellant American Trucking Associations, Inc. ATA, as their representative, has brought this suit not because of any objection to the raising of revenues by highway user charges or to the level of revenues Pennsylvania seeks to raise, but solely because the discriminatory nature of the 2 highway use taxes Pennsylvania has adopted, the marker fee and its successor, the axle tax, favors local interests at the expense of interstate commerce. Example B. Introduction. In their journey from the assembly line to the dealer's showroom, automobiles occasionally experience minor damage requiring repair or refinishing. The question then naturally arises whether, or in what circumstances, the fact of repair or refinishing should be disclosed to the dealer or to the retail purchaser of the automobile. By 1983, several states had answered this question by statute or regulation. BMW canvassed these laws and adopted the strictest disclosure threshold, 3% of the manufacturer's suggested retail price (MSRP), as its nationwide policy. Since that time, many other states have adopted disclosure thresholds. The vast majority, including Alabama, which enacted its statute after the trial in this case, require disclosure only if any repairs or refinishing cost more than 3% or some higher percentage of MSRP. See, e.g., ALA. Code Section 819522, the failure to give notice of repairs or refinishing costing less than 3% of MSRP is not an unfair trade practice and shall not constitute a material misrepresentation or omission of fact. In this case, a jury found that BM's 3% disclosure policy constituted fraud under Alabama common law. It then proceeded to award $4 million in punitive damages, later reduced by the Alabama Supreme Court to $2 million to plaintiff Drive. Ira Gore, not just for BMW's application of that policy to him but for its application of the policy to hundreds of cars sold outside Alabama, despite the absence of any showing that those sales were unlawful where they occurred. Example C. Introduction. Whedon Van Lines, Inc. appeals a $1.3 million judgment holding Whedon liable for an assault committed by Michael Mullinax, a third party over whom Whedon had no control. While working for a local mover, David Lux, Mullinax helped move appellee Kevin Mason to a new apartment in the same apartment complex. 11 days later, after being fired by Lux for stealing some of Mason's property, Mullinax assaulted Mason in Mason's apartment. The overarching issue is whether Whedon is liable for Mullinax's criminal conduct, when Whedon's only connection to Mullinax was a contract under which Lux sometimes acted as Whedon's agent for interstate moves. Example D. Introduction. No good deed goes unpunished. The reason Cellular One now finds itself defending against the harsh accusations made in this lawsuit is that in 1995, alone among Bay Area cellular providers, it voluntarily slashed cellular phone rates for customers with documented disabilities. Had Cellular One not initiated its groundbreaking, Enable Link, program, it would not now stand accused of deliberately preventing disabled customers from obtaining rate discounts. In this lawsuit, the plaintiffs allege that Cellular One failed to adequately inform some of its disabled customers that they might be eligible for Enable Link rate discounts. They further allege that Cellular One wrongfully discouraged plaintiff George Eckert and others from applying for the Enable Link plan by requiring them to obtain a physician's certification that misrepresented the plan's eligibility requirements. They also point to similar alleged misrepresentations in an advertising brochure for the program. What the complaint doesn't say is that this lawsuit represents an ambitious, but deeply flawed, attempt to take Business and Professions Code Section 17200 where it has never gone before. Other cases have held that Section 17,200 inches borrows the substantive provisions of other laws. Some have gone so far as to hold that Section 17,200 can add a private right of action to a statute that does not feature one. But no case ever has held that Section 17,200 allows a court to step into the shoes of a regulatory agency and promulgate regulations that the agency has declined to issue on its own. And no case ever should hold that, because it would violate the constitutional separation of powers and thrust courts into a policymaking role they are ill-equipped to handle. This case shows why. The statute plaintiffs rely on to provide a legal standard for their claim. Public Utilities Code (PUC), Section 2896(8) gives the Public Utilities Commission the power to impose disclosure requirements on telephone service providers. Plaintiffs claim that the Superior Court should bypass the Commission and do that job itself. In other words, plaintiffs want the Superior Court to issue a regulation telling Cellular One exactly what it must disclose to its customers about its special rate program for the disabled, and exactly how the disclosures must be made. Moreover, this court-created regulation would apply only to Cellular One, thus creating the anomalous situation where Cellular One would be the only provider in the state subject to regulation under Section 2896(a). This lawsuit therefore invites the Superior Court to simultaneously usurp legislative power by rewriting Section 2896(a) in a manner contrary to the legislative intent, and executive power by promulgating regulations within the exclusive jurisdiction of the Commission. So far, the Superior Court has declined the invitation. It sustained 2 successive demurrers, the second one against all remaining causes of action, without leave to amend. This appeal attempts to revive 2 claims pleaded in the second amended complaint. 1. The count for unlawful and unfair business practices under Business and Professions Code Section 17,200 et seq. And 2. The count for breach of contract styled as a tariff enforcement action. We will show that the trial court was right and that its judgment dismissing this lawsuit should be affirmed, for 4 independent reasons. First, a long line of case law holds that the Superior Court lacks jurisdiction over any civil suit against a regulated utility if that suit asks the court to make factual findings or to grant relief that would conflict with the Commission's orders, policies, or ongoing inquiries. That's exactly what would happen here. In orders issued in 1962 and 1996, the Commission occupied the field of customer service notification, spelling out exactly what disclosures a telephone company must make and exactly how to make them. In 1996, the Commission launched an ongoing inquiry into whether it should revise those orders in light of changes in technology and markets. The factual findings and relief sought here would conflict with these Commission actions. Accordingly, the Superior Court lacks any jurisdiction to consider the plaintiffs' claims. Second, the plaintiffs' Section 17,200 claim alleges that Cellular One breached duties that do not exist. Their theory is that Cellular One failed to meet disclosure requirements allegedly contained in PUC Section 2896(a). But that statute imposes duties only on the Commission. It imposes no duties whatsoever on Cellular One, and certainly not the duties that the plaintiffs claim Cellular One breached. Moreover, the legislative history also shows that Section 2896(a) never could have become law had it purported to grant directly enforceable rights to consumers, because the governor would have vetoed it. Lawmakers understood this, and drafted a bill enforceable only by the Commission, indeed, too vague to be enforced by anyone but the Commission. Third, plaintiff's Section 17,200 claim is really an end run around the state constitution's separation of powers clause, which prohibits courts from ordering agencies to promulgate specific regulations. Here, the plaintiffs seek relief that inevitably would require the Superior Court to specify the customer service disclosure obligations of California cellular service providers. Granting that order would violate the state constitution and thrust the Superior Court into a quasi-regulatory role that it is simply not equipped to perform. Fourth and finally, plaintiff's breach of contract claim fails as a matter of law because Eckert admits that he never applied for the Enable Link program. Accordingly, he never entered into any contract with Cellular One that could have entitled him to the plan's benefits. Here, again, plaintiffs allege the breach of non-existent duties. For all these reasons, this court should affirm the judgment below. Example E. Introduction. Kojatoriali Shujai is a bit like the cosmonauts who were stranded on the Mir space station when the Soviet Union collapsed. When they went up, they were from one sort of nation. When they came down, after a long delay, they belonged to a very different one. The difference is that Shujai cannot safely return to the land he once knew. During the 8 years that Shujai awaited this board's decision on his appeal from an adverse asylum ruling, his home country of Afghanistan was turned upside down. The Soviet-backed communist government fell. The country disintegrated into violence and brigandry as competing mujahideen groups vied for power while terrorizing the citizenry. A military force led by ethnic Tajiks, a minority to which Shujai belongs, took over the nation's capital in the northeast, gaining international recognition as the country's leaders even as rival warlords carved up the rest of the country. 2. Beginning in 1994, young peasant men attending primitive religious schools across the border in Pakistan began assembling themselves into a fighting force that vowed to take over all of Afghanistan, suppress the marauding mujahideen groups, and impose an ultra-orthodox brand of Islamic fundamentalism on the nation. Calling themselves the Taliban, or Students of Islam, they belonged to the dominant Pashtun ethnic group that had long ruled the nation. They made rapid inroads and by late 1996 had captured Kabul. Wherever they took power, they imposed an iron-fisted form of Islam that they believed would restore the social system that prevailed in the time of the Prophet. Other belief systems were crushed, people were forced to convert to Sunni Islam at knife point. 4, rival ethnic groups were massacred or forcibly displaced. 5, women were eliminated from public life and placed under virtual house arrest. 6, everyday life became heavily policed by self-appointed guardians of morality who used stonings, amputations, and severe beatings to enforce a myriad of rules governing everything from marital fidelity to the length of a man's beard to the amount of noise a woman's shoes should make when she walks. 7. But one obstacle remains to the Taliban's complete takeover of the country. In the Panjshir Valley northeast of Kabul, where Shujai hails from, his Tajik compatriots remain at war with the rapidly consolidating regime. Today, they comprise the last significant pocket of resistance to the Taliban. As a result, ethnic Tajiks like Shujai have been subjected to a campaign of killings, bombardments, forced relocations, detentions without cause, and outright warfare. Families have been divided and entire towns emptied and put to the torch. Not only is Shujai a member of the embattled ethnic group, but 2 of his brothers have actually fought for the Tajik forces. Just as his nation has changed, so has Shujai himself. He has now lived in the United States for almost a decade, has largely abandoned his religion, and has become a thoroughly secular and increasingly westernized man. Unschooled in Islamic religious practice because his limited education was cut short by war and a war-related head injury, and overtly hostile to the Taliban's beliefs and social program, Shujai will be a marked man if forced to return to Afghanistan. This unreligious man from an embattled ethnic group, who has spent a decade living in the United States, has much to fear upon return to his homeland. He has, in short, a well-founded fear of persecution. For reasons discussed more fully below, we respectfully urge this board to reopen Shujai's asylum proceedings to consider all of the evidence set forth here, evidence concerning a brutal, cultish regime that did not even exist when the immigration judge denied Shujai asylum in 1991. We note that the board has previously held that the Taliban's emergence represents a change in country conditions that merits a reopening or remand of asylum and withholding proceedings. 8. Alternatively, we ask that the board suspend Shujai's deportation on humanitarian grounds under 8 U.S.C. Section 1254(8)(1). 14. Highlight the reasons for the conclusion you're urging. Quotable quotes. For the writer of argumentation, the because clause is apt to be the most difficult element of the whole thesis statement. If the thesis is a good one, it is apt to seem to the writer his ultimate statement upon the subject. To find a because clause for that thesis, he must go beyond the ultimate statement. But the step must be taken, he must find the reason that will link him to his audience and make it possible for them to accept the thesis itself. The because clause is not an irrational requirement the instructor has invented to make writing difficult, it is an essential connection that makes communication persuasive. William J. Brandt et al. The Craft of Writing 20, 1969. One of the temptations you will face in persuasive writing, especially if the subject is one you feel strongly about, is to keep repeating your opinion in different words instead of supporting it. Resist that temptation. Remember that you are trying to persuade your readers, not just impress them with your sincerity. And to persuade them, you have to offer them sound reasons for believing as you do. James F. Dorrell and Charles W. Harwell, Read and Write. A Guide to Effective Composition 284-85, 1987. Any argument is only as convincing as the reasons that support it. No matter how right you think you are, you have to make your readers agree. And before readers will change their minds, they need to know why. They expect you to complete a version of this statement. My position is, blank, because, blank. Your reasons follow the, because. John M. Lannon, The Writing Process 310-11, 1989. Explanation. If you follow the advice in the preceding tips, writing your conclusion, your statement of what you want the court to do, should be straightforward. It will be the answer to the question posed by your issue. But when you omit the reason for your conclusion, it appears almost as if you're hiding something. When you give a good reason, on the other hand, you're more likely to seem both thoughtful and sensible. In short, you're more persuasive. This tip is key to both your opening words and your closing words. Succinctly tell the court why it should do what you ask. You'd be well served to follow the Lannan formula quoted above, except invert it, because, blank, my position is blank. By doing that, you'll move your brief to the top of the stack in terms of clarity and persuasiveness. Why? Because an appallingly large number of briefs in this country don't clearly state why the court should do what the brief writer asks. Think of all the briefs you've seen that can be boiled down to something like, Proposition 1. Citation, Proposition 2, Citation, Proposition 3, Citation, for the foregoing reasons, judgment should be entered for the plaintiff. Or, if a brief does mention reasons, they're often buried somewhere in the middle of a long, jumbled paragraph. Notice how effectively the examples below highlight the reasons for the conclusion stated. Example A is my revision of a motion to quash. Example B is by Patricia Villarreal of Dallas. In her brief, she clarified a difficult problem. Notice especially the bulleted points in which her opener culminates. Two uncommonly good examples. Example A. Corinth's motion to quash. Subpoena duces tecum. This court should quash Van Helden's subpoena duces tecum for 3 reasons. The request seeks the personnel files of Corinth's sales and marketing managers, information that is highly confidential and irrelevant to Van Helden's claims. The discovery deadline has long since passed, and Van Helden never asked for these materials in discovery. Even if Corinth complied with these improper requests, Van Helden would be precluded from using the materials at trial because they aren't included in this court's pretrial order regarding exhibits. For these reasons, Corinth moves this court for an order quashing Van Helden's subpoena. Respectfully submitted. Memorandum in support follows. Example B. No. 9105637F. Image. Highlands. Motion for partial summary judgment. Introduction. In a 5-year overhaul of a broken workers' compensation system, the Texas legislature in 1993 created a statutory safe harbor for any pass-throughs of assigned risk pool deficit assessments. The legislature's judgment was that pass-throughs should be deemed valid if consistent with the statute's purpose and if the resulting premium was less than the rejected risk fund premium. The legislature gave this blanket approval to all pass-throughs except those challenged in a civil proceeding pending on May 1, 1993. If there were no civil proceeding pending against Highlands on May 1, 1993, has the Texas legislature preempted the claims McCoy Tree Surgery asserts here against Highlands? Highlands contends the answer must be yes. Hence, Highlands moves for partial summary judgment on McCoy Tree's claims for any pass-throughs of deficit assessments because Section 4.04Q expressly authorizes any such assessments. Highlands, motion for partial summary judgment, page 1. The pass-through allowances authorized in Sections D and E hereof shall be deemed exclusive subsequent to the effective date of this article, but other methods utilized prior to such effective date shall be deemed valid if consistent with the purpose of this article and the premium resulting from their use is less than the premium which would have been charged for a similarly rated risk in the rejected risk fund. The legislature wholly removed the question of validity of the pass-throughs from the scrutiny of courts or regulators, with one carefully circumscribed exception. The validation made by this amendment shall govern any civil or regulatory proceeding except a civil proceeding pending in a court of competent jurisdiction on May 1, 1993, including civil proceedings filed on or before May 1, 1993, which are seeking class action status, whether or not the plaintiff or defendant classes have been certified. That exception does not apply to Highlands because, on May 1, 1993, Highlands was not named a defendant in Weatherford. The Weatherford defendant class allegations, insufficient in any event to connect Highlands to this proceeding on May 1, 1993, were voluntarily dismissed by plaintiffs, extinguishing any claim against unnamed defendants as if it had never existed. On May 1, 1993, no named plaintiff in Weatherford had a contractual relationship with Highlands or standing to assert a claim against Highlands. On May 1, 1993, the Weatherford named plaintiffs, without the defendant class allegations, only assert claims against the named defendants. McCoy Tree owes Highlands more than twice the amount of damages it seeks. Highlands, motion for partial summary judgment should be granted. Highlands, motion for partial summary judgment, page 2. 15. Make your points as simple as possible, but no simpler. Quotable quotes. When a thought is too weak to be expressed simply, it should be rejected. Luke, Marquis de Vauvenargues, Reflations et Maximes No. 3, 1746. Order and simplification are the first steps toward the mastery of a subject. Thomas Mann, The Magic Mountain ch. 5, 1924. The desire for simplification is a perennial weakness of the human mind, even the mind of judges. Sir Wilfrid Green M.R., The Judicial Office 12, 1938. If you know something you can state it clearly. If you have not mastered the thought you are not yet in a position to pass it on to others, although sketching a rough draft for your own further analysis often proves useful. George J. Miller, On Legal Style, 43 KY. L.J. 235, 241, 1955. A simple, clear, and harmonious style does not come easily. It is the product of much mental sweat and a critical evaluation of first efforts. Sumner Ives, A New Handbook for Writers 275 1960. I prefer the risk of oversimplification to even a whisper of unnecessary complexity. John C. Godbold, 20 pages and 20 minutes, Effective Advocacy on Appeal, 30 SW. L.J. 801, 801 1976. The kind of writing instruction most of us have gotten in school is exactly the reverse of what we need. Instead of teaching us how to communicate as clearly as possible, our schooling in English teaches us how to fog things up. It even implants a fear that if we don't make our writing complicated enough, we'll be considered uneducated. John L. Beckley, The Power of Little Words 8, 1984. A lawyer should write the brief at a level a 12th grader could understand. That's a good rule of thumb. It also aids the writer. Working hard to make a brief simple is extremely rewarding because it helps a lawyer to understand the issue. At the same time, it scores points with the court. William Bablich, as quoted in Mark Rusk, Mistakes to Avoid on Appeal. Abba J., September 1988, at 78, 80. Simple arguments are winning arguments, convoluted arguments are sleeping pills on paper. Alex Kaczynski, How You Too Can Lose Your Appeal, 23. Montana Law, 5, 6 October. 1997. Explanation. This tip itself is a paraphrase of a quotable quote, one by Albert Einstein: everything should be made as simple as possible but not simpler. Asterisk. As you'll soon see, simplicity can be achieved by following many of the other tips in this book, striving for shorter sentences, preferring the active voice, breaking up the text with headings, and so on. But perhaps the more important way to achieve simplicity is to think through the issues fully. You'll know you have mastered your points when you can explain them to a non-lawyer in ordinary language. Of course, that same explanation shouldn't be oversimplified. You can test it on a reasonable colleague, and you probably should. But remember that any old mediocre mind can make things complex. Your quest is for simplicity. A before and after example. Before final section in a response to a motion for new trial. Plaintiff's final point of attack in the timely filed motion for new trial is simply the argument that Barkley's presence at trial would have been detrimental to his defense and particularly to the defense of the other insured, 4-star delivery, and proffers as supporting evidence the fact that separate counsel would have been hired for Barkley due to a conflict of interest between Barkley and 4-star delivery. Plaintiff references evidence of Barkley's seizure disorder which came out after the underlying trial and which is not before this court in any fashion and argues that Barkley would have hurt his own defense and 4-star delivery would have had a more difficult time avoiding the cause of action of negligent entrustment. None of this one-sided speculation is relevant to the issues before this court. Plaintiff proffers no evidence to support this speculation. Defense counsel in this case could make similar irrelevant arguments that had Barkley been present and explained his seizure disorder, the defense of unavoidable accident would have been established and, therefore, not ignored by the jury as it was in the case that was tried, or that Barkley's counsel could have brought in Barkley's physician as a third-party defendant and maybe avoided liability. What might or might not have happened, or what might or might not have been successful strategy, is far outside the purview of what is before this court in addressing a motion for new trial on defendant's motion for summary judgment. 249 words. After finally, Hutchins argues that Barkley's presence at trial would have hurt both his defense and 4 stars. Hutchins speculates that their defenses would have become harder because Barkley, having a conflict of interest with 4-star, would have been represented by separate counsel. Hutchins further speculates that Barkley's seizure disorder, which is not in the record, would not only have hurt Barkley but also have made it more difficult for 4-star to defeat the claim of negligent entrustment. Defendants could likewise speculate self-servingly about the effect of Barkley's presence, but none of this one-sided, unsupported speculation bears on the issues. What might or might not have happened should not affect this court in deciding to deny Hutchins a new trial. 123 words. Part C. Marching forward through sound paragraphs. 16. Begin a paragraph with a topic. Sentence. Don't end the preceding paragraph with what should be the next paragraph's topic sentence. Quotable quotes. It is customary to indicate the unity of the paragraph, the special nature of the thought it contains, by means of a topic sentence. Although it may occupy any position in the paragraph, and indeed is sometimes omitted altogether, in most paragraphs the topic sentence is placed at the beginning because this is ordinarily its logical place. Norman Forster and J.M. Stedman Jr., Writing and Thinking 43, James B. Macmillan ed. 5th ed. 1952. There are few things more boring than a 20 or 30-page paper consisting of page after page of case discussion in which each paragraph begins, in A verses. B, in C verses. D, in E verses. F. By the third one, the reader feels like saying, who cares? Add a little zip to these paragraphs by a strong lead-in sentence. Use the opening line to give the reader some clue about what's interesting or whatever about the case. In other words, what's the point of discussing the case? Tell your reader as you open your discussion of it. Then he or she will work along with you to make the point. Paula Samuelson, Good Legal Writing, of Orwell and Window Panes. 46 U. Pitt, L. Rev. 149, 159, 1984. A topic sentence lets readers know the focus of a paragraph in simple and direct terms. Because paragraphing usually signals a shift in focus, readers expect some kind of reorientation in the opening sentence. They need to know whether the new paragraph is going to introduce another aspect of the topic or develop one already introduced. This need is especially strong when readers are under pressure to read quickly and efficiently. Rise B. Axelrod and Charles R. Cooper, The Saint, Martin's Guide to Writing 354, 1985. Because the topic sentence, with its controlling idea, is a serviceable guide for achieving unity in the paragraph, you should place it first. Then, as you write, keep it clearly in mind. Allow it to control what you include and exclude. The topic sentence is your general frame of reference, the controlling idea is your specific focus. John Ostrom and William Cook, Paragraph Writing Simplified 9, 1993. Paragraphing is a subtle but important element in writing nonfiction, a roadmap constantly telling your reader how you have organized your ideas. Study good nonfiction writers to see how they do it. You'll find that most of them think in paragraph units, not sentence units. Each paragraph has its own integrity of content and is rounded off to serve as both an end and a springboard to what's coming next. William Zinsser, On Writing Well 128 5th ed. 1994. Explanation. A good topic sentence, usually the first in the paragraph, centers the paragraph. It announces what the paragraph is about, and the other sentences play supporting roles. Oddly, though, legal writers frequently make the last sentence in a paragraph what should be the topic sentence in the next paragraph. You see this problem in example A corrected, of course, in the revised version. Example B illustrates a different problem. The first sentence in the second paragraph really should be the final sentence in the preceding one. Why? Because it doesn't really announce the point being developed in the paragraph it begins. It's implicitly a four-part statement, but it opens a paragraph that develops only one of the 4 points. Also, the fourth paragraph Messrs. Nisbet and Morgenthau lacks a topic sentence. For ease of reference in seeing the improvements made, the topic sentences are marked in boldface. Some before and after examples. Example A. Before the attorney-client privilege protects confidential communications between a client and the client's lawyer. Cal. EVID, Code Section 954. Generally, a communication to a third party, i.e., someone other than the client or the client's lawyer, is not privileged. See Cal. EVID, Code Section 952, Veer Brick vs. Luby, 67 Cal. App. 2D 842, 844, 1945. However, Evidence Code Section 952, defining a confidential communication between client and lawyer, specifies 3 exceptions to the general rule. See Cal. EVID, Code Section 952. The first exception is where the third party is present to further the interest of the client in consultation. Cal. EVID, Code Section 952. The second exception applies when the third party is one to whom disclosure is reasonably necessary to transmit the information. ID. The third exception applies when a lawyer must disclose information to a third party to accomplish the purpose for which the lawyer is consulted. ID. After the attorney-client privilege protects confidential communications between a client and the client's lawyer. Cal. EVID, Code Section 954. Generally, a communication to a third party, i.e., someone other than the client or the client's lawyer, is not privileged. See Cal. EVID, Code Section 952, Veer Brick vs. Luby, 67 Cal. App. 2D 842, 844, 1945. But the Evidence Code specifies 3 exceptions to the general rule, each establishing when a third-party communication is privileged. See Cal. EVID, Code Section 952. The first exception applies when the third party is present to further the interest of the client in consultation. ID. The second exception applies when the third party is one to whom disclosure is reasonably necessary to transmit the information. ID. The third exception applies when a lawyer must disclose information to a third party to accomplish the purpose for which the lawyer is consulted. ID. Example B. Before to be reliable, scientific testimony must be grounded in the scientific method and must constitute more than subjective belief or unsupported speculation. Daubert, 509 U.S. at 589-90. Factors bearing on reliability include 1. Whether the theory can be tested, 2. Whether the theory has been subjected to peer review and publication, 3. The known or potential rate of error, and 4. To some extent, general acceptance in the field. ID. At 593. Burgess's opinion testimony about the Moores House met the standard for admissibility. First, Messrs. Nisbet and Morgenthau are qualified. They both have master's degrees in engineering and are registered professional engineers with experience in examining house foundations. SF 808-10, 1007-10. Even Mr. Moore agreed that they are competent engineers. SF 741-46. Second, their opinion was based in part on a reliable study. Specifically, they relied on the study by the University of Tennessee engineering faculty, reporting on actual tests and observations of many house foundations. SF 836-37. One of the Moore's engineers, Fred Hayden, agreed that the Tennessee report is considered reliable. SF 509-10. Another of the Moore's engineers testified that the Tennessee staff has done extensive work on this subject. SF 941. Even if the Tennessee study was inadmissible, Burgess was entitled to rely on it because the record shows that the report is of the type reasonably relied on by experts in the field. SF 509-10. Messrs. Nisbet and Morgenthau also relied on their inspection of the Moore's house. And contrary to the Moore's assertion, they did examine later developed information, including the data concerning the size and location of the leak and the moisture content of the soil borings. SF 764, 816-17, 1015-16. They even wrote supplemental reports about their additional investigative efforts. PX 25, DX 14. Moreover, like any experts, they relied on their general expertise and experience in the field. Before forming its general opinion, Burgess even went so far as to consult with engineers in academia. SF 813, 833. Finally, Burgess's opinion met the last criterion, that the opinion be relevant to the case. Burgess's opinion was germane to a dispositive issue, whether the Moores suffered foundation damage due to an accidental leak from their plumbing system. Thus, having met all the criteria, Burgess's opinion was admissible. After to be reliable, scientific testimony must be grounded in the scientific method and must constitute more than subjective belief or unsupported speculation. Daubert, 509 U.S. at 589-90. Among the factors bearing on reliability are whether the theory can be tested, whether the theory has been subjected to peer review and publication, the known or potential rate of error, and general acceptance in the field. ID. At 593. The testimony of Burgess's two experts met the standard of reliability. 4 points demonstrate this. First, both Mr. Nisbet and Mr. Morgenthau are qualified. They both have master's degrees in engineering and are registered professional engineers with experience in examining house foundations. SF 808-10, 1007-10. Even Mr. Moore agreed that they are competent engineers. SF 741-46. Second, their opinion was based in part on a reliable study. Specifically, they relied on the study by the University of Tennessee engineering faculty, reporting on actual tests and observations of many house foundations. SF 836-37. One of the Moore's engineers, Fred Hayden, agreed that the Tennessee report is considered reliable. SF 509-10. Another of the Moore's engineers testified that the Tennessee staff has done extensive work on this subject. SF 941. Even if the Tennessee study was inadmissible, Nisbet and Morgenthau were justified in relying on it because it's the type reasonably relied on by experts in the field. SF 509-10. Third, Nisbet and Morgenthau double-checked their work in two ways. One, they continued examining data after inspecting the grounds, and two, they sought second opinions within academia. On the first of these points, they relied not only on their own inspections of the Moore's house, but also on later developed information. For example, they examined data concerning the size and location of the leak and the moisture content of the soil borings. SF 764, 816-17, 1015-16. They even wrote supplemental reports about their additional investigative efforts. PX 25, DX 14. On the second point, they went beyond relying on their own general expertise and experience in the field. Before forming its general opinion, Burgess even went so far as to consult with engineers in academia. SF 813, 833. Fourth, Nisbet's and Morgenthau's opinions amply met the last criterion, that the opinion be relevant to the case. Their opinions were germane to a dispositive issue, whether the Moores suffered foundation damage due to an accidental leak from their plumbing system. Thus, having met all the criteria, Burgess's opinion was admissible. 17. Bridge from one paragraph to another. Quotable quotes. A.S. sentences should follow one another in harmonious sequence, so the paragraphs must fit onto one another like the automatic couplings of railway carriages. Winston Churchill, My Early Life, A Roving Commission 211-12, 1930. The topic sentence smooths the way from paragraph to paragraph by binding that which has been said to that which is going to be said. By hooking the previous series of ideas to the coming one, it provides momentum. Sherman Kent, Writing History 61, 1941. Just as transitions can help the reader glide from sentence to sentence within a paragraph, so they can help him or her step easily from paragraph to paragraph. In the usual case, transitions come at the beginning of the paragraph, referring to the thought in the preceding passage and connecting it with the group of sentences to follow. But transitions between paragraphs are usually stronger and longer than transitions and conjunctions between sentences. For one thing, a paragraph presents a new idea or aspect of an idea. For another, it takes the reader longer to find out for himself or herself whether the relationship is one of contrast, amplification, emphasis, or some other nature, whereas in the case of sentences, if there is any doubt, a flick of the eye is all that is needed. David W. Ewing, Writing for Results in Business, Government, the Sciences and the Professions 222d ed. 1979. If you can't find some way to connect the ideas developed in one paragraph to those being developed in the one that follows, it is likely that you have left out some component of the argument. Paula Samuelson, Good Legal Writing, of Orwell and Window Panes, 46U. Pitt, L. Rev. 149, 159, 1984. Transitions between paragraphs connect the unifying idea of one paragraph with the unifying idea of the next. Paragraphs should not be presented as separate from each other. Writers need to link these parts to each other into the thesis. Jean F. Campanelli and Jonathan L. Price, Write in Time 107, 1991. Each topic sentence must somehow hook onto the paragraph above it, must include some word or phrase to ease the reader's path, a transition. One brief transitional touch in your topic sentence, your opening sentence, is usually sufficient. Sheridan Baker, The Practical Stylist 42, 8th ed. 1998. Explanation. Although it's true that a paragraph should generally have a topic sentence, the more important point, a little-known one, is that it should have a bridge. Ideally, every paragraph beginning with the second should connect with the paragraph immediately preceding it, and it should do so explicitly. That's how you create fluent prose, in which the ideas are closely connected. That's how you write a brief that marches forward from one point to the next. In creating bridges to achieve that effect, you have three options. Pointing words this, that, these, those because they point to something immediately preceding. Echo links, which are words that repeat an idea in summary language or otherwise reverberate from what has just preceded. Explicit connectives further, moreover, in addition, likewise, in sum, etc., which are obvious transitional words. Masterly writers use all three devices to establish a continuity from paragraph to paragraph. In the example that follows, David Fernandez of Newark uses bridges so well that they even work with and through the headings. The result is an unusually tight and readable brief. An unusually good example. Argument. 1. The motion should be denied because the PUC was not a party to the Essex County litigation. The two matters involve wholly separate facts. The PUC has never raised bidding deficiencies as a defense in this lawsuit, and, in any event, the PUC has waived the right to raise that defense now, on remand. Judicial estoppel does not entitle the PUC to summary judgment for a variety of reasons, all rooted in unequivocal case law and simple common sense. First, the PUC had no involvement in the Essex County matter and therefore has no standing to assert judicial estoppel here. Second, Roberts cannot be estopped on the basis of positions it took in the Essex County litigation since that matter arose from completely separate facts. Third, Roberts has never expressed any opinion on whether the local public bidding law applies to the Roberts-PUC contract, and thus has not taken inconsistent positions on this question. And, finally, the PUC long ago waived its right to assert this defense in this litigation. For all these reasons, the court should deny the motion. A. The court should deny the motion because the PUC was not a party to the Essex County litigation, nor was it in privity with a party in that case. Judicial estoppel prevents parties from assuming inconsistent or mutually contradictory positions with respect to the same matter in the same or a successive series of suits. Scarano vs. Central R.R. Company, 203 F2D 510, 513 3 DCIR. 1953. Unlike equitable estoppel, which concerns the relationship between the parties, judicial estoppel looks to the connection between the litigant and the judicial system. Oneida Motor Freight, Inc. vs. United Jersey Bank, 848 F2D 414, 419 3 DCIR, cert. Denied, 488 U.S. 967, 1988. The central purpose of judicial estoppel is to preserve the integrity of the judicial system, by preventing parties from playing fast and loose with the courts. Fleck vs. KDI Sylvan Pools, Inc., 981 F2D 107, 121 3 DCIR 1992, citations omitted, cert. Denied sub nom. Doughboy Recreational, Inc., Div. of Hoffinger Eind, Inc. vs. Fleck, 507 U.S. 1005 1993. At least one important boundary limits this doctrine in a way that is dispositive here. Simply put, a party may not assert judicial estoppel if he had no involvement in the earlier matter. The Third Circuit has held that judicial estoppel is appropriate only where the same parties are involved. Gleason vs. United States, 458 F2D 171, 175 3 DCIR. 1972. This limitation arises from the Third Circuit's earliest and most significant cases on judicial estoppel. In the seminal Scarano case, for example, the Third Circuit built this important limitation into the basic rule itself. A plaintiff who successfully asserts a position in one case may not contradict himself, in an effort to establish against the same adversary a second claim inconsistent with his earlier contention. 203 F2D at 513 emphasis added. The Western District of Pennsylvania, speaking through Judge D. Brooks Valentino, recently reaffirmed this limitation in the recent case of Mellon Bank, N.A.V. Makarov, 153 BR. 155 WD. Pa. 1993. In that bankruptcy case, a debtor argued in an adversary proceeding brought against a business partner that an agreement structured as an employment contract was actually for the sale of assets, entitling him to a full payout. The debtor received $124,000 in settlement of this action, but promptly found himself defending against the Mellon Bank's efforts to collect these funds under a security agreement covering the debtor's business proceeds. The bank argued that the debtor could not deny that these funds were for the sale of assets, given the debtor's position in the earlier action against the business partner. On appeal from the bankruptcy court, Judge Valentino held that the debtor was free to oppose the bank's efforts to collect these proceeds because judicial estoppel did not apply. In reaching this decision, Judge Valentino held that judicial estoppel does not empower a litigant to hold an adversary to a previous position unless that litigant played some role in the earlier action. This circuit has endorsed a restrictive approach to judicial estoppel which allows judicial estoppel to be invoked only by a party to the prior proceeding or someone in privity with that party. Accordingly, although C&J Travel, the adversary in the earlier matter, might in the appropriate case be able to invoke judicial estoppel, Mellon cannot. ID. At 158-59 citations omitted. If judicial estoppel is limited in the way that Judge Valentino held in Mellon Bank, then the upshot for the PUC is clear. It may not attempt to hold Roberts to positions Roberts took in the Essex County matter. The PUC played no role in the Essex County litigation. It was not a party to that case. It was not in privity with any party to that case. It made no appearances in that case. The PUC's only connection with the ECUA litigation, in fact, is that these two entities share the same attorneys, a circumstance that certainly explains the origins of this motion but does not create a sufficient connection to assert judicial estoppel here. In short, because the PUC was neither a party to nor in privity with a party to the Essex County matter, the PUC may not invoke judicial estoppel. B. The motion should be denied because the two litigation matters involve wholly unrelated facts. A larger and more serious flaw in the PUC's position is that it would radically expand judicial estoppel far beyond its accepted contours. The PUC is attempting to capitalize on a legal position Roberts took in the ECUA litigation in order to restrict the legal positions Roberts may articulate here. Setting aside for the moment the obvious fact that Roberts has never taken any position in this litigation on the issue of public bidding, the central weakness with the PUC's argument is that these two lawsuits arise from completely separate facts. This litigation involves Roberts' claim that the PUC breached a long-term disposal contract that Roberts and the PUC entered into in 1987. The Essex County lawsuit, by contrast, involved a contract that the ECUA and Waste Management entered into in 1994. These lawsuits thus involve separate contracts, awarded to different entities, at different times, and by different government agencies. There is, in short, no factual overlap between these two cases. The Puck nevertheless suggests that judicial estoppel applies, even though these lawsuits are factually unrelated. The Puck does this by quoting out of context from the Oneida Motor Freight case, in which the court articulated the rule broadly, as follows: judicial estoppel applies to preclude a party from assuming a position in a legal proceeding inconsistent with one previously asserted. 848 F2D at 419 quoted at page 12 of PUC's BRF. The Puck does not bother to observe, of course, that the Oneida case involved legal positions taken in two lawsuits arising from the identical facts. The Puck forges ahead anyway, making the enormous leap from this isolated expression of the rule to the breathtaking proposition that judicial estoppel applies to positions taken in completely unrelated lawsuits. Puck BRF, at 14-16. This theory of judicial estoppel is flat wrong. The Puck has furnished no authority for the extraordinary proposition that litigants are encumbered by the legal positions they took in earlier, factually unconnected cases. To the contrary, this doctrine only prevents litigants from taking inconsistent positions in the same litigation or in successive cases arising from the same core set of facts. See Himmel vs. Continental Ill, Natal Bank and Trust Company, 596 F2D 205, 210 7th CIR 1979, rejecting judicial estoppel argument on the grounds that the facts here are not the same facts in the first suit, citation omitted. As one court recently observed, in order for a litigant to assert judicial estoppel, the facts at issue should be the same in both cases. Levinson vs. United States, 969 F2D 260, 264 7th CIR, cert. Denied, 506 U.S. 989 1992. The Puck proves this point in its own brief. Not only does the Puck fail to furnish a single case holding that judicial estoppel applies across factually unrelated lawsuits, but every case it relies on involves two lawsuits arising from the same facts. In some of these cases, a litigant asserts judicial estoppel to prevent an adversary from taking diametrically opposite factual positions in two matters arising from the same factual scenario. For example, in Lewandowski vs. Natal RR, Passenger Corp., Amtrak, the court barred a former railroad employee from claiming in a reinstatement lawsuit that he was physically fit, because in an earlier lawsuit against the railroad, the plaintiff claimed that he had suffered injuries that rendered him incapable of working. 882 F2D 815, 819 3 DCIR. 1989. In other cases, as the Puck points out, the courts have used judicial estoppel to prohibit contradictory legal positions as well. Puck BRF, at 13. But these cases, too, all involve positions advanced in the same lawsuit, or in successive lawsuits arising from the same facts. A classic example of this is Levin vs. Robinson, Wayne and LaSala, in which a lawyer claimed in his divorce action that his partnership agreement entitled him to a certain distribution, but then took the position in a later lawsuit against his law firm that the same agreement entitled him to a higher amount. 246 NJ. Super. 167 Law Div. 1990. The court held that judicial estoppel barred the plaintiff from asserting such diametrically opposite readings of the identical agreement. The PUC's overbroad theory of judicial estoppel not only contradicts settled case law, it also lacks common sense. The Puck argues that Roberts may not sue for breach because of a legal position that it took in a lawsuit arising from wholly separate facts. But imagine the consequences of holding litigants to legal positions successfully taken in earlier, unrelated matters. By the PUC's logic, a litigant would be stuck, presumably forever, with whatever legal positions he or she successfully asserts in any single case. Not only would a litigant's claim or defense depend on legal consistency within a lawsuit, but it would now depend on legal consistency across all other lawsuits in which that litigant or anyone in privity with that litigant ever successfully participated. Indeed, if the Puck is correct, then Roberts is entitled to rifle through the PUC's own litigation history, catalog all legal positions the Puck has ever successfully advanced, and hold the Puck to those positions in this lawsuit. Surely the Puck does not believe that positions of law it has taken in other unrelated lawsuits hamper its ability to take legal positions in this case. The case law provides no support for such a radical transformation of the doctrine of judicial estoppel. The courts in this circuit have consistently adopted a restrictive approach to judicial estoppel, reminding litigants that this doctrine is meant to apply only when contradictory positions taken in the same or related matters threaten the integrity of the court. Mellon Bank, 153 BR at 158, Simcar Lighting Fixture Company vs. Genlight, Inc., 906 F. Sup. 967, 975 DNJ. 1995. In the absence of any authority that taking inconsistent legal positions in factually unconnected matters threaten the integrity of the court, the court should reject this motion. C. Roberts has not taken any position in this litigation on whether the local public bidding law applies to the Roberts-Puck contract. The court should deny the PUC's motion for yet another important reason. For judicial estoppel to apply, the two offending positions must truly be diametrically opposed. Unum Corp. vs. United States, 886 F. Sup. 150, 159 D. Me. 1995, quoting United States vs. Levasseur, 846 F2D 786, 794 1st CIR, cert. Denied, 488 U.S. 894, 1988. If there is any way to reconcile the two positions, judicial estoppel does not warrant summary judgment. C. Levinson, 969 F2D at 264. In order for judicial estoppel to apply, the later position must be clearly inconsistent with the earlier position. Here, the Puck claims that Roberts has taken contradictory positions on whether New Jersey law requires long-term disposal contracts to be publicly bid. But one will search the pleadings, the briefs, and, indeed, the entire record in this case in vain for any mention of this issue anywhere, by either Roberts or the PUC. Roberts has never raised this issue because the PUC has never asserted it as a defense. And one can certainly understand the PUC's reluctance to raise it. The PUC, after all, took full advantage of the Roberts contract for almost 6 years. Then, when it was convenient to do so, the PUC replaced that agreement with a cheaper Empire contract that it also awarded without public bidding. Hence, attacking the manner in which it awarded this contract to Roberts would have the embarrassing result of asserting that the Empire contract, too, is void for illegality. More broadly, the PUC cannot bring itself to assert this defense because by doing so it would be expressly stating in a forum open to full public scrutiny that it is legally obligated to publicly bid all such contracts in the future. Apparently the PUC wishes to refrain from making such a statement in this setting. Whatever the reason for the PUC's skittishness, the blunt truth is that the PUC has never asserted that it ought to have publicly bid the Roberts contract. As a result, Roberts has never once taken any position on this issue. Because the PUC cannot point to 2 instances in which Roberts has taken a position on whether contracts of this kind should be publicly bid, much less that these 2 positions are diametrically opposed, judicial estoppel does not apply. Unum Corp. 886 F. Sup. At 159. The PUC's response to this state of affairs is to strike a precarious, even disingenuous, legal posture. Although the PUC cannot bring itself to assert illegality as a defense, it argues that Roberts is stopped from denying that the contract it seeks to enforce here is void for illegality. PUC BRF. At 1 emphasis added. Clever though it may be, this argument begs the question of how a party can deny a defense that the other party has never asserted. Even if it were true that Roberts may not deny that the Roberts PUC contract is void for illegality, doesn't the PUC have to affirmatively maintain that the contract is illegal before Roberts can be prevented from opposing that defense? More to the point, even if the PUC attempted to assert this defense, Roberts would be free to oppose it without fear of contradicting its position in the ECUA litigation. If the PUC were to advance this defense now, Roberts' position would be simple. By failing until now to complain even once about the manner in which it awarded the contract to Roberts, the PUC either waived this defense or is stopped from asserting it. See section ID, infra. This argument is not diametrically opposed to anything Roberts stated in the ECUA matter. For in the ECUA matter, Roberts took a position on the merits of the public bidding issue. Here, Roberts' position would enable the court to dispose of the PUC's defense without reaching the merits. In this way, there is no threat that the court's conclusion here would in any way conflict with the conclusion reached by the court in the ECUA lawsuit. In short, permitting Roberts to proceed in this litigation does not threaten the integrity of the courts. As a result, judicial estoppel does not prevent Roberts from advancing its claim for breach of contract. See Lynn and Fay Conster, Company vs. Housingoff of Camden, 49 F3D 915, 933 3D CIR. 1995, 18. Connect your sentences smoothly to one another. Avoid bumps in the prose. Quotable quotes. One aspect of organization that seems to have eluded practically all graduate students is that involved in the making of transitions. Even those who have been taught how to lay beads in a row have not been taught how to string them. The ability to move from one sentence or paragraph or chapter to the next, in such a way as to blend them into a unified whole, is largely dependent upon an understanding of the reasons for going from one to the next. Wendell Johnson, You Can't Write Writing, in 20th Century English 229, 235-36 William S. Knickerbocker ed. 1946. A first draft is rather like a road under construction. A reader, like a motorist, would have to go slow and watch for obstructions. A writer, like a builder, must smooth out the bumps and fill in the holes. Sumner Ives, A New Handbook for Writers 275 1960. In whatever paragraphs you write, verify the sequence of ideas and take out or transpose everything that interrupts the march of thought and feeling. Jacques Barzin, Simple and Direct 176 1975. One of the differences between inexperienced writers and mature writers is that mature writers know how to make connections between ideas. Inexperienced writers have lots of ideas, but they jot them down as independent units, sometimes single sentences that, like items on the evening news, have little to do with what comes before and after them. Sometimes, in fact, inexperienced writers make an assertion in one sentence and contradict it in the next. James C. Raymond, Writing as an Unnatural Act 112 1980. Transition is the technique of drawing sentences together, dovetailing them, making them overlap so that the reader's journey from one sentence to the next is not a series of jerks and lunges but a smooth ride. Thomas Wisson, Away with Words 111 1982. Experienced readers are on the lookout for transitional phrases because they mark out an interpretive path through a paper. Needless to say, clear marking helps the reader cooperate with you, while clumsy marking or none at all forces the reader to guess at the relationship between one sentence and the next. Peter Richardson, Style, A Pragmatic Approach 45 1998. Good writers are sticklers for continuity. They won't let themselves write a sentence that isn't clearly connected to the ones immediately preceding and following it. They want their prose to flow, and they know that this is the only way to achieve that beautiful effect. John R. Trimble, Writing with Style 45 2D ed. 2000. Explanation. If it's true that connections should exist at the paragraph level, it's equally true at the sentence level. Every sentence should relate directly to the ones next to it. For example, in a follow-up sentence you might amplify, qualify, modify, or exemplify the preceding sentence. But if you ever find yourself darting off in a new direction, you'll create a bump in the narrative line unless you include a contrasting connective, usually a word such as but, however, or even so. Avoid bumps. A before and after example. Before. Introduction. Spouse has filed a motion to compel her own treating chiropractor, Drive. Baxter, to appear on her behalf and testify personally in court on May 11, 1992, the original trial date. In her motion to compel, spouse attacks the constitutionality of Idaho Code Ann. Section 101-24. Bump. Dr. Baxter has appeared for the limited purpose of filing a motion to quash the subpoena to testify in court. Bump. According to spouse's motion to compel, Drive. Baxter has offered to give a video deposition on spouse's behalf. Bump. Spouse has asked the court to waive the statutory immunity granted by the legislature in Idaho Code Section 101-24 and to exercise the court's discretion. Bump. The state of Idaho appears to defend the constitutionality of the statute. After. Introduction. Spouse has filed a motion to compel her own chiropractor, Drive. Baxter, to appear on her behalf and testify at trial. Although he has offered to give a video deposition, Drive. Baxter does not wish to appear in court and has sought to quash the subpoena to testify. In her motion, spouse attacks Idaho Code Ann. Section 101-24, which exempts practicing chiropractors from trial subpoenas, as unconstitutional. Spouse thus asks the court to exercise its discretion, waive this statutory immunity, and compel Drive. Baxter to appear at trial. In defense of the statute's constitutionality, the state of Idaho files this brief and asks the court to deny spouse's motion. 19. Ease your reader's way by providing signposts. Quotable quotes. The secret ambition of every brief should be to spare the judge the necessity of engaging in any work, mental or physical. Mortimer Levitan, Confidential Chat on the Craft of Briefing, 1957 Wis. L. Rev. 59, 63. Think of a piece of writing as a trip from a definite starting point to a definite destination. At the very start we look for a signpost pointing the way and naming the place we are headed for. At every fork of the road we need directions, legible and understandable directions. From time to time we glance back over the road we have already come, in order to remind ourselves of our position and direction. At the end we want to know that we have arrived at the point we set out for. Reminders of this sort are just as necessary in writing as they are in posting a road. David Lambeth et al. The Golden Book on Writing 6-7, 1964. Signpost your argument every step of the way. If you have 3 important pieces of evidence to support a particular contention, tell your reader so she can understand precisely where you're going. For instance, 3 examples will bear this out. First, the original treaty of 1923. John R. Trimble, Writing with Style 47, 2D ed. 2000. Headings are signposts, of course, but you'll also need textual signposts in all but the most elementary writing. If there are 3 issues you're going to discuss, state them explicitly on page 1. If there are 4 advantages to your recommended course of action, say so when introducing the list. And be specific. Don't say that there are several advantages. If there are 4, say so. This shows that you've thought through the problem. Brian A. Garner, Legal Writing in Plain English Section 27, at 75 2001. Explanation. Picture yourself as a passenger in a car, going somewhere but not knowing where because the driver won't tell you. If you're like most people, you'd probably feel uneasy, even if you know the driver, but more so if you don't. You'd probably like to know something about where you're going and how you're going to get there. In that way, a written argument is analogous to a car journey. This means, of course, that the effective writer must orient the reader at the outset and place signposts along the way as the analytical journey proceeds. Even as you approach little bends in the road, it's helpful to know that they're coming up. Hence, you need to supply signposts both for the brief as a whole and for individual paragraphs as well. In example A, notice how much easier it is to follow the argument when a simple sentence, that allegation is meritless for 2 reasons, is added. And in example B, notice what a big difference 2 additional words and 3 parenthetical numerals make. Some before and after examples. Example A. Before. To the extent that defendant's laches argument rests on the allegation that Borland acted inequitably by allowing defendants to build up sizable damages over many years, it must be rejected because Borland could not and did not recover monetary damages for the vast majority of defendants' sales of plastic encapsulated products before February 23, 1989, which was when the Process Patent Amendments Act added 35 U.S.C. Section 271G, making defendants' importation of products made by an infringing process abroad compensable in monetary damages, and after receiving notice of infringement, defendants failed to mitigate their damages and, in fact, increased their sales of infringing products. After. Defendants' sole allegation on laches is that Borland acted inequitably by allowing defendants to build up sizable damages over many years. That allegation is meritless for 2 reasons. First, Borland could not and did not recover monetary damages for the vast majority of defendants' sales of plastic encapsulated products before February 23, 1989, the date when the Process Patent Amendments Act first made defendants' importation of products manufactured by an infringing process abroad compensable in monetary damages. Second, after receiving notice of infringement, defendants failed to mitigate their damages. In fact, they increased their sales of infringing products. Example B. Before. Since a court looks to the surrounding circumstances to determine reasonable assurance, it is important to examine the progress and state of PSI's negotiations with Park Central's satisfaction with PSI and the previous contract, and whether Park Central was seeking alternatives to PSI. After. Since a court looks to the surrounding circumstances to determine reasonable assurance, the court should examine three things. 1. The progress and state of PSI's negotiations with Park Central. 2. Park Central's satisfaction with the parties' earlier contract. And 3. Whether Park Central was seeking alternatives to PSI. 20. Break up long, complex sentences. Shoot for an average sentence length of 20 words. Quotable quotes. Whenever you can shorten a sentence, do. And one always can. The best sentence, the shortest. Gustave Flaubert is quoted in Rudolf Flesch, The Art of Readable Writing 119, 1949, Reaper. 1967. Highly complex sentences are increasingly difficult to justify as business and professional readers grow more demanding, even when the readers are scientific, engineering, and legal people. In this category fall sentences that contain long series of modifying phrases and clauses piled one on top of the other, like driblets of sand on a sand castle. David W. Ewing, Writing for Results in Business, Government, and the Professions 337-38 1974. Most long sentences are not totally bewildering. Usually you can get some sense out of them, but they do make the meaning foggier and the reading less enjoyable. John L. Beckley, The Power of Little Words 32 1984. All readers find continuous reading of long sentences a strain. The writer continually makes maximum, and sometimes unreasonable, demands on their short-term memories, gradually they get tired, and concentration lapses. The writer of long sentences risks making readers inattentive. Christopher Turk and John Kirkman, Effective Writing, Improving Scientific, Technical, and Business Communication 94 2D ed. 1989. Short sentences are better. One of the easiest ways to write short sentences is to give each sentence just one job. James W. McElhaney, Writing to the Ear, Abba J., December 1995, at 74-76. Explanation. Lawyers are afraid of periods. They fear simplicity, yet a brief should be as simple as possible, that is, simple to read. Even if your arguments are technical or complex, your sentences never should be. And the best way to keep your sentences simple is to keep them short. In a 2001 survey of a California appellate court, 91% of the respondents agreed with this statement. Sometimes long sentences are distracting or confusing even if they are grammatically correct. Asterisk. Readability experts agree that the average sentence length for most expository prose should be something fewer than 20 words. But note that the goal of 20 words is only an average. If all your sentences are short, your prose will seem clipped and choppy. You should vary your sentence length to give your prose some rhythm. Of course, it's rare to see a choppy brief. More likely, the style could be characterized as suffocating. And the most common cause of this literary asphyxia is the overlong sentence. Some before and after examples. Example A. Before. It was the understanding of the parties and the court at the time the divorce agreement was entered that Mr. Montgomery would take all necessary steps to relieve Ms. Pretty of mortgage debt on the property, which was to become his alone, even if it required refinancing on the property. To the extent that Ms. Pretty is compelled to continue to carry this mortgage obligation, she will not be able to obtain any credit to assist her in getting back on her feet financially. Accordingly, this factor should be taken into consideration as an additional extenuating circumstance requiring deviation from the child support guidelines. 104 words, AVG. Sentence length, 34 words. After. The parties in the court understood at the time of the divorce agreement that Mr. Montgomery would take all necessary steps to relieve Ms. Pretty of the mortgage debt. The property was to become his alone. He knew he might have to refinance it. To the extent that Ms. Pretty continues to carry this mortgage obligation, she will not be able to obtain any credit. The court should consider this extenuating circumstance in deciding whether to deviate from the child support guidelines. 82 words, AVG. Sentence length, 16 words. Example B. Before. The fact that the attorney was not a party to the probate action necessarily means that he did not have a full and fair opportunity to litigate the issue of negligence, and he therefore should not be precluded from denying negligence in the later malpractice action despite the fact that the issue of his negligence may have been decided as an issue integral to the outcome of the will construction action. 71 words, AVG. Sentence length, 71 words. After. Because Smithwick was not a party to the probate action, he could not have had a full and fair opportunity to litigate the issue of negligence. Therefore, he cannot now be precluded from denying negligence, regardless of what the probate court decided. 42 words, AVG. Sentence length, 21 words. 21. Avoid tiresome repetitions that hurt the mind's ear. Quotable quotes. To repeat the identical word over and over produces a very crude and awkward effect. John F. Janung, Outlines of Rhetoric 160, 1894. The alert editor will pick up the inadvertent repetition of a word. The author, concentrating on what he is trying to say, may not notice such a repetition. To the editorial eye, not clouded by the original pressure of thought, a word used, say, 5 times in 5 successive sentences will stand out sharply. The editor will then find some way to get rid of the repetition, perhaps by introducing synonyms or perhaps by recasting the sentence. Lester S. King, Why Not Say It Clearly 92, 1978. Our appetitiveness is nowadays considered a sign of pauperdom in oratory, and of feeble-mindedness in narrative. Robert Graves and Alan Hodge, The Reader Over Your Shoulder 103 2D ed. 1979. My file contains another striking example of how not to say it short and plain. The case was complex, and the brief writer had used up all allowable pages after being denied permission to file an overlength brief. One of the major parties was United States Fidelity and Guarantee Company, known to everyone who has done much trial practice, and surely to the brief writer, as USF&G. In every instance from the beginning of the brief to the end, more than 200 times, USF&G is referred to as Defendant Appellant United States Fidelity and Guarantee Company, a Maryland corporation. Similarly, in every instance the trial judge is described not as the judge, the court, the trial judge, Judge Rowe, or even he, but as Honorable Richard R. Rowe, United States District Judge for the blank, District of blank. Motivated by frustration and curiosity, I made a word count of the excess baggage consisting of the description of USF&G and of the trial judge. Of course there was more flab than that. This verbiage alone used up 16 pages, space precious to both the writer and the court. John C. Godbold, 20 pages and 20 minutes, in Appellate Practice Manual 84, 91 Priscilla A. Schwab ed. 1992. Avoid frequent repetition of a character's name, identify him or her with a pronoun or descriptive phrase. Few things are more annoying than the overuse of a name. David L. Carroll, A Manual of Writer's Tricks 55, 2D ed. 1995. Explanation. If a word or phrase appears in sentence after sentence, the droning effect will annoy readers. For some reason, this is a common problem among legal writers. Why might that be? Well, there seem to be two convergent reasons. First, some legal writers fear pronouns. They have decided, because pronouns are sometimes ambiguous, to stop using them. Sometimes, though, you need them. Second, some writers are simply tone deaf. They haven't attuned themselves to the melodies of language. When you edit, try reading your sentences aloud, one after the other. This exercise helps you hear repetitions that you might not otherwise notice. You've probably heard this advice before. If so, have you acted on it? It's a suggestion meant to be followed, not merely to sound good. One other thing, find a good thesaurus and use it. Most word processors these days have one built in. Or try J.I. Rodale's Synonym Finder or Roget's Thesaurus. Some before and after examples. Example A. Before. The district court correctly recognized that it was bound by the jury's findings. After remand, both Hartnett and Woodcrest requested the district court to enter judgment on Hartnett's Title VII claim. Record, Volume 3, at pp. 572-85, 586-90. Plaintiff requested judgment based on his assertion that he had shown a prima facie case of Title VII discrimination. Record, Volume 3, at pp. 572-85. Woodcrest filed a motion for summary judgment, requesting the district court to enter judgment against Hartnett because the jury's findings of no discrimination on Hartnett's Section 1981 claim precluded a finding of discrimination on his remaining Title VII claim. Record, Volume 3, at pp. 586-90. On September 8, 1994, the district court issued a memorandum order and entered a judgment against Hartnett and for Woodcrest on Hartnett's Title VII claim. Record, Volume 3, at pp. 777-91, 792, Exhibit 2 to Appellant's Record Excerpts. In making this determination, the district court did not request additional evidence from the parties, as allowed by the remand. In the district court's memorandum order, the district court found that plaintiff failed to make out a prima facie case of discrimination under Title VII because he was not qualified for the job positions for which he applied. Record, Volume 3, at p. 783. The district court also expressly found that Woodcrest did not discriminate against Hartnett on the basis of race or national origin. Record, Volume 3, at p. 784. It is from the district court's judgment, along with the accompanying memorandum order, that Hartnett has taken this appeal. 261 words. After. The district court correctly recognized that it was bound by the jury's findings. After remand, both Hartnett and Woodcrest asked the district court to enter judgment on Hartnett's Title VII claim. 3. 572-85, 586-90. Hartnett requested judgment based on his claim that he had shown a prima facie case of discrimination. 3. 572-85. Woodcrest filed a motion for summary judgment because the jury's findings of no discrimination on Hartnett's Section 1981 claim precluded a finding of discrimination on his remaining claim. 3. 586-90. On September 8, 1994, the court issued a memorandum order and entered a judgment against Hartnett and for Woodcrest on Hartnett's discrimination claim. 3. 777-91, 792, Appellants X. 2. In ruling, the court did not request additional evidence from the parties, as allowed by the remand. In its order, the court found that Hartnett failed to make out a prima facie case of discrimination under Title VII because he was not qualified for the job positions for which he applied. 3. 783. The court also expressly found that Woodcrest did not discriminate against Hartnett on the basis of race or national origin. 3. 784. Hartnett now appeals. 188 words. Example B. Before. Plaintiff alleges that Great American violated Article 21.21 of the Texas Insurance Code. A plaintiff suing under Article 21.21 must give proper notice at least 30 days prior to filing suit. Because plaintiff has not sent proper notice to Great American respectfully requests that the court abate all proceedings in this case until 30 days after receipt of proper notice under Article 21.21 of the Texas Insurance Code. 70 words. After. Washburn alleges that Great American violated Article 21.21 of the Texas Insurance Code. That statute, however, requires a plaintiff to give proper notice at least 30 days before filing suit. Because Washburn did not do this, Great American respectfully requests that the court abate all proceedings in this case until 30 days after Washburn meets its notice obligations. 58 words. Example C. Before. Dynasty Mutual has apparently abandoned and waived a series of other arguments that Dynasty Mutual had been vigorously pursuing up to the date Dynasty Mutual filed its motion for summary judgment. These defenses had previously been the primary focus of Dynasty Mutual's attempts to avoid its defense obligation to Cortland. Dynasty Mutual's motion for summary judgment addresses several of these issues. Most of the legal arguments of Dynasty Mutual were the subject of Dynasty Mutual's motion to dismiss and were rejected by Judge Poynter in his order dated January 24, 1996. However, Judge Poynter reserved ruling on whether Dynasty Mutual had a duty to defend to allow Dynasty Mutual to conduct discovery on Dynasty Mutual's purported defenses. 117 words. After. Dynasty Mutual has apparently abandoned and waived a series of other arguments that it had vigorously pursued before moving for summary judgment. These defenses, several of which are addressed in the motion, had previously been the primary focus of Dynasty Mutual's motion to dismiss, which Judge Poynter denied in January 1996. But Judge Poynter reserved ruling on the duty to defend until the parties conducted further discovery. 67 words. 22. Put all your citations in footnotes, while saying in the text what authority you're relying on. But ban substantive footnotes. Quotable quotes. References in footnotes. I don't know what we are going to do with the briefs, but it does seem to me that it is a wearisome thing to have these long citations. Almet F. Jenks, Presiding Justice of the Appellate Division of the N.Y. Supreme Court lecture before the Asin of the Bar of the City of New York, the 1st of March 1923, is quoted in Mario Pitoni, Brief Writing and Argumentation 44, 1967. Here a brief is written with the hope of presenting an argument that will be interesting as well as instructive. Footnotes may advantageously be used for the incorporation of necessary reference material, the inclusion of which in the text would interrupt the otherwise smooth-flowing chain of argument. Frank E. Cooper, Writing in Law Practice 266 2d ed. 1963. TE system used for citing references should be designed to give minimum interruption to readers' progress through the text. It should allow them to concentrate on primary information. Christopher Turk and John Kirkman, Effective Writing, Improving Scientific, Technical, and Business Communication 69-70 2d ed. 1989. Many brief writers suffer chronic cases of literary hiccups. They insert citations as often as possible, 3 or 4 in a simple declaratory sentence, irrespective of how these interfere with the flow of the prose, the rhythm of the presentations or the order of argument. Ruggiero J. Aldizert, Winning on Appeal, Better Briefs and Oral Argument 202, 1992. Only the hardiest of stylists will own up to this difficult fact. In many types of legal writing, in briefs and memos, for example, the only sensible place for citations is in footnotes. Putting them in the body clutters the text, slows the reader, and hampers the writer's ability to construct a coherent paragraph. Few writing reforms would benefit the legal world more than adopting the following rules. 1. Put all citations in footnotes, and 2. Ban footnotes for all purposes other than providing citations. Brian A. Garner, A Dictionary of Modern Legal Usage 156 2d ed. 1995. As lawyers, we often forget how much cites break up the flow of a narrative, even for a lawyer who is used to reading them. Why? Our readers don't absorb cites, they jump over them. Once they start jumping, it's hard to get them to stop so they don't miss subsequent text. Stephen D. Stark, Writing to Win 232-33 2000. Citations belong in footnotes. You will be amazed at the increased readability. The clutter of letters and numbers in the middle of a paragraph is gone. The sentences flow into each other, instead of being isolated islands in a sea of citations. Judge Mark P. Painter, The Legal Writer 47 2d ed. 2003. No substantive footnotes. Perhaps no single implement of all the vast apparatus of scholarship is so thoroughly misused in the law as the footnote. There may be some justification in the manifold areas of the academic world for that formidable display of learning and industry, the thin stream of text meandering in a veil of footnotes, but such a technique is quite self-defeating in the law. It makes the writer's thoughts more difficult to follow, and hence far less likely to persuade the judicial reader. Frederick B. Wiener, Briefing and Arguing Federal Appeals 245 Reverend ed. 1967. Avoid footnotes. They are nuisances in the field of argumentation. They impede readability and understanding, and they break up the continuity of argument. True, at times, they are unavoidable. But generally, if the pearl cannot be worked into the main part of the brief, it is either unimportant or is part of muddled thinking, and the note is used to cover muddiness of thought. Mario Pitoni, Brief Writing and Argumentation 39, 1967. If your point is important, it belongs in the text. If it is not important, it does not belong in the brief. Like all rules, this one may have exceptions, and occasionally a particular case may necessitate the use of footnotes, but, as a rule of thumb, work with the presumption that they will not be utilized. You are not writing a scholarly law review article that is expected to be filled with long, tortuous footnotes. Harvey C. Couch, Writing the Appellate Brief, 17 Prac. Law, 27, 30, 1971. If footnotes were a rational form of communication, Darwinian selection would have resulted in the eyes being set vertically rather than on an inefficient horizontal plane. Abner J. Mikva, Goodbye to Footnotes, 56 U. Colo, L. Rev. 647, 648 1985. Footnotes are usually a sign that the writer has not thought out carefully what he or she wanted to say, or what importance to attach to each piece of information. Christopher Turk and John Kirkman, Effective Writing, Improving Scientific, Technical, and Business Communication 71 2d ed. 1989. Explanation. Put citations in footnotes. Of all the tips in this book, this one is the most controversial. Its inclusion in the first edition resulted in a minor furor in which I was called a Rasputin, who was misleading lawyers and judges into undermining the doctrine of precedent. 1. The New York Times ran a front-page article on the brouhaha. 2. And soon after Judge Richard A. Posner debated me on the point in an exchange that deserves greater attention than it has gotten. 3. Justice Rodney Davis of California weighed in on my side of the dispute. 4. Despite the occasionally raucous objections, as well as the calmer ones raised by Judge Posner, the power of the tip remains undiminished, and it continues to make headway in the profession. The trend is slow but steady. Here, essentially, are the pros and the cons. Footnoted citations without substantive footnotes. Image. Whereas the pros are hard to answer, often unanswerable, the cons are mostly easy to counter. Why, you may wonder, have briefs always had citations in the text? That's never been so of law reviews and treatises, but there must be a good reason why briefs are different. Right, wrong. The reason is quite simple. The traditional method of preparing briefs involved scribes and after the 1880s typewriters. It was all but impossible to get citations and footnotes and to make the lines work out right on the page. That's why citations were in the text in 1900, and that's why they were still there in the late 20th century. Today, things have gotten worse. With computer research and the proliferation of case law, it has become easier than ever to find a passel of cases to support almost every sentence in a brief. So, over time, the pages of briefs have become increasingly cluttered. Some have become virtually unreadable. Others are readable, but only by a reader who is mentally capable of dealing with lots of underbrush. Meanwhile, in the late 1980s, technology gave us word processors with the ability to rid the text of citations. The computer automatically finds where to break pages, how to place footnotes, even keeping track of changing footnote numbers. Of course, it's not that simple for the writer. You must rewrite in a way that cues the reader to what your authority is. It's just that you put this into prose, you work it into your paragraph, while ridding the text of volume numbers and page numbers, and thereby make life easier for the judge who reads your brief. Citations have posed a major problem not just for readers, but also for writers. Many lawyers have gotten in the habit of putting a citation or two between sentences. That weakens the connection between consecutive sentences. So distrusting the reader to make a connection, they repeat the relevant part of the preceding sentence in the one that follows. The sentences get longer and longer and more repetitive. All this is anathema to a good writing style. So you see, even if readers think they can handle citations in the text, the fact is that most legal writers can't. Although writers continue to experiment with possible solutions, such as putting citations in smaller type or in colored ink, both of which would violate the federal rules of appellate procedure, the sensible solution is to use reference notes. That is, put citations and only citations in footnotes. And write in such a way that no reader would ever have to look at your footnotes. Give the name of the court you're quoting, the year in which it wrote, and, if necessary, the name of the case up in the text. Just get the numbers out of the way. Why not endnotes? You might ask. Well, endnotes simply aren't handy. For the reader who really wants to see the citation, it's annoying to have to flip back and find the relevant note. You've probably tried to read articles or books that annoyed you in this very way. If you think that footnoting citations is an off-the-wall idea, ask yourself why you've never seen a biography written like this. Hand's assumption that judges are likely to impose their class predilections if they are involved in determination of the fundamental issues of society. Learned Hand, Mr. Justice Holmes at 85, N.Y. World, March 8, 1926. Reaper. In Learned Hand, The Spirit of Liberty 24. Irving Dillard ed. 1952. Hereinafter Spirit of Liberty, stating that judges are usually taken from that part of the bar which has distinguished itself in the field of action, and adding, they are likely to be men of strong will, set beliefs and conventional ideals, seems to be more speculative, and Hand himself insisted that some people are free from such bias. See, e.g., Learned Hand, The Speech of Justice, 29 Harv. L. Reverend 617, 619, 1916, noting that some members of the American bench could utter justice without misgiving or constraint. Cf. Catherine Griffith, Judge Learned Hand and the Role of the Federal Judiciary 93, 1973, analogous point for the receipt as well as the meting out of justice. He was not as much concerned with the grosser economic or material interests of judges. Southern Transby. Company vs. Dauntless Towing Line, 140 F2D 215, 2DCIR 1944, evincing characteristic disinterestedness in a case involving the collision of barges, as with their more basic understanding of what constitutes the good life. See Learned Hand, How Far is a Judge Free in Rendering a Decision? CBS Nationwide Radio Broadcast. Reaper. In Learned Hand, Spirit of Liberty at 103. Hand believed that most judges did not use their power for personal gain but that it was often difficult for them to maintain an open mind to ideas which challenge their basic faith and most profound assumptions. See Learned Hand, The Commodities Clause of the Fifth Amendment, 22 Harv. L. Rev. 250, 252, 1909. Learned Hand, Due Process of Law in the 8-Hour Day, 21 Harv. L. Reverend 495, 497, 1908. But see Jerome Frank, Some Reflections on Judge Learned Hand, 24 Chi. L. Reverend 666, 668, 1957, throwing into question, by implication, Hand's point about basic faith and profound assumptions, citing U.S.V. Kirschenblatt, 16 F2D 202, 203 2DCIR. 1926. He felt that these fundamental predispositions would almost invariably be part of a decision in which a judge sought to interpret vague and ill-defined pronouncements of the public will. Learned Hand, Is There a Common Will? In Spirit of Liberty at 47, 50. He did not argue that judges can or should divest themselves of their basic beliefs or make their own beliefs the criteria of the basic values of society. See id. According to Hand's understanding of the American system, see, e.g., USV. Kaplan, 185 F2D 629, 631 2DCIR 1950 illustrating same USV. Cotter, 60 F2D 689, 692 DCIR 1932 same. The court was not the proper forum for a confrontation of fundamental interests, in either the material or the ideological sense. See Learned Hand, Mr. Justice Holmes at 85, NY. World, March 8, 1926 Reaper. In Learned Hand, Spirit of Liberty at 24, 26 noting that the court is not the proper forum for a confrontation of ideological and material interests. See also Felix Frankfurter, Learned Hand, in Of Law and Life and Other Things That Matter 224, 229 Philip B. Kurland ed. 1965 noting that, key individual contribution of judges is absorbed in the anonymity of the coral reef by which the judicial process shapes the law. A historian would be insane to ruin a good story that way. But brief writers commonly do something like it. Besides improving readability, putting citations and footnotes allows you to strip down an argument and focus on what you're really saying. In example A, for instance, you'll see a lack of coherence once the citations have been removed. This type of incoherence is commonplace, but textual citations help mask it. 3 other points. First, you generally shouldn't just footnote naked propositions of law. Instead, say something like, New Jersey courts have held, or, Section 28.007 of the Probate Code requires, so that the reader can get the gist of your authority without having to glance down at the bottom of the page. Second, even when citing cases in footnotes, some writers think they should put record references in the text if they're uniformly short. That's the method in the 3 model fact statements in tip number 80. My own preference is to put even the record references in footnotes. CPP 378-85. The prose gains continuity if it's not interrupted by little parentheticals. Third, know your audience. Some judges say they don't like citations in footnotes. I happen to believe that they haven't fully thought through the point or seen good examples. Why do I think that? Because every time I teach a seminar on judicial writing, a vast majority of the judges finally conclude that they think it makes sense to put citations in footnotes. A few others, however, think otherwise. And if you know that's what a judge thinks, heed the judge's preference. Just don't let your temporary heed become your regular habit. Ban substantive footnotes. In substantive footnotes, as distinguished from footnotes limited to citations, a writer argues or explains points related to those in the text. Although some judges defend substantive footnotes, the safer bet is that your judicial reader will react to them with revulsion. It's a common feeling among judges these days because so many brief writers abuse footnotes. Sometimes the writer wants to seem more scholarly, sometimes the purpose is to squeeze more words into the brief. There's surely much to be said for substantive footnotes in scholarship, but in purely persuasive writing, you'll find them pretty easy to do without. My rule of thumb allows 1 or 2 substantive footnotes in a year of busy brief writing. Adopt an up or out policy. If it's not important enough to say up in the text, then take it out of the brief altogether. Some before and after examples. Example A. Before. Nor is the due process requirement satisfied. Due process requires that a defendant have sufficient contact with the forum state so that an exercise of long-arm jurisdiction will not offend traditional conceptions of fair play and substantial justice, and so that a defendant should reasonably anticipate being hailed into court there. Tidgewell, 820 F. Sup. At 632 quoting International Shoe Company vs. Washington, 326 U.S. 310, 320, 66 S. Court. 154, 160, 90 L. ed. 95 1945, and Worldwide Volkswagen Corp. vs. Woodson, 444 U.S. 286, 297, 100 S. Court. 559, 567, 62 L. ed.2d 490 1980. The court has identified 5 relevant criteria. 1. The defendant's burden of appearing. 2. The forum state's interest in adjudicating the dispute. 3. The plaintiff's interest in obtaining convenient and effective relief. 4. The judicial system's interest in obtaining the most effective resolution of the controversy. And 5. The common interests of all sovereigns in promoting substantive social policies. United Elec. Radio and Mock. Workers, 960 F2D at 1088, citing Burger King vs. Rudzowitz, 471 U.S. 462, 477, 105 S. Court. 2174, 2184, 85 L. ed.2d 528 1985. After. Nor is the due process requirement satisfied. A defendant must have sufficient contact with the forum state so that an exercise of long-arm jurisdiction will not offend traditional conceptions of fair play and substantial justice, and so that a defendant should reasonably anticipate being hailed into court there. 32. Engaging this standard, the Supreme Court has named 5 relevant criteria. The defendant's burden of appearing. The forum state's interest in adjudicating the dispute. The plaintiff's interest in obtaining convenient and effective relief. The judicial system's interest in obtaining the most effective resolution of the controversy, and the common interests of all sovereigns in promoting substantive social policies. 33. Example B. Before. In order for a family of trademarks to be protected, the common characteristic must have developed secondary meaning. Spraying S. Wise, Company vs. Delavan, Inc., 975 F2D 387, 393 7th CIR 1992, see also Traffics Devices, Inc. vs. Marketing Displays, Inc., 532 U.S. 23, 27-29, 121 S. Court. 1255, 1259, 149L. Ed. 2D 164 2001. The design or packaging of a product may acquire a distinctiveness which serves to identify the product with its manufacturer or source, and a design or package which acquires this secondary meaning, assuming other requisites are met, is a trade dress which may not be used in a manner likely to cause confusion as to the origin, sponsorship, or approval of the goods. In other words, the family characteristic must be such as to inform the consumer of the product's source, not simply of its nature, featuring Howard Paper Company vs. Nice Pop Prods, Inc., 127 USPQ. 431 TTAB. 1960 NAP. Suffixes told public that products were used in connection with napkins, not that they came from the same source, so as to prompt the consumer who sees an article of merchandise to say, "That's the article one want because I know its source," not, "Who makes that article?" Ferrari SPAV. Roberts, 944 F2D 1235, 1239 6th CIR 1991, citing West Point MFG. Company vs. Detroit Stamping Company, 222 F2D 581, 595 6th CIR. 1955. Whether a family of marks exists is an issue of fact based on the common formative components' distinctiveness, the family's use, advertising, promotion, and inclusion in related marks. McDonald's Corp. vs. McBagels, Inc., 649 F. Sup. 1268, 1271 SDNY. 1986. Whether the party claiming a family of marks has used joint advertising and promotion in a manner designed to create an association of common origin may be pertinent. Champion International Corp. vs. Plexowood, Inc., 191 USPQ. 160 TTAB. 1976. After. For a family of trademarks to be protected, the common characteristic must have developed secondary meaning, a distinctiveness that serves to identify the product with its source. 6. This characteristic must be something that consumers associate with the source, not just the nature, of the goods or services. 7. But once consumers rely on that association, competitors and others may not use the same characteristic in a way that creates confusion about the source. 8. As the Sixth Circuit has put it, the distinctive characteristic must prompt the consumer who sees it to say, "That's the article one want because I know its source," not, "Who makes that article?" 9. Whether a family of marks exists is an issue of fact based not just on the common components' distinctiveness, but also on the family's use, advertising, promotion, and inclusion in related marks. 10. The use of joint advertising and promotion to create an association of common origin may also be pertinent. 11. Substantive footnotes, an example of what judges detest. Applicant intervener may be impaired in civil prosecution sui juris of federal law allegation of prohibited activities under a pattern of racketeering, inclusive of the intervening state court judgment. 12 is a component artifice, capable of proof by a preponderance of the evidence. 13 is contradistinguished from the accelerated, clear and convincing standard required to establish both vacation of the state court proceeding. 14 and proof of any underlying state law questions which substantively devolve to common law fraud. The critical component of the impairment theory devolves to a judgment analysis of whether Section 1031, paragraph Mark IV, review sub judice actually metastasizes federal law issue preclusion under the Full Faith and Credit Act, 28 U.S.C. Section 1738, 1982. The metastasis would occur not only as to pure state law issues of common law fraud justiciable under pendent jurisdiction, but also as to heretofore pristine federal law issues. Academic scrutiny finds impairment to be more than conjecture. A model example of citations in footnotes. Beverly Ray Burlingame of Dallas is a master at writing readable briefs with citations in footnotes. What follows is a brief for an evidentiary hearing in federal court. Notice how clean the pages look in comparison with those in most briefs. In the United States District Court. For the Northern District of Texas. Dallas Division. Johnson's brief on the use of extrinsic evidence in claims construction. This brief addresses Sempro's objections to the exhibits that Johnson intends to offer at the upcoming Markman hearing. 15. These objections are apparently based on two errors by Sempro. 1. It has misinterpreted the purpose of some of the exhibits, and 2. It has overlooked recent federal circuit law, including the Markman case itself, explaining the proper role of extrinsic evidence in construing patent claims. Johnson's brief on the use of extrinsic evidence, page 1. Argument. A. Extrinsic evidence can properly be used in claim construction as long as it does not vary the unambiguous meaning of the claim. As the Federal Circuit has observed, in determining the proper construction of a claim, the court has numerous sources that it may properly utilize for guidance. 16. When the court is unfamiliar with technical terms or the underlying technology of a patent, the testimony of witnesses may be received upon these subjects, and any other means of information may be employed. 17. In construing a claim, a district court should look first to the intrinsic evidence of record, including the claim, the specification, and, if in evidence, the prosecution history. 18. If this public record unambiguously describes the scope of the patented invention, then reliance on extrinsic evidence is improper. 19. But if the meaning of a disputed claim cannot be determined from the public record, then extrinsic evidence may be helpful, particularly if a critical technical aspect of the invention was neither discussed in the specification nor commented on during patent prosecution. 20. Johnson's brief on the use of extrinsic evidence, page 2. Under such circumstances, extrinsic evidence, including expert testimony, inventor testimony, dictionaries, technical treatises, and articles, may be useful to the court in reaching a proper understanding of the patent and of the claim languages. 21. The only pertinent limit on using such evidence is that the court should not rely on it to vary or contradict unambiguous claim language. 22. B. Sempro has no valid objection to the extrinsic evidence that may be offered by Johnson. 1. Evidence concerning prior art, both cited and uncited, is relevant in construing the asserted claims. As Sempro apparently recognizes, some of Johnson's exhibits relate to prior products and patents that were not cited in the prosecution histories of the patents in suit. 23. From this fact, Sempro leaps to the incorrect conclusion these exhibits will be offered at the Markman hearing to prove that some of the asserted claims are invalid. 24. Although for some claims, Johnson has asserted the defense of invalidity based on prior art, the issue of invalidity is not the subject of this proceeding. Indeed, Johnson intends to offer prior art at the Markman hearing to show that to the extent that any claim may be found ambiguous, it must be construed narrowly to uphold its validity. Under well-established law, patent claims are generally construed so as to sustain their validity, if possible. 25. As Johnson's previously filed brief makes clear, the relevant prior art, both cited and uncited, is being offered by Johnson so that the claims can be properly, and narrowly, construed to avoid their being invalidated by the prior art. 26. Johnson's brief on the use of extrinsic evidence, page 3. In Amhill Enterprises, the Federal Circuit construed a claim to sustain its validity over several instances of prior art. 27. There, the court addressed the proper meaning of substantially vertical in describing the faces and side edges of a cup lid. The court first considered the prior art Zabner and Davis patents, which were cited by the examiner in initially rejecting the claim under Section 103. 28. As the court explained, the patentee distinguished its invention from the cited prior art, based in part on the slope of the projection faces. 29. Thus, the term substantially vertical was construed to mean vertical, or not including lids with sloping faces like those of Zabner, 645. 30. As the Federal Circuit explained, the claim had to be construed narrowly to avoid the prior art. Finally, it is apparent from our review of the prior art of record that lids of the general construction claimed in the 244 patent were common in the industry. Several prior art lids depict outwardly extending projections with variously sloped outward faces, as may be seen in the figures from some prior art lid patents reproduced in the attached appendix. In order for Claim 1 of the 244 patent to avoid these prior art lids, substantially vertical face must be construed as the same as or very close to vertical face. Any other construction of Claim 1 would render it invalid. 31. Johnson's brief on the use of extrinsic evidence, page 4. Exactly the same type of analysis will be required for some of the claims asserted in the present case. These claims must be construed so that they avoid the prior art. Otherwise, as in Amhill Enterprises, the claims would be rendered invalid. Sempro suggests that while prior art that was actually cited in the prosecution history might be relevant, the court should ignore any prior art that was not cited. 32. But in Vitronics, the Federal Circuit expressly authorized considering both cited and uncited prior art in construing patent claims. A court in its discretion may admit and rely on prior art proffered by one of the parties, whether or not cited in the specification or the file history. 33. Consistent with Vitronics, a Michigan federal court recently used extrinsic prior art in construing a claim to sustain its validity. 34. As the district court explained, the chute of prior art reference serves as extrinsic evidence, i.e., evidence external to the patent and prosecution history, that demonstrates the state of the art at the time of the invention. 35. Quoting Markman, the court observed that this extrinsic prior art was useful to show what was then old, to distinguish what was new, and to aid the court in the construction of the patent. 36. Johnson's brief on the use of extrinsic evidence, page 5. The Renishaw court then construed the claim to sustain its validity over the uncited prior art chute of reference. Using plaintiff's proposed construction, these limitations, along with the rest of Claim 51, literally read on the chute of reference. To avoid rendering Claim 51 invalid, these limitations would have to be construed so as to exclude the chute of reference. 37. In the same way, some of the asserted claims in this case should be construed to avoid rendering them invalid based on extrinsic prior art that will be proffered by Johnson at the Markman hearing. Despite Sempro's objections, both cited and uncited prior art may properly be considered and used by this court in construing the asserted claims. Such evidence will plainly be helpful, to show what was then old, to distinguish what was new, and to aid the court in the construction of the patent. 38. 2. There is no support for the notion that extrinsic evidence must be limited to evidence that is dated before the filing date of the patents. Sempro's second objection to Johnson's extrinsic evidence is that some of the exhibits are dated after the filing of the various patents in suit to which the exhibits relate. 39. Without citing any authority, Sempro asserts that such exhibits are irrelevant and can never have any bearing on claim construction. 40. But recent Federal Circuit case law makes this assertion insupportable. In Vitronics, a case in which the sole issue was claim construction, the plaintiff brought suit in November 1991 for infringement of its 502 patent. 41. The district court considered a wide array of extrinsic evidence, including expert testimony, live testimony of one of the plaintiff's engineers, deposition testimony, technical articles, and a paper by one of the plaintiff's employees. 42. This employee paper had been written in 1994, which was plainly several years after the filing date of the patent. 43. And all the testimony considered by the court, including the deposition testimony, was clearly taken after that filing date. Johnson's brief on the use of extrinsic evidence, page 6. The Federal Circuit ultimately concluded that because there was no ambiguity in the phrase, solder reflow temperature, as used in the claims, the district court should not have relied on extrinsic evidence to vary or contradict the manifest meaning of the claims. 44. As explained in Vitronics, a district court should use extrinsic evidence in claims construction only if there is some genuine ambiguity in the claims, after consideration of all available intrinsic evidence. 45. But the Federal Circuit expressly approved of a trial court's hearing all possible evidence before construing the claim, even if the judge permissibly decided to hear all the possible evidence before construing the claim, the expert testimony, which was inconsistent with the specification and file history, should have been accorded no weight. 46. As the court noted, if the district court had, instead, used the expert testimony and other extrinsic evidence to help it understand the underlying technology, we could not say the district court was in error. 47. Johnson's brief on the use of extrinsic evidence, page 7. Similarly, the Markman court concluded that a district court can properly admit extrinsic evidence and then later reject such evidence to the extent that it contradicts the construction required by the public record. We conclude that 1. The trial court did not abuse its discretion when it admitted the extrinsic evidence offered by Markman's testimony and the testimony of Markman's patent expert on the issue of claim construction, and that 2. The trial court properly rejected this extrinsic evidence to the extent it contradicted the court's construction of the claims based on the specification and prosecution history. 48. As one Pennsylvania federal court recently recognized, a district court may properly consider extrinsic evidence when helpful, such as expert testimony, learned treatises, and even sales literature. 49. Moreover, the Vitronics court recognized that in some cases, district courts can go beyond merely considering such evidence. In construing ambiguous claims, they can properly rely on exactly the types of extrinsic evidence discussed in Vitronics, including the paper written by the patentee's employees several years after the patent issued. Here, the trial judge considered not only the specification, but also expert testimony and other extrinsic evidence, such as the paper written by the former Vitronics employee. No doubt there will be instances in which intrinsic evidence is insufficient to enable the court to determine the meaning of the asserted claims, and in those instances, extrinsic evidence, such as that relied on by the district court, may also properly be relied on to understand the technology and to construe the claims. 50. Johnson's brief on the use of extrinsic evidence, page 8. This 1996 opinion from the Federal Circuit thus directly contradicts Sempro's argument that documents created after the patent's filing date can never have any bearing on claim construction. 51. By its very nature, most extrinsic evidence, including all expert testimony, will have been created after the date the patent was filed. Contrary to Sempro's view, that sequence of events provides no reason for excluding such evidence. Conclusion. Vitronics authorizes this court to hear all possible evidence, including extrinsic evidence, before construing the claims at issue. This method promotes efficiency because it allows the court to hear all the evidence that might possibly be useful and relevant, instead of 1. Hearing solely the intrinsic evidence, 2. Deciding whether each claim is ambiguous, and 3. Then possibly having to hear additional evidence to resolve any ambiguities in the claims. Johnson therefore respectfully asks this court to overrule Sempro's objections to Johnson's extrinsic evidence and to grant Johnson any further relief to which it is justly entitled. Johnson's brief on the use of extrinsic evidence, page 9. 23. If you must cite in text, make the citations unobtrusive. Quotable quotes. By any measure, the attorneys did a poor job of restricting their presentations of authority to those cases the judges considered useful. This is one of the major points made in the judge's writings on appellate advocacy. A substantial number asked counsel to limit themselves to the more relevant authority, especially galling to the judges is the long string of case citations to support a proposition, rather than a few apposite ones. Thomas B. Marvell, Appellate Courts and Lawyers 133, 1978. Use authorities sparingly and only to the extent necessary to support a well-thought-out theory of your case. Nathan S. Hefferman is quoted in Ruggiero J. Aldizert, Winning on Appeal, Better Briefs and Oral Argument 198, 1992. About citations, a lawyer should include as few as practical, mainly those of the leading or more recent cases. Albert Tate Jr., The Art of Brief Writing, What a Judge Wants to Read, in Appellate Practice Manual 197, 205 Priscilla A. Schwab ed. 1992. Pete lays citations so as to have them available but out of the way. Always subordinate citations to the statements they support. Never begin a sentence with a citation. By the time your readers get to the first parallel citation in the second line of your sentence, and realize that no thoughts have yet filtered through, they will decide that you're a writer who deserves, at the very most, a quick scan. Brian A. Garner, The Elements of Legal Style 90, 2D ed. 2002. Explanation. If you're nervous about following the advice of number 22, or if court rules prohibit you from doing so, then, when citing in text, avoid 4 bad conventions. First, don't begin a sentence with a citation. Nobody gets excited about reading a sentence that begins, The Voting Rights Act of 1965, Pub. L. No. 89 to 110, 79 Stat. 445 codified at 42 U.S.C. Sections 1971, 1973 to 1973 BB 1, 1988 provides. Second, don't put a citation in mid-sentence. Instead, always arrange for the citation to fall at the end of the sentence, even if you mention the case in the text. Here's an example of what not to do. While name plaintiff's lack of standing also precludes them from meeting Fed. R. Civ. P23 AS, Typicality, Requirement for Class Certification, C. Lamar vs. H&B Novelty and Loan Company, 489 F2D 461, 465-66 9th CIR. 1973. In brief, typicality is lacking when the representative plaintiff's cause of action is against a defendant unrelated to the defendants against whom the cause of action of the members of the class lies. We assert that a plaintiff who has no cause of action against the defendant cannot fairly and adequately protect the interests of those who do have such causes of action. Standing is a threshold requirement that must be met before any inquiry into class representation under Rule 23 is made. See Wiener vs. Bank of King of Prussia, 358 F. Sup. At 694, it must be noted that the question of standing is totally separate and distinct from the question of plaintiff's right to represent a purported class under Rule 23. Standing to sue is an essential threshold which must be crossed before any determination as to class representation under Rule 23 can be made. Is that a 187-word-long sentence? Or a 41-word-long sentence with citations stuck in it? Less horrific examples abound in briefs. Here's a typical one. In Fitzpatrick vs. Illinois Human Rights Common, 267 Ill. App. 3D 386, 642 NE 2D 486 4th Dist. 1994, the plaintiff alleged that the employer discriminated on the basis of physical handicap when it failed to accommodate the plaintiff, who had been diagnosed with a sleeping disorder, by simply transferring her from the day shift to the night shift. 267 Ill. App. 3D at 387, 642 NE 2D at 487. The court held that, even assuming that this is the first passage where the case has been cited, you could handle the citation in this way. In Fitzpatrick vs. Illinois Human Rights Common, the plaintiff alleged that the employer discriminated on the basis of physical handicap when it failed to accommodate the plaintiff, who had been diagnosed with a sleeping disorder, by simply transferring her from the day shift to the night shift. 267 Ill. App. 3D 386, 387, 642 NE 2D 486, 487 4th Dist. 1994, the court held that, of course, you'd be better off following tip number 22. Third, don't put the citation flush left after a block quotation. Example A shows how misleading it can be to end a block quotation and put the citation at the left margin, where the text is meant to resume. The sentence after the quotation is all but lost. Instead, the better practice, regardless of what the Blue Book says, is to tuck the bracketed citation under the quoted matter. Fourth, don't use string citations. This warning has become something of a cliché, yet lawyers everywhere continue to use string citations. They're a bad habit, and like many other bad habits in legal writing, string citations often betray a lack of confidence. Once again, tip number 22 eliminates the problem. But if you're citing in text, and you can support a proposition with just one case, do it. There's no need to cite every case on point. Simply pick the most recent case from the court of last resort in your jurisdiction. Generally, that case will serve as ample authority. If, however, you're convinced of the need to highlight the cases in your string, when, for example, the development of the law is important to understanding the argument you're making, then put them in a list, preferably with holdings before citations. The whole problem of textual citations is one of emphasis and subordination. Most relevant to the authority of a citation are the court, the holding, and the date of the holding, all the information that appears at the end of the citation, with the holding further buried in parentheses. Least important are the name of the case, typically, the volume number, and the page numbers. So traditional modes of textual citation emphasize the least important things and subordinate the most important, as here. New York courts have held that several types of activities by a defendant are evidence of doing business in the state. W. Lowenthal Company vs. Colonial Wooden Mills, Inc., 38 AD.2D 775, 776, 327 NYS 2D 899, 901 3D Deep 1972, holding that maintenance of an office in New York is doing business done vs. Southern Charters, Inc., 506 F. Sup. 564, 567 EDNY 1981, holding that solicitation of business in New York is doing business Masonite Corp. vs. Hellenic Lines, Limited, 412 F. Sup. 434, 438 SDNY 1976, holding that having a New York bank account is doing business Caslow and Caslow vs. A. Goodman and Company, 92 MISC. 2D 1084, 1086, 402 NYS 2D 98, 99 First Deep 1977, holding that making use of New York courts is doing business. It would be hard, without getting quite far-fetched, to devise a more inefficient way of delivering the message contained in that passage. But consider what happens when the parentheticals are highlighted in a list and the rest is subordinated in parentheses. New York courts have held that the following types of activities by a defendant are evidence of doing business in the state. Maintaining an office in New York. W. Lowenthal Company vs. Colonial Wooden Mills, Inc., 38 AD.2D 775, 776, 327 NYS 2D 899, 901 3D Deep 1972. Soliciting business in New York done vs. Southern Charters, Inc., 506 F. Sup. 564, 567 EDNY. 1981. Having a New York bank account Masonite Corp. vs. Hellenic Lines, Limited, 412 F. Sup. 434, 438 SDNY. 1976. Making use of New York courts Caslow and Caslow vs. A. Goodman and Company, 92 MISC. 2D 1084, 1086, 402 NYS 2D 98, 99 First Deep 1977. Example B illustrates a variation on this technique. The case names come first, before substantial quotations, to show the development of the law during the 20th century. Either way of doing a string citation, the one just above or the one in the revised version of example B, is much stronger than run in strings with parentheticals. Example A. The problem of the flush left citation. Before. At least 2 current or former NAVPRO employees have confirmed in their depositions that Mr. Riley had no involvement in the Maplewood 1 development. Richard Shipman, who was vice president of property management in NAVPRO's New York office when Riley worked there, adamantly declared that Riley had nothing to do with Maplewood 1. Q. Are you aware of what Michael Riley's responsibilities were at the time that you had responsibilities in the New York office for Maplewood 1? Mr. Conyers. Objection. The witness. Michael Riley had responsibility for developing new properties. Therefore, he had no responsibility on Maplewood 1. Ellipsis. Q. Do you recall if Mr. Riley would have had any involvement with either the decision to remove asbestos from Maplewood 1 or the actual removal of asbestos from Maplewood 1? Mr. Conyers. Objection. The witness. Absolutely not. Q. Would Mr. Riley have had any management responsibilities for the Maplewood 1 building? Mr. Conyers. Objection. The witness. Absolutely not. See the transcript of the deposition of Richard Shipman, dated December 14, 1995, at 83, 18, 84, 14, attached as Exhibit A to the certification of counsel. Matthew Brooks, who was the asset manager for Maplewood 1 while Riley worked in the New York office, also confirmed this fact. See the transcript of the deposition of Matthew Brooks, dated December 20, 1995, at 76, 20-23, attached as Exhibit B to the certification of counsel. After. At least 2 current or former NavPro employees have confirmed in their depositions that Mr. Riley had no involvement in the Maplewood 1 development. Richard Shipman, who was vice president of property management in NavPro's New York office when Riley worked there, adamantly declared that Riley had nothing to do with Maplewood 1. Q. Are you aware of what Michael Riley's responsibilities were at the time that you had responsibilities in the New York office for Maplewood 1? Mr. Conyers. Objection. The witness. Michael Riley had responsibility for developing new properties. Therefore, he had no responsibility on Maplewood 1. Ellipsis. Q. Do you recall if Mr. Riley would have had any involvement with either the decision to remove asbestos from Maplewood 1 or the actual removal of asbestos from Maplewood 1? Mr. Conyers. Objection. The witness. Absolutely not. Q. Would Mr. Riley have had any management responsibilities for the Maplewood 1 building? Mr. Conyers. Objection. The witness. Absolutely not. Shipman Dep. 83, 18, 84, 14, X. To counsel cert. Matthew Brooks, the asset manager for Maplewood 1 while Riley worked in the New York office, also confirmed this fact. C. Brooks Dep. 76, 20-23, X. B. To counsel cert. Example B. A string citation in a bulleted list. Still, the case is not unique. A long and unbroken line of Texas cases establishes that an insurer who unqualifiedly defends without a reservation of rights is estopped to disclaim liability for an adverse judgment. These cases began with this court's holding in Automobile Underwriters Inc. Company vs. Mora, in which the court concluded that, when the insurer, with full knowledge of the issues to be tried in the suit against Adair, the insured took exclusive control and management of Adair's defense in such suit, introduced all of the evidence that was before the court on such defense, filed all of the pleadings that were filed for Adair, examined and cross-examined all witnesses, it thereby waived the defensive clauses in the policy of insurance and admitted an unconditional indebtedness in favor of Adair. 40 SW 2D 233, 234 Tex. Civ. App. Dallas 1931, Writ Reft. The more recent cases in this line of authority follow Mora's lead. Pacific Indem, Company vs. Assel Delivery Serve, Inc., 485 F2D 1169, 1175 5th CIR 1973, applying Texas Law, Cert. Denied, 415 U.S. 921 1974 F or estoppel to be effective against a defense of non-coverage even where the insurer has assumed the defense, prejudice must be shown to have been suffered by the party contending estoppel. Pacific's untimely withdrawal less than 1 month prior to trial of the suit, however, certainly does not preclude a finding of prejudice but compels it. Western Casualty and Sir, Company vs. Newell MFG, Company, 566 SW2D 74, 77 Tex. Civ. App. San Antonio 1978, Writ Reft N. R. E. Insurer undertook the defense, its attorneys selected a jury, and an offer of settlement was received with no indication to the insured defendant that a determination of breach of the policy had been made and that insurer had elected to withdraw. It certainly would have been grossly unfair, at that time, to notify defendant that it had decided to withdraw from the defense. Farmers Texas County Mutt, Inns, Company vs. Wilkerson, 601 SW2D 520, 521-22 Tex. Civ. App. Austin 1980, Writ Reft N. R. E. If an insurer assumes the insured's defense without obtaining a reservation of rights or a non-waiver agreement and with knowledge of the facts indicating non-coverage, all policy defenses, including those of non-coverage, are waived, or the insurer may be estopped from raising them. Arkwright Boston MFRs. Mutt, Inns, Company vs. Ares Marine Corp. 932 F2D 442, 445 5th CIR. 1991 The paradigm estoppel situation occurs when the insurer assumes the insured's defense of a claim arguably not covered by the policy without reserving its right to deny coverage. After losing the litigation, the insurer refuses to pay the claimant on the ground of non-coverage and suggests that the claimant collect from the insured. Estoppel is predicated upon the insurer's conflict of interest. It is too likely to be defending the insured in the lawsuit while at the same time formulating policy defenses to deny coverage. Guardian can point to no contrary line of authority. Even so, it is mildly surprising that Guardian could file with this court a 49-page brief without citing, much less distinguishing any of these controlling cases, several of which the court relied on in its earlier opinion. 24. Say something about the critical cases you cite, show how and why they apply. For other cases, be satisfied with a simple citation. Quotable quotes. Only when a case is being cited for a black-letter rule of law is it sufficient to merely cite the case. All other authorities, especially less well-known cases, deserve a minimum of 1 or 2 sentences explaining how the facts in that case or its reasoning apply to your case. If you think back to the research, there were reasons why you chose to make a note about that case as opposed to others. That reason was probably a similarity of facts or clarity of reasoning, which should be highlighted in your brief. Richardson R. Lynn, Appellate Litigation Section 9.8, at 188 1985. In most instances, the purpose of a citation should be explained. A case may be important for its facts, its holding, its reasoning, its approval of other authority, or for an observation that is dictum. It is essential to tell the court exactly how a case is being used. E. Norman Vesey, Chief Justice of Delaware, is quoted in Judges on Briefing 17. Brian A. Garner ed. 2001. Explanation. Make sure to give the context for the important cases you cite. Unless you're stating a well-known or routine point of law, briefly explain how the facts and holding of the cited case apply to your point. The following example, again from Beverly Ray Burlingame of Dallas, contains a case law discussion that typifies truly excellent legal writing. An unusually good example. B. The Supreme Court has broadly interpreted Section 1305 to preempt state law claims. In Morales v. Trans World Airlines, Inc., the Supreme Court construed the scope of Section 1305 preemption broadly, concluding that state deceptive advertising rules could not be enforced against the airlines because they are laws relating to rates, routes, or services of an air carrier. 1. The Morales Court interpreted the phrase, relating to, expansively. The ordinary meaning of relating to is a broad one: to stand in some relation, to have bearing or concern, to pertain, refer, to bring into association with or connection with. Black's Law Dictionary 1158 5th ed. 1979, and the words thus express a broad preemptive purpose. 2. Relying on its interpretation of a similarly worded preemption provision in ERISA, the court noted that such a provision has a broad scope and an expansive sweep. 3. In Morales, the Supreme Court made clear that a state rule or law may be preempted even if 1. It is not specifically addressed to the airline industry, 2. Its effect is only indirect, and 3. It is not inconsistent with federal law. 4. As this court characterized the Morales rule, laws of general applicability, even those consistent with federal law, are preempted if they have the forbidden significant effect on rates, routes, or services. 5. Morales leaves little doubt that a claim based on common law tort or contract is as subject to Section 1305 preemption as any other claim, if it can be demonstrated that it relates to airline, rates, routes, or services. 6. As the Morales Court explained, some state actions may affect airline rates, routes, or services, in too tenuous, remote, or peripheral a manner, to be preempted. 7. But as this court recognized in Hodges, the Morales Court did not state exactly where the line should be drawn. 8. Like the claims in Morales, the claims in this case do not present a borderline question. 9. Instead, enforcing these state law claims would create direct and profound effects on airline services. C. The Ninth Circuit has correctly recognized that state law claims relating to alcohol service are preempted. Relying extensively on Morales, the Ninth Circuit has recently recognized that state law claims related to an airline's service of alcohol are completely preempted. 10. Harris v. American Airlines, which addresses a similar issue to the one raised in this case, was decided after this court's en banc opinions in Hodges and Smith. 11. In Harris, the plaintiff filed an action in state court, alleging negligence and other causes of action. 12. As in the present case, American Airlines removed the case to federal court and filed a summary judgment motion, arguing that the state law claims were preempted and alternatively that no genuine fact issue existed. 13. The trial court ruled that Harris state claims were not preempted, but granted American Airlines summary judgment motion on the merits. 14. On appeal, the Ninth Circuit affirmed on grounds of preemption, declining to reach the merits of the state law claims. 15. As the Ninth Circuit concluded, because these claims related directly to the service of an airline, they were preempted. Harris is complaining directly about the service of alcoholic beverages that she claims caused John Doe's reprehensible conduct. These allegations pertain directly to a service the airlines render, the provision of drink. 16. The issue before the Ninth Circuit was identical to the issue in this case, whether Section 1305(8)(1) of the Federal Aviation Act preempts state law claims against an airline for negligence. 17. As the court correctly concluded, all the plaintiff's state tort claims, including negligence, were completely preempted because they related to an airline's services. 18. The Harris court considered facts similar to those in this case and concluded that an airline cannot be sued under state law for harm caused by a passenger who has allegedly become intoxicated during a flight. 19. Harris sued American Airlines for events that occurred during a flight from Dallas to Portland in 1990. 20. Harris, a passenger in the first-class cabin, claimed that during the flight, American Airlines served 4 drinks to a fellow passenger, whom she believed to be intoxicated. 21. The passenger uttered racial slurs that upset Harris, an African American. 22. The Ninth Circuit's decision in Harris is directly on point. The Millers complained specifically of American Airlines' alleged failure to honor its duty as an alcoholic beverage server and to properly control the conduct of an intoxicated passenger. 23. Consistent with Harris, the Ninth Circuit would almost certainly hold that the state law claims in this case relate to airline services and are therefore completely preempted by Section 1305(8)(1) of the Airline Deregulation Act. Even the dissenting opinion in Harris supports the preemption of the Millers' state law claims. 24. While concluding that preemption was improper, the dissenting judge based his opinion on his belief that the claims were related not to the service of alcohol, but to the airline's failure to ensure the safety of a passenger by protecting her from the abusive conduct of another passenger. 25 In contrast, the Miller's claims cannot be viewed as related to the safety of a passenger because the Millers were not passengers on the flight. Instead, the claims are directly and solely related to the service of alcohol to Barber. Under both the majority and dissenting opinions in Harris, the Miller's state law claims are preempted. 25. Use parenthetical case explanations merely to show why you're citing the cases, not to present your argument. Quotable quotes. Subordination provides the means of distinguishing major points from minor points or bringing in supporting context or details. Andrea Lunsford and Robert Connors, The Saint. Martin's Handbook 310, 1989. Parentheticals are for the facts of unimportant cases. Don't put the facts of an important case in parentheses. Parentheses signal the reader that what's inside them is incidental. Alan L. Dworsky, The Little Book on Legal Writing 96 2d ed. 1992. Parenthetical information is generally recommended when the relevance of a cited authority might not otherwise be clear to the reader. The Blue Book Section 1.5, at 28 17th ed. 2000. Explanation. If citations in the text cause problems, see number 22, then parentheticals in the text cause even greater ones. Although citation parentheticals are terrific in footnotes, they are horrendous in text. Why? Because they drive an even bigger wedge between your sentences. Brief writers often present major chunks of their argument in parentheticals. These case explanations, they often tell me, are important. But the phrase, important parenthetical, is surely an oxymoron. Instead of appearing in parentheticals, the important information ought to be elevated to the text, and the citations should be subordinated, preferably in footnotes. A typically bad example. I. Acquiescence. Acquiescence involves one party's implicit or explicit assurances to another party that induce reliance by the latter party. Conan Properties, Inc. vs. Conan's Pizza, Inc., 752 F2D 145, 153 5th CIR 1985. Acquiescence found where defendant was in business for 5 years and during that time plaintiff visited defendant's restaurant, congratulated them on their venture, and later sent a signed photograph wishing them success while laches is defined as an unreasonable delay in filing suit that results in prejudice to the defendant, id. But drawing a distinction between the two terms can be difficult because they are frequently referred to interchangeably by different courts. See, e.g., University of Pittsburgh vs. Champion Prods, Inc., 686 F2D 1040, 1045 3D CIR, cert. Denied, 459 U.S. 1087, 1982. University's 40-year delay in filing suit against Champion was a silent acquiescence that barred monetary relief. Saratoga Vichy Spring Company, Inc. vs. Lehman, 625 F2D 1037, 1041 2D CIR 1980. In discussion of a laches defense, court held that the Saratoga Vichy Spring Company had acquiesced in the state's use of its mark by failing to make any objection to defendant's use over a period of 7 years. Fluff vs. Eagle White Lead Company, 185 F 769, 772 3D CIR. Plaintiff acquiesced in defendant's use by its silence where defendant had rejected 2 of plaintiff's cease and desist letters, asserted its own adverse rights to the mark and plaintiff took no legal action over a period of 14 years. Cert. Denied, 220 U.S. 615, 1911. Other courts have enunciated a clear distinction between acquiescence and laches. See, e.g., Dial A Mattress Operating Corp. vs. Mattress Madness, Inc., 841 F. Sup. 1339, 1356 EDNY 1994. Distinguishing acquiescence from laches in that acquiescence requires active encouragement of defendant's use whereas laches results from prolonged negligence or inaction. Chase Fed. Savs. And Lone Assen vs. Chase Manhattan Finn. Serves. Inc., 681 F. Sup. 771, 783 SD. Florida. 1987. Distinguishing acquiescence from laches. Carl Zeiss Siftung vs. VEB. Carl Zeiss, Jenna, 293 F. Sup. 892, 917 SDNY. 1968. As distinguished from laches, acquiescence constitutes a ground for denial of relief only upon a finding of conduct on the plaintiff's part that amounted to an assurance to the defendant, express or implied, that the plaintiff would not assert his trademark rights against the defendant. F is modified, 433 F2D 686 2D CIR 1970, cert. Denied, 403 U.S. 905 1971. Part D. Editing for brisk, uncluttered sentences. 26. Relax the tone. Eliminate the jargon known as legalese. Quotable quotes. Simple English is no one's mother tongue. It has to be worked for. Jacques Barzin, Teacher in America 47, 1945. I am the last one to suppose that a piece about the law could be made to read like a juicy sex novel or a detective story, but I cannot see why it has to resemble a cross between a 19th century sermon and a treatise on higher mathematics. Fred Rodell, Goodbye to Law Reviews, Revisited, 48 VA. L. Rev. 279, 282, 1962. In jargon nobody ever does anything, feels anything, or causes anything, nobody has an opinion. Opinions are had, causes result in, factors affect. Everything is reduced to vague abstraction. The writer can even abolish himself, for jargon never sounds as though anybody had written it, it seems simply to come about, as from a machine, and it talks mechanically of things that come about, through some indistinct interaction of forces. Robert Waddell, Formal Prose and Jargon, in Modern Essays on Writing and Style 84, 89 Paul C. Wermuth ed. 1964. The major fault in modern prose generally is stuffiness. For most people, in most situations, in the writing of everyday serious expository prose, it is the stuffy voice that gets in the way. The reason it gets in the way, I submit, is that the writer is scared. If this is an age of anxiety, one way we react to our anxiety is to withdraw into omniscient and multisyllabic detachment where nobody can get us. Walker Gibson, Tough, Sweet and Stuffy 107, 1966. I'm no English professor, and I don't expect my literary preferences in argumentative writing to coincide with those of others. I can only repeat that good, clear, forceful English is essential. Frederick B. Wiener, Briefing and Arguing Federal Appeals 67, Reverend ed. 1967. Legalize is worse than smoking cigarettes. To kick the habit is extremely hard. So don't kid yourself. If you want to write plain English, you'll have to learn how. You'll have to study it as if it were Spanish or French. It'll take much work and lots of practice until you've mastered the skill. Rudolph Flesch, How to Write Plain English, a book for lawyers and consumers 2, 1979. Attitudes need to change more than rules of composition need to be memorized. Lawyers must be convinced that there is no purpose, or value, in sounding archaic. This is a tall order. It will take an emotional, almost psychological, pitch to teach many attorneys that there is nothing wrong with sounding like a citizen of the second half of the 20th century. You are no less a lawyer for being understandable. Christopher T. Lutz, Why Can't Lawyers Write? In Appellate Practice Manual 167, 177 Priscilla A. Schwab ed. 1992. Play a game with yourself, see how long a list you can make of lawyers' words we could perfectly well do without. Examine your language from this day on. Strip out anything that sounds lawyerish. Find some other way of saying what you want to say. Work hard at it because it really matters. The golden rule is clear, do not sound like a lawyer any more than is absolutely necessary. Keith Evans, The Golden Rules of Advocacy 17, 1993. If you have fallen under the spell of legalese, words take on a certain institutional stiffness. When words such as whereby, thereby, heretofore, and wherein creep into your vocabulary, put down your pen, take a few deep breaths, and read your work aloud. Your ear will soon tell you just how awkward and antiquated these phrases are. Gary Blake and Robert W. Bly, The Elements of Technical Writing 73, 1993. I am particularly careful to avoid jargon, and to write simply and clearly. For certain types of writing a high level of technicality is unavoidable, but in general it is the second-rate intellect that cultivates a pretentious vocabulary and a solemn and portentous style. Richard A. Posner, How I Write, 4 Scribes J. Legal Writing 45, 49, 1993. For 100 years, good lawyers have been writing without all the garbage and in a simple, direct style. Lynn N. Hughes is quoted in Brian A. Garner, Judges on Effective Writing, The Importance of Plain Language, 73 Mich. B.J. 326, 326, 1994. The idea is to avoid any word that does not command instant understanding. Your words should be transparent vehicles that let the reader see your ideas without straining to grasp the meaning. Most of the concepts you struggle to master in law school can be grasped by the average 12-year-old. It is the vocabulary training that makes it such a drudgery. James W. McElhaney, Writing to the Ear, Abba J., December 1995, at 74, 76. When it comes to plain talk, lawyers are the worst. Most speak and write as if they live in a repository for dead bodies. When they write briefs that some poor trapped judge must read, they fill them with heavy, gray, lifeless, disgustingly boring word gravel, piles of it, tons of it. When I read most briefs I want to scream. I want to throw the brief out the window and jump. If I could find the author, and had the power, I would make the villain eat the thing a page at a time without salt or catsup. Jerry Spence, How to Argue and Win Every Time 105, 1995. Explanation. Pursuant to the above referenced quotations, and each and all of the ideas embodied therein, notwithstanding anything to the contrary herein contained. Did you know that in every state in which judges have been polled, they've overwhelmingly said that they'd like lawyers to stop using legalese? Did you know that they consider lawyers who use legalese to have little prestige, to be less smart, and to be lower in their academic rankings? Any phrase that smells like jargon should be immediately suspect. This means that you might have to let go of some cherished phrases. What you'll find, though, is that you'll not only communicate better, but also think more clearly. Some before and after examples. Example A. Before. To the Honorable Judge of said court. Comes now Guy Walt Williams, plaintiff in the above styled and numbered cause, and files this his response to defendant's motion for summary judgment and would respectfully show unto the court as follows. After. In response to Mitsubishi's summary judgment motion, Guy Walt Williams will show that there remain no fewer than 17 genuine issues of material fact in this case. One of the principal factual issues is. Example B. Before. Pursuant to leave of court granted on March 4, 1992, General Golf Inc. has, contemporaneously with the filing of this letter brief, supplemented the summary judgment evidence before this honorable court with an additional affidavit from Lynn Presby dated March 8, 1992, hereinafter the Presby affidavit. After. With the court's permission, General Golf has today supplemented the summary judgment evidence with Lynn Presby's affidavit. Example C. Before. Wherefore, premises considered, defendant requests that final judgment be entered against plaintiffs on the matters set forth herein, that defendant recover from plaintiffs all of defendant's reasonable and necessary attorneys' fees and costs and post-judgment interest at the highest rate allowed by law, and such other and further relief to which defendant may show itself to be justly entitled. After. Defendant therefore requests final judgment against plaintiffs, together with attorneys' fees and costs, plus post-judgment interest at the highest lawful rate, and any other relief to which it may be entitled. 27. Avoid over-particularization. Quotable quotes. True brevity of expression consists in everywhere saying only what is worth saying, and in avoiding tedious detail about things that everyone can supply for himself. This involves correct discrimination between what is necessary and what is superfluous. Arthur Schopenhauer, On Style, 1851, in Theories of Style in Literature 251, 263, Lane Cooper ed., 1923. A great deal of good advice is given about the need for detail in writing, but one should not add so many details that the main line of discussion is buried under them. Sumner Ives, A New Handbook for Writers 316, 1960. You must state the facts of the case in your brief as you yourself would wish to read them, the introductory summary first, the details later, in order to get a clear, consecutive, understandable picture of what the case is really about. Frederick B. Wiener, Briefing and Arguing Federal Appeals 45, Reverend ed. 1967. Being precise doesn't mean compiling details, it means selecting details. Michael Alley, The Craft of Scientific Writing 35, 1987. A reader should not be forced to confront details before the writer has provided a framework for understanding. William A. Bablich, Writing to Win, Complete Law. Winter 1988, at 11. I like a brief that shows the signs of an organizing and discriminating mind. No swamping with unnecessary facts, a brief so written that I can quickly scan it in preparation for oral argument but can find further riches if I have been assigned the opinion to write. Frank M. Coffin, On Appeal, Courts, Lawyering, and Judging 120, 1994. People who lavish unnecessary information on their conversational partners are known as bores. They can be recognized by their detailed accounts of summer vacations and long-winded descriptions of common experiences. The basic challenges of writing resemble those of conversation. In both, the trick is to keep things moving forward without skipping anything important. Peter Richardson, Style, A Pragmatic Approach 2-3, 1998. Explanation. Judge Thomas Gibbs G., the great Fifth Circuit judge, gave this vice its name. In his judicial style sheet, he wrote, "No overparticularization, which can throw your reader off by causing him to try to keep track of things that do not matter." Judge G had diagnosed the most common literary disease from which legal writers suffer, the progressive inability to winnow important from unimportant facts. Here's my test. If it isn't necessary to understanding the issues, or if it doesn't add human interest, then leave it out. A before and after example. Before. What follows begins a procedural history section of a motion for summary judgment, but the history has nothing to do with why summary judgment is appropriate. And the dates have nothing to do with anything in the motion. Procedural history. Plaintiff, Robin B. Sorter, administratrix of the estate of Walter E. Sorter, commenced this action against the defendant, Chuden Mutual Insurance Company Chuden, by filing a complaint in the Superior Court of Connecticut on or about June 22, 1994. Chuden was served on or about July 12, 1994. On August 3, 1994, Chuden removed to this court. On September 24, 1994, Chuden filed its answer in affirmative defenses. See the affidavit of John T. Green, Jr. Green Affidavit, paragraph Mark 2. Chuden now seeks summary judgment pursuant to Fed. R. Civ. P56 with respect to count 1 of Sorter's complaint and seeks dismissal pursuant to Fed. R. Civ. P12B6 of counts 2 through 5 for failure to state a claim upon which relief can be granted. After. The better strategy would be to begin with the deep issues. Introduction. In deciding Chuden's summary judgment motion, the court faces two issues. 1. Statement question. 2. Statement question. 28. Populate your sentences. Use real names not procedural labels for parties. Quotable quotes. And nothing adds more realism to a story than names, nothing is as unrealistic as anonymity. Imagine a story whose hero has no name. If you ever read Franz Kafka's nightmarish novels about K, you will know what namelessness does to a story. So name your characters. Rudolf Flesch, The Art of Readable Writing 80, 1949, Reaper. 1967. It is easier for us, or at least me, to remember the parties by name. I have difficulty in remembering who was petitioner, respondent, appellant, relator, and the like. Joe R. Greenhill, Advocacy in the Texas Supreme Court, Tex. B.J., June 1981, at 624, 628. Whenever you can, write about people. In fact, adding people to your sentences may do more to make them clear than any other writing habit you could develop. Maxine Hairston, Successful Writing 115, 2D ed. 1986. Speak of real people, not of categories. The plaintiff, defendant, and witnesses have names. Use them. Michael Tiger, Federal Appeals, Jurisdiction and Practice 333, 2D ed. 1993. The idea was to refer to people as plaintiffs, and defendants, or petitioners, and respondents, instead of using their real names. That way, we lawyers could drain all the humanity out of the case and focus on pure questions of rights and duties. But it makes the whole story harder for anyone to follow, even lawyers and judges who have been doing it for years. Use the real names whenever you can. James W. McElhaney, Writing to the Ear, Abba J., December 1995, at 74, 77. Imagine a world in which all novelists use the terms protagonist and antagonist as the names of their principal characters. Assume that playwrights and screenwriters did the same. The stories would grow tedious, wouldn't they? Legal writers have traditionally spoiled their stories by calling people plaintiff and defendant, appellant and appellee, or lesser and lessee. It's a noxious habit that violates the principles of good writing. Brian A. Garner, Legal Writing in Plain English 44, 2001. Explanation. By putting people in your sentences, you'll make your briefs clearer and more memorable. Even in a dispute between, say, two insurance companies, it's better to refer to Allstate and CNA than to plaintiff and defendant or appellant and appellee. And don't try to personalize your client and dehumanize your adversaries by using the real name for the client and a procedural label for the adversaries. Instead, use real names for both parties and let your arguments do the talking. See example A. That helps judges keep track of who's who. There's a reason, after all, why Rule 28D of the Federal Rules of Appellate Procedure enacts this principle. References to parties. In briefs and at oral argument, counsel should minimize use of the terms appellant and appellee. To make briefs clear, counsel should use the parties, actual names or the designations used in the lower court or agency proceeding, or such descriptive terms as the employee, the injured person, the taxpayer, the ship, the stevedore. Asterisk. The same is true at the trial court level. But the tip does have two exceptions. First, if an opponent is extremely sympathetic, you may wish not to remind the court repeatedly just who that person is. Second, if multiple parties are aligned in such a way that a single name is inaccurate, that is, the defendants or banks, insurance companies, and individuals as well, then you may have to say, defendants. But do it as a last resort. Some before and after examples. Example A. Before. Prior to October of 1992, plaintiff became addicted to narcotics and had purchased cocaine on company premises for a number of years. Also prior to October of 1992, plaintiff claims that the company denied his requests for substance abuse treatment in breach of their agreement. On October 2, 1992, a co-employee promised to share cocaine with plaintiff if plaintiff would obtain and deliver the cocaine to the co-employee. Plaintiff maintains that had he received the substance abuse treatment that had been refused, plaintiff would not have obtained the cocaine as requested. Plaintiff was discharged effective October 3, 1992, for selling narcotics on company premises. After. Sometime before October 1992, Kent Smith became addicted to narcotics and had started buying cocaine while at work for Wheelock, Inc., on company premises. He did this for several years. Although Smith was an at-will employee, he now claims that Wheelock breached an employment agreement by denying his requests for substance abuse treatment. On October 2, a coworker suggested that if Smith would get some cocaine, the two could share it. The next day, Smith got the cocaine, was discovered, and was promptly fired. He now claims that if he had gone through a substance abuse program, he wouldn't have gotten the cocaine as requested. And, of course, Smith says he wouldn't have been fired. Example B. The brief writer represents the city of Amarillo, the defendant in a Section 1983 civil rights action. The statement of facts is drawn from an appellate brief assigning as error the omission of a requested charge. Record citations are omitted. Instead of repeatedly referring to plaintiff, the writer should have called the opponent burden. Plaintiff is a Teflon name. Bad facts don't stick to plaintiff the way they do to burden. Before. Nature of the action. This is a civil action brought pursuant to 42 U.S.C. Section 1983 by plaintiff against 1. The City of Amarillo, 2. Dory L. Fisk, Director of the Department of Public Safety, and 3. Individual police officers. In his complaint, plaintiff claims he was 1. Falsely arrested, 2. Exposed to excessive force handcuffing, 3. Falsely imprisoned, 4. Deprived of due process, and 5. Deprived of rights secured to him under 42 U.S.C. Section 1983. Plaintiff also asserts state law claims for 1. Assault and battery, 2. Malicious prosecution, 3. Intentional infliction of emotional distress, 4. Defamation, and 5. Common law conspiracy. Summary of facts. This case arises out of the plaintiff being arrested for driving while intoxicated (DWI) at approximately 2:20 a.m. on Saturday, November 20, 1996, by Officer Gibson. Officer Gibson observed plaintiff's vehicle coming westbound in the 3700 block of Paramount Avenue in Amarillo toward the four-way stop sign at the corner of Paramount and St. John's. Plaintiff did, in fact, stop at the stop sign and then remain stopped there for what Officer Gibson felt was a rather lengthy period of time. Officer Gibson then observed plaintiff proceed 1 block to the next four-way stop sign and also stop there for a rather long period of time. Officer Gibson also noticed that when plaintiff was stopped at the stop sign, plaintiff opened the driver's side door of his pickup truck and was leaning out of the vehicle. This leaning out of the vehicle at this hour of the morning concerned Officer Gibson that plaintiff was possibly intoxicated and he followed plaintiff. Officer Gibson observed that as plaintiff left the second stop sign, at Lakeside Drive in Marlow, plaintiff was driving straddling the line with his wheels, straddling the center line or the center stripe indicator of the roadway. Officer Gibson observed that plaintiff would periodically get back into the correct lane of traffic and then a little bit later, he would tend to weave off and steer down the center line again. Officer Gibson also observed that as plaintiff began going southbound on Marlow, after he crossed the intersection of Stanton Avenue and Marlow, plaintiff was in the center lane at this time and there was a vehicle in front of plaintiff in the center lane. Plaintiff changed lanes to the right-hand lane without signaling and cut back in front of the car and proceeded across the 3 lanes on this 3-lane, one-way street into the left-hand lane of traffic. From there, plaintiff crossed Hillcrest, continuing to periodically leave his lane of traffic. As he crossed Hillcrest, Officer Gibson made the decision to attempt to stop him. Officer Gibson activated the strobe lights and the alternating flashing high beams on his vehicle and radioed in that he was attempting to stop plaintiff's vehicle. Rather than immediately pulling over, plaintiff continued driving for another 5 blocks, at which time Officer Gibson decided plaintiff was not aware of the patrol vehicle with all its lights activated, and Officer Gibson turned on his siren. When the sirens went on, plaintiff pulled over in the parking lot of a medical clinic at the intersection of Marlow and Iberville. Officer Gibson approached the plaintiff's vehicle and asked him where he had come from. Plaintiff told him that, 549 words. After. Nature of the case. In this Section 1983 action, Randall Burden has sued the city of Amarillo, D'Oriel Fisk, director of the Department of Public Safety, and 3 police officers Gibson, Pyle, and McAllister. In his complaint, Burden has stated claims for false arrest, excessive force, false imprisonment, deprivation of due process, violations of 42 U.S.C. Section 1983, assault and battery, malicious prosecution, intentional infliction of emotional distress, defamation, and common law conspiracy. Summary of facts. This case arises out of Burden's arrest by Officer Brent Gibson for driving while intoxicated at about 2:20 a.m. on Saturday, November 20, 1996, in Amarillo. Officer Gibson first saw Burden's pickup truck coming westbound on Paramount Avenue toward the four-way stop sign at the corner of Paramount and St. John's. Burden stopped at the stop sign, but then remained there for what Officer Gibson felt was an unusually long time. Officer Gibson then watched Burden proceed 1 block to the next stop sign and stop there for an unusually long time as well. Officer Gibson also noticed that while Burden was stopped, he opened the door of his truck and leaned outside. This caused Officer Gibson to suspect that Burden might be intoxicated, so he followed Burden. Burden continued driving, but quite erratically. After he crossed the center line several times, Officer Gibson decided to stop him. Gibson turned on his patrol car's strobe lights, flashed his high beams, and radioed in that he was stopping Burden's truck. But instead of pulling over immediately, Burden continued driving for another 5 blocks. Officer Gibson then decided that Burden was unaware of the patrol car with all its lights activated, so he turned on his siren. When the siren went on, Burden pulled over into the parking lot of a medical clinic at the intersection of Marlow and Iberville. Officer Gibson approached Burden's truck and asked him where he had come from. Burden replied that, 321 words. 29. Work hard to replace be verbs with action verbs. Quotable quotes. If you go through any newspaper or magazine and look for active, kicking verbs in the sentences, you will realize that this lack of well-used verbs is the main trouble with modern English writing. Almost all nonfiction nowadays is written in a sort of pale, colorless sauce of passives and infinitives, motionless and flat as paper. Rudolf Flesch, The Art of Plain Talk 67, 1946. As so besets us, we are willing to sit back on our ises, that we not only replace active with passive voice, but active verbs with sedentary ones. Sheridan Baker, Scholarly Style, or the Lack Thereof, 1956, in Perspectives on Style 64, 68 Frederick Candelaria ed., 1968. The stronger the verb the better the sentence. No generalization is wholly true, as Disraeli reminds us, including this one, but you will find it of great practical use to husband verbs. They will repay attention 100-fold, for they flash pictures across the mind, reduce our craving for adjectives if they do not deliver us from it entirely, and force us to reckon with structure. Charles W. Ferguson, Say It with Words 117, 1959. For those persons willing to make a substantial effort to improve their writing, I suggest the following exercise. Choose 8 to 10 consecutive sentences from any random text and count the total number of verbs. Record this as the denominator of a fraction. Then count the copulas be verbs or passives and record that number as the numerator. If the fraction exceeds 1/3, consider the number of copulas as excessive. Lester S. King, Why Not Say It Clearly 27, 1978. Verbs act, verbs move, verbs do, verbs strike, soothe, grin, cry, exasperate, decline, fly, hurt, and heal. Verbs make writing go, and they matter more to our language than any other part of speech. Donald Hall, Writing Well 83, 4th ed., 1982. Although the verb to be in all its forms is, am, was, were, will be, have been, and so on remains the central verb in our language, careful writers use it sparingly. Maxine Hairston, Successful Writing 118, 2d ed., 1986. Resort to forms of to be only when an arduous search turns up no alternative. In 9 sentences out of 10, a better verb can be found, and the entire shape and structure of the sentence will immediately improve once an is or was or has been has made its exit. Christopher Lash, Plain Style 76, Stuart Weaver ed., 2002. Explanation. Be verbs lack muscle. When you overuse them, your writing becomes flaccid, even inert. As an editorial exercise, try highlighting every be verb and converting it into a stronger verb. I did it with this book. Perhaps I missed opportunities to replace still more be verbs than I did, but the text certainly improved with the changes I made. A before and after example. Before. There is no classification in the savings clause, other than the deadline for filing cases that are accepted from the amendment. Such a deadline is reasonable. Every statute typically has a date upon which it is effective, and therefore automatically distinguishes between those it affects and those it does not. The deadline in the savings clause is analogous to an effective date of a statute. Certainly it cannot be argued that such a deadline is a classification in violation of Art. 3, Section 56 of the Texas Constitution. Moreover, even if the deadline can be characterized as a classification, it operates equally on all within the class. Any and all such cases throughout the state that were on file prior to May 1, 1993, were saved from the amendment. 129 words, 10 be verbs, 4 passive voice constructions. After. The savings clause contains no classification other than the deadline for filing cases to which the amendment does not apply. This deadline operates as an effective date, much like the effective date that every statute contains to distinguish between persons it affects and those it does not. Certainly the deadline does not amount to a classification that violates Article 3, Section 56 of the Texas Constitution. Even if the deadline did classify, though, the classification operates equally on all class members. By virtue of the savings clause, all cases filed before May 1, 1993 fall outside the amendment. 98 words, no be verbs, no passive voice constructions. 30. Know what the passive voice is, and minimize it. Quotable quotes. In its modern uses, the passive fails to present an impression of swift action or vividness. It is the staple of the report, the research monograph, and the catalog. Margaret M. Bryant and Janet Rankin Aiken, The Psychology of English 144, 1940. The difference between an active verb style and a passive verb style, in clarity and vigor, is the difference between life and death for a writer. William Zinsser, On Writing Well 111, 5th ed. 1994. Although the passive voice has its occasional legitimate uses, usually, when the actor is either unimportant or unknown, its frequent use makes a piece of writing much less interesting and readable. Brian A. Garner, A Dictionary of Modern Legal Usage 643, 2d ed. 1995. Explanation. Many lawyers talk about passive voice without knowing exactly what it is. In fact, many think that any be verb signals passive voice, as in. The doctrine is applicable to this case. But that sentence is actually an active voice, even though it's badly in need of editing. Most professional editors would change as applicable to applies, but they wouldn't call it passive because it's not. It's just a flabby be verb. The point about passive voice is that the subject of the clause doesn't perform the action of the verb. Instead, you back into the sentence. Passive, the deadline was missed by defense counsel. Active, defense counsel missed the deadline. And, of course, in the passive form, it's possible to omit the actor altogether, a prime source of unclarity. Sometimes it amounts to responsibility dodging. Passive, the deadline was missed. As anyone who follows political discourse knows, the passive voice is a staple of politicians. The unfailing test for passive voice is this: you must have a be verb or get plus a past participle, usually a verb ending in ed. Thus, constructions such as these are passive. Image. Sometimes, though, the be verb won't appear. It's simply an implied word in the context. For example, recently I heard it suggested by a client that national insurance should cover all legal fees. Grammatically speaking, that sentence contains the implied verb being after the word it, so it's in the passive voice. To make it active, you'd write: recently I heard a client suggest that national insurance should cover all legal fees. What's the real problem with using passive voice? There are three. First, passive voice usually adds a couple of unnecessary words. Second, even if it doesn't add those unnecessary words, it fails to say squarely who has done what. That is, a by phrase is necessary to show the actor the brief was filed versus the brief was filed by Lori Vaughn, Inc. Third, the passive subverts the normal word order for an English sentence, thereby making it harder for readers to process the information. The opposite of each of those liabilities appears as a gain in the active voice. It saves words, says directly who has done what, and meets the reader's expectation of an actor-verb-object order. Sometimes, of course, you'll be justified in using the passive voice. There's no absolute prohibition against it, and anyone who tried to follow such a prohibition would spoil a piece of writing. In his fine book Mightier Than the Sword, Ed Good identifies 8 situations in which you'll sometimes need the passive. When the actor is unimportant. When the actor is unknown. When you need to put the punch word at the end of the sentence, see number 36. When you want to hide the actor's identity. When you want to avoid sexist language, see number 56. When the focus of the passage is on the thing being acted upon. When you need to generalize without using one as the subject. When the passive simply sounds better. Asterisk. Still, professional editors find that these 8 situations don't account for more than about 15 to 20% of the contexts in which the passive appears. That means you ought to have a presumption against the passive, unless it falls into one of the categories just listed. The following examples typify what you'll see in many briefs. Some before and after examples. Example A. Before. Commercial success is considered relevant to the question whether an invention was obvious under the rationale that competitors would have been economically motivated to make the invention sooner if it had been truly obvious. After. Commercial success is relevant to the question whether an invention was obvious, because competitors would have had an economic incentive to make the invention sooner if it had been truly obvious. Example B. Before. To support a trespass action when the injurious acts that are complained of were not actually committed by the defendant himself, the person who committed the acts must be either employed, paid, or controlled by the defendant in order to hold him liable. After. For the defendant to be liable in a trespass action when the defendant did not personally commit the acts complained of, the defendant must have employed, paid, or controlled the person who did commit them. Example C. Before. Whether the Bergdorf's gift to the library must be returned because the Bergdorf Lecture Hall has been renamed is an entirely different matter that in no way addresses the actions that were taken by the defendants prior to the time when the complaint was filed. After. Whether the library must return the Bergdorf's gift because it has renamed the Bergdorf Lecture Hall is an entirely separate matter from the defendants' actions before the filing of this lawsuit. 31. Uncover buried verbs, especially words ending in tion. Quotable quotes. Turgid flabby English is full of abstract nouns. The commonest ending of abstract nouns is tion, and to count the ion words in what one has written, or, better, to cultivate an ear that without special orders challenges them as they come, is one of the simplest and most effective means of making oneself less unreadable. It is as an unfailing sign of a newly abstract style that a cluster of ion words is chiefly to be dreaded. H.W. Fowler, A Dictionary of Modern English Usage 640, Ernest Gowers ed. 2d ed. 1965. Wordy writing not only droops from weak verbs but sags under bulky nouns, especially long latinate ones with endings like tion and maintenance. Claire K. Cook, Line by Line, How to Improve Your Own Writing 6 1985. To Michelangelo, every piece of marble had a form hidden in it. He had only to chisel through to reveal a Pietà or a Moses. So it is with verbs hidden in and weighted down by noun forms like these. Negotiation, administration, documentation, utilization, transmittal. Mr. Jones had the company's authorization, is correct, but the company authorized Mr. Jones is better. They made a determination of, is correct, but they determined, is better. Miriam Cass, The Both Theory of Persuasive Writing, in Appellate Practice Manual 179, 180-81 Priscilla A. Schwab ed. 1992. Why uncover buried verbs? 3 reasons are detectable to the naked eye. First, you generally eliminate prepositions in the process. Second, you often eliminate be verbs by replacing them with so-called action verbs. And third, you humanize the text by saying who does what, an idea often obscured by buried verbs. The 4th reason is not detectable to the naked eye. In fact, it is the sum of the 3 reasons already mentioned. By uncovering buried verbs, you make your writing much less abstract. It becomes easier for readers to visualize what you're talking about. Brian A. Garner, A Dictionary of Modern Legal Usage 123 2D ed. 1995. Explanation. A buried verb isn't really a verb at all. It's a noun created by a verb. The verb has been buried in the longer noun. Usually, a buried verb ends in one of the following suffixes: tion, scion, ment, ence, ants, ity. Whenever the true verb will work in context, the better choice is to use it instead of the buried verb. Thus, image. Why do lawyers like buried verbs so much? It might have something to do with Jeremy Bentham, who wrote about what he dubbed the noun-preferring principle. Bentham thought that you should always choose a noun over a verb. But there's no reason to think that Bentham carried any particular weight on this point. He was probably describing an age-old lawyerly bias. As a group, we've historically preferred writing about static things, abstract static things, over people's actions. And that should tell you something about why so much legal writing is as dull as it is. If you want to be fresh and punchy and memorable, though, you'll have to try the verb-preferring principle. Given the choice between a noun and a verb, choose the verb. Given the choice between a ion word and an ing word, choose the ing word. Almost every time you do it, you'll eliminate a prepositional phrase, you'll avoid be verbs, and you'll force yourself to be more concrete about people performing actions, not, mind you, about the performance of actions. Some before and after examples. Example A. Before. Zellman alleges that the Caswell Company's actions are in violation of the Americans with Disabilities Act. After. Zellman alleges that the Caswell Company's actions violate the Americans with Disabilities Act. Example B. Before. The court placed principal reliance on its findings that the existence of official signs and state and national flags on the building gave the appearance of a government stamp of approval on discriminatory conduct and that the city, through its lease, derived a financial benefit from the restaurant's discrimination. After. The court relied principally on its findings that signs, as well as state and national flags, hung from the building, making it appear that the government approved discriminatory conduct and that the city, through its lease, benefited financially from the restaurant's discrimination. Example C. Before. Plaintiff's lawsuit is predicated on her dissatisfaction with the company's response to her complaint regarding her former supervisor, Monty Crump. After. Moore sued because she was dissatisfied with how the company responded when she complained about her former supervisor, Monty Crump. Example D. Before. The IRS has suspended the issuance of determination letters with respect to the qualification of an ESOP under the Tax Reform Act of 1986. After. The IRS has stopped issuing determination letters on whether an ESOP qualifies under the Tax Reform Act of 1986. Example E. Before. Those allegations include violations of failing to provide documentation specifically required by the Act, failing to provide proper identification showing the name of a professional solicitor during solicitation campaigns, failing to sign required documentation prior to filing same, and entering into contracts with professional solicitors without the benefit of registration. After. In particular, the Berber Club failed to provide documents specifically required by the Act, failed to identify the professional solicitor properly while soliciting, failed to sign required papers before filing them, and contracted with unregistered solicitors. 32. When given the choice between a passive voice verb and a buried verb, choose the passive voice. Quotable quote. TE language is overrun by a plague of nouns, most of them ending in ion, with the result that formal writing, reports, public speaking, scholarship, even fiction becomes a string of nouns weakly tied together by prepositions and connective phrases of the type, as far as concerned, and, in terms of. This sort of writing, easy to write and dull to read, is the surest protection against the critical analysis of thought. Jacques Barzin, The House of Intellect 233, 1959. Though long neglected in books about writing, buried verbs ought to be a sworn enemy of every serious writer. In legal writing, they constitute a more serious problem even than passive voice, whether in analytical writing, persuasive writing, or drafting. Brian A. Garner, A Dictionary of Modern Legal Usage 123 2D ed. 1995. Explanation. We hear a lot about passive voice. For the most part, it deserves its bad press. But we don't hear much about buried verbs or nominalizations, to use the English teacher's jargon. This is a curious state of affairs because every observant editor notices the frequency with which you must choose either the buried verb or the passive voice construction. And 90% of the time when you're faced with this dilemma, the better choice is passive voice. See for yourself in the examples below. Some before and after examples. Example A. Before. The Internal Revenue Code provides rules governing the taxation of ESOPs. After. The Internal Revenue Code provides rules governing how ESOPs are taxed. Example B. Before. Abraham's transfer took place on July 18, 1995, prior to the announcement of any layoffs. After. Abraham's transfer took place on July 18, 1995, before any layoffs were announced. Example C. Before. Prior to the promotion of Ms. Hall to the position of Laboratory Assistant Administrator, she worked as a medical technologist in the lab. After. Before Ms. Hall was promoted to Laboratory Assistant Administrator, she worked as a medical technologist in the lab. Example D. Before. Horn alleges that the Commissioner did not inform Horn that, 6 months after the completion of the audit, the General Assembly revised the revenue statutes. After. Horn alleges that the Commissioner did not inform him that, 6 months after the audit was completed, the General Assembly revised the revenue statutes. Example E. Before. Wholesale Silks asks the arbitrator to issue an order denying Brogna's motion to dismiss and requiring Brogna to serve an answer within 7 days after service of the arbitrator's ruling. After. Wholesale Silks asks the arbitrator to deny Brogna's motion to dismiss and require Brogna to serve an answer within 7 days after being served with the arbitrator's ruling. 33. Eliminate unnecessary prepositional phrases, especially those beginning with of. Quotable quotes. It is certain that our sentences can easily sound like a stick being drawn along railings. We could condone our clusters of little prepositions if they firmly surrounded and placed their nouns in an indisputable context, but they have multiple meanings, and when used irresponsibly they jam the traffic of their sentences. For me, for example, for years the question has been as to whether in the event of, is the kind of rambling that constitutes the real menace of the preposition, not whether it is used to end a sentence with. Basil Cottle, The Plight of English 13, 1975. The overuse of prepositions is a severe and extremely common fault. Indeed, if I wanted to offer a single rule for improving the quality of writing, I would unhesitatingly say, reduce the number of prepositions. Lester S. King, Why Not Say It Clearly 34, 1978. However innocuous it may appear, the word of is, in anything other than small doses, among the surest indicators of flabby writing. The only suitable vaccination is to cultivate a hearty skepticism about its utility in any given context. If it proves itself, fine. Often, though, it will fail to do so. Brian A. Garner, A Dictionary of Modern Legal Usage 612 2d ed. 1995. Explanation. When Dr. John R. Trimble, the great editing maven at the University of Texas, first told me that we should encourage legal writers to focus on eliminating as many of phrases as possible, I scoffed. The advice seemed simplistic. The amazing thing is that it works quite well, in passage after passage. When I was working on the Federal Rules of Appellate Procedure in 1995, I encountered the phrase the principal office of the Clerk of the Court of Appeals. In the revision adopted in 1998, that phrase became the Circuit Clerk's principal office. It went from 11 words to 5. You won't always cut more than half the words in a phrase, but your savings will usually be significant. And once you sensitize yourself to the flabbiness that of signals, you'll achieve a much leaner style. Other prepositions help propagate clutter, to be sure, but of is the prime offender. Scrutinize its every appearance. Some before and after examples. Example A. Before. Defendant is contending that delays on the part of Penny have resulted in delays by defendant. 16 words, 4 prepositions. After. Costco claims that Penny's delays have caused Costco's delays. 9 words, no prepositions. Example B. Before. The facts of this case indicate that the Pennate Corporation, of which Burgos was the CEO, allegedly bribed certain officials of the State Department of Taxation and Finance to resolve some tax problems of the corporation. During the course of the investigation into the alleged illegal activity, the SEC alleged in its indictment of Burgos that he failed to disclose in the proxy statement of the corporation that he was a member of a conspiracy to bribe said officials. 79 words, 12 prepositions. After. The facts show that the Pennate Corporation, of which Burgos was the CEO, allegedly bribed certain state officials to resolve some corporate tax problems. While investigating the alleged illegal activity, the SEC indicted Burgos, alleging that he failed to disclose in the Pennate Corporation's proxy statement that he had conspired to bribe those state officials. 55 words, 2 prepositions. Example C. Before. In this case, there is a substantial risk that the current collection arrangement with Wolverton will be deemed a violation of the FDCPA. Many courts have found that the use of another party's letterhead, without actual participation by that party in the collection of the debt, is a deceptive practice in violation of sections 1692E and 1692J, subjecting both the creditor and the flat rater to liability. 67 words, 10 prepositions. After. The current collection arrangement with Wolverton may well be found to violate the FDCPA. Many courts have found that using another party's letterhead, without that party's actually helping to collect the debt, is a deceptive practice that violates sections 1692E and 1692J, subjecting both the creditor and the flat rater to liability. 52 words, 3 prepositions. 34. Don't separate a short subject from its verb with a modifying phrase. Instead, start the sentence with the modifier. Quotable quotes. Be compact, do not put a strain on your reader's memory by widely separating parts of a sentence that are closely related to one another. Sir Ernest Gowers, The Complete Plain Words 37, 1954, Reaper. 1964. Don't interrupt subject and verb with intervening subordinate constructions and modifiers. Walker Gibson, Tough, Sweet and Stuffy 108 1966. Whenever you write a long sentence, be sure that you have not so separated the subject and the verb that the reader forgets who before learning what. Miriam Cass, The Both Theory of Persuasive Writing, in Appellate Practice Manual 179, 183 Priscilla A. Schwab ed. 1992. Explanation. The core words in a sentence are the subject and the verb. They are related both in sense and in grammar. And related words should go together. If you separate them very much, the sentence goes asunder. Although it's sometimes necessary to modify a subject with an interruptive phrase, and to highlight the phrase by doing so, see number 57, writers too often lump words between the subject and verb with no special purpose in mind. Look at the first example below. Notice how long it takes to get from each subject to its corresponding verb, all the qualifiers get in the way. Indeed, the writer had the same problem matching parts of speech. Try putting any modifying phrases at the beginning of the sentence, so that the subject and verb can remain together. Amateur writers consider the move counterintuitive, but it works. A typically bad example. Consideration of the legal and factual elements of their claims and the corresponding defenses, as well as the language of the insurance policies at issue, reveals that plaintiffs' knowledge of the extent, if any, to which its activities and operations resulted in, or were likely to result in, environmental contamination, as well as the knowledge of when, if ever, such contamination occurred and when plaintiffs first had knowledge of such contamination, are read as of central relevance. Some before and after examples. Example A. Before. Defendant, in his motion, has represented to the court that he has complied with all outstanding discovery requests. After. In his motion, Folks has represented to the court that he has complied with all outstanding discovery requests. Example B. Before. The court, in reaching this conclusion, first discussed O'Neill vs. Quilter, in which the Texas Supreme Court had found a three-room house, built by a tenant, to be removable. After. In reaching this conclusion, the court first discussed O'Neill vs. Quilter, in which the Texas Supreme Court had found a three-room house, built by a tenant, to be removable. Example C. Before. The cases on which NECA Corporation relies, dealing with the narrow question of whether state statutes of frauds can bar 10b-5 claims predicated on otherwise valid contracts, do not dictate a contrary result. After. NECA Corporation relies on cases dealing with the narrow question whether state statutes of frauds can bar 10b-5 claims predicated on otherwise valid contracts. These cases do not dictate a contrary result. Example D. Before. In Barber vs. SMH US Inc., 9 IER. Cases 244, 1993, the Michigan Court of Appeals held that the plaintiff's reliance on a statement made by defendant that, as long as he was profitable in doing the job for defendant, he would be defendant's exclusive representative, as establishing an oral contract for just cause employment was misplaced. After. In Barber vs. SMH US Inc., 7, the plaintiff claimed reliance on the defendant's statement that, as long as he was profitable in doing the job for defendant, he would be defendant's exclusive representative. According to the plaintiff, this statement established an oral contract for just cause employment. But the Michigan Court of Appeals rejected this claim. Example E. Before. The interests of Fizel's children, who have been hanging in temporary care limbo since 2001, are paramount. After. The interests of Fizel's children are paramount. They have been hanging in temporary care limbo since 2001. 35. Don't separate a verb from its object. Quotable quotes. A frequent offense against ease is that caused by the separation of words that belong together in meaning, such as subject and verb, verb and object. Adams Sherman Hill, The Principles of Rhetoric 203, Reverend ed. 1896. Remember to keep the object of a verb close to the verb. In the negative, do not let a gap disrupt the natural relationship a transitive verb has with its object. C. Edward Good, Mightier Than the Sword 29, 1989. In seeking to understand a sentence, the reader's mind searches for the subject, the verb, and the object. If those three elements are set out in that order and close together in the sentence, then the reader will understand quickly. Richard C. Wydick, Plain English for Lawyers 43, 4th ed. 1998. Explanation. The rationale for the previous tip applies here as well. After encountering a verb, the reader naturally expects the verb's object to follow close behind. Put any modifying phrases before the subject or after the object. Some before and after examples. Example A. Before. Bradley testified in his February 8, 1995 deposition that he did not know the law had changed and that he thought the plaintiff was paying the bills correctly. After. In his February 1995 deposition, Bradley testified that he did not know the law had changed and that he thought Adams was paying the bills correctly. Example B. Before. After the Supreme Court's decision, this court granted, over the United States' vehement objection, plaintiff's motion for leave to amend their complaint. After. After the Supreme Court's decision, and over the United States' vehement objection, this court granted the Rittenberry's motion for leave to amend their complaint. 36. To write forcefully, end your sentences with punch. Quotable quotes. The emphatic position in a sentence is the end. The beginning is also an emphatic position, although to a less degree. Margaret M. Bryant and Janet Rankin Aiken, The Psychology of English 172, 1940. The most emphatic place in clause or sentence is the end. This is the climax, and, during the momentary pause that follows, that last word continues, as it were, to reverberate in the reader's mind. It has, in fact, the last word. One should therefore think twice about what one puts at a sentence end. F.L. Lucas, Style 39-40, 1955. A sentence must be so written that the punch word comes at the end. Carl Llewellyn, A Lecture on Appellate Advocacy, 29 U. Chi. L. Rev. 627, 628 1962. A word or phrase gains importance by being placed at the beginning or the end of a sentence. The end is the more important position of the two, for the sentence that trails off in a string of modifiers runs downhill in interest. By saving an important part of the predicate till the end, you emphasize the main idea. Alan H. Vrooman, Good Writing, An Informal Manual of Style 131, 1967. The strongest stress falls naturally at the beginning and at the end, and it is at these points that the important words or ideas are properly placed. Of the two positions, the last is most emphatic. If I had said, the last is the most emphatic of the two positions, the sentence would have been less forceful, since it would have ended with an unimportant word. Ellsworth Barnard, English for Everybody 110, 1979. A writer who wants a sentence with punch will generally avoid putting flabby elements at the end, and will prefer having the main accent at the end. Dwight Bullinger, Language, The Loaded Weapon 178, 1980. Because the end of a sentence is the last thing a reader sees, it is a position of emphasis. Don't use it to express minor thoughts or casual information. Don't write, both candidates will appear here in July, if we can believe the reports. This is correct only if you want to stress the doubtfulness of the reports. Don't write, pray for the repose of the soul of John Bowler, who died last week in Cleveland. Your reader will start wondering what he was doing in Cleveland. Daniel MacDonald, The Language of Argument 219, 5th ed. 1986. Make your sentences rise to a climax, let them reveal their most significant information at the end. David L. Carroll, A Manual of Writer's Tricks 63, 2d ed. 1995. Try to arrange sentences so that the most important words or ideas come at the end. Christopher Lash, Plain Style 81, Stuart Weaver ed. 2002. Explanation. Every sentence is a crescendo. The point eludes many people. The primary position of emphasis in an English sentence is not at the beginning, but at the end. Whatever you put there will get special attention. This means that we can deduce the following general rules. Don't end a sentence with a date unless the date is critical. Don't end with a citation unless the case name is critical. Don't end with a client's name unless it comes as a surprise. Don't end with a qualifying phrase such as in many circumstances, generally speaking, or the like. One way of testing how effective your sentence ends is to read aloud, exaggerating the last word in each sentence. If the reading sounds foolish, then the sentence probably needs to be recast. Some before and after examples. Example A. Before. Significantly, Gutierrez did not identify his ex-girlfriend, her brother, or Leuenberger as persons with knowledge of relevant facts in his routine discovery submitted pursuant to Local Rule 26. After. Significantly, in his discovery under Local Rule 26, Gutierrez did not identify his ex-girlfriend, her brother, or Leuenberger as persons with knowledge of relevant facts. Example B. Before. At the time when Paul's plane hit the ground, Paul's wife Betty was helping a friend with a garage sale. Shortly after the accident, Betty received a call from Billy Nugent. He came by and drove Betty to her parents' house, where she was told of the death of her husband about 30 minutes earlier. After. Betty, Paul's wife, was helping a friend with a garage sale when Paul's plane crashed. Shortly after the accident, Betty received a call from Billy Nugent, a family friend, who came by and drove her to her parents' house. There she learned that Paul had just died. Example C. Before. For example, in Steenbergen, defendants produced numerous documents in response to plaintiff's request for production. 814 SW2D at 759. Several documents were created by others or could not be verified as accurate or authentic. ID. The court indicated that P. Reduction of these documents expressed nothing more than Ford's belief that they contained information on passive restraints as described in plaintiff's request. ID. At 760. Thus, the documents were properly excluded since no authenticating testimony was given. ID. After. For example, in Steenbergen, defendants produced many documents at plaintiff's request. 814 SW2D at 759. Several either were created by others or could not be verified as accurate or authentic. ID. The court said that P. Reduction of these documents expressed nothing more than Ford's belief that they contained information on passive restraints as described in plaintiff's request. ID. At 760. But since no witness could authenticate the documents, they were properly excluded. ID. Example D. Before. The Buick being operated by Mr. Warren was owned by Neva Chowning and was being operated with the consent and permission of Ms. Chowning. After. Warren was driving the Buick with the owner's permission. Example E. Before. This action was filed in the State District Courts of Dallas County, Texas by Data Security on May 22, 1995. In addition to seeking damages under various business tort causes of action, Data Security sought injunctive relief against Nautica International. In the 3 weeks that followed, Data Security pursued discovery at breakneck speed in the course of obtaining temporary injunctive relief against Nautica International. After. Data Security filed this action in the State District Courts of Dallas County in May 1995. Besides seeking damages under various business tort theories, Data Security sought an injunction. And in the 3 weeks that followed, Data Security pursued discovery at breakneck speed. Example F. Before. It is undisputed that Deckard had no role in the decision whether to rehire plaintiff in 1993. After. It is undisputed that Deckard had no role in deciding whether to rehire Kirkland. Example G. Before. Brief of Kluwer Mutual Insurance Company in opposition to 5-Ash's motion for summary judgment. I. The manifestation rule governs this case. After Kluwer briefed its motion for summary judgment, a Georgia court issued a highly significant trigger ruling. See Plantation Pipeline Company vs. Lumberman's Mutt, Casualty Company, number D92719 DA. Super. Court, Fulton County, October 7, 1994 X. 67. Plantation Pipeline is the first and only Georgia authority to trigger coverage for environmental property damage cases. The court for Fulton County, Georgia, ruled that the manifestation rule governed an environmental property damage case. Plantation Pipeline involved petroleum contamination. Contrary to Five-Ash's assertion, the manifestation rule is hardly a dead letter. The Plantation Pipeline case shows that courts continue to adopt the manifestation rule for environmental property damage cases. See also New Hampshire Ball Bearings vs. Aetna Casualty, 848 F. Sup. 1082 DNH 1994, holding that the date on which coverage is triggered is the time when the contamination of the groundwater was reasonably capable of discovery. Five-Ash refers to a section of an article published by the Defense Research Institute, DRI, which Five-Ash identifies as wither manifestation. This 1.5-page tract does not state that an overwhelming number of courts reject the manifestation rule. The article notes that California has already adopted manifestation as the trigger rule for first-party property damage cases. See Prudential LMI Commercial Inns. Company vs. Superior Court, 51 Cal. 3D 674, 1990. The article also cites North Carolina and South Carolina cases, a Fourth Circuit case, and others that adopt the manifestation rule. After Kluwer's brief in opposition to Five-Ash's motion for summary judgment. 1. The manifestation rule governs because Georgia courts have adopted it. Five-Ash brought its bad faith claim merely because Kluwer has relied on the manifestation rule in this environmental property damage case. Although Five-Ash claims that this rule is insupportable and baseless, the only Georgia case on point, Plantation Pipeline, one which was decided only last month, adopts this very rule. In light of this precedent, Five-Ash's motion for summary judgment on the bad faith claim should fail. 37. Cut filler phrases such as there is and there are. Quotable quotes. The habit of beginning statements with the impersonal and usually vague there is or there are shoves the really significant verb into a subordinate place instead of letting it stand vigorously on its own feet. David Lambeth et al. The Golden Book on Writing 19, 1964. The trouble with there has nothing to do with grammar or with correctness of any kind. It's a perfectly proper word, and it moves in the best circles. You will find it in abundance in the work of the most distinguished writers. But the fact remains that it is one of the most insidious enemies a beginning writer faces in his search for style. It is the enemy of style because it seldom adds anything but clutter to a sentence. And nothing saps the vitality of language as quickly as meaningless clutter. Lucille von Payne, The Lively Art of Writing 64-65 1965. Explanation. When you need to talk about the existence of something, you'll need there is or there are. For example, despite what Jackson claims, there is a good reason for this rule. There are several possible objections to this question. But most of the time when you see one of these phrases, you'd be better off cutting it. By doing that, you'll almost certainly supply the sentence with a stronger verb, and you'll eliminate some unnecessary words. Some before and after examples. Example A. Before. There are 3 reasons why the court should overrule that case. After. The court should overrule that case for 3 reasons. Example B. Before. There is no medical evidence to contradict Drive. Goodman's opinion that an award should be apportioned 50% to the special fund and 50% to the employer. After. No medical evidence refutes Drive. Goodman's opinion that an award should be apportioned 50% to the special fund and 50% to the employer. Example C. Before. To date, there have been no such third-party actions in the Hunt County suit. After. To date, no third-party actions have been filed in the Hunt County suit. Example D. Before. It is apparent that the parties to the agreement did not intend that Fortis Inc. could sue for its breach. After. The parties did not intend that Fortis Inc. could sue for breach of the agreement. 38. Eliminate throat-clearing phrases. Quotable quotes. I might add, it should be pointed out, it is interesting to note that, how many sentences begin with these dreary clauses announcing what the writer is going to do next. If you might add it. If it should be pointed out, point it out. If it is interesting to note, make it interesting. Being told that something is interesting is the surest way of tempting the reader to find it dull. William Zinsser, On Writing Well 16-17 5th ed. 1994. Make every word tell. Rooting out verbiage isn't easy. Verbosity often results from quick, facile writing. Watch out for recurrent phrases that are the verbal equivalent of throat clearing, for example. In my considered opinion, may I respectfully suggest that. I should note here that it would be helpful to remember the fact that. It should not be forgotten that. It is also of importance to bear in mind the following considerations. Consideration should be given to the possibility of carrying into effect. These needless build-ups wrap the reader's mind in wool before the point can be made. Forget the opening flourish and say what you mean. Brian A. Garner, The Elements of Legal Style 53-54 2D ed. 2002. Explanation. The English language is full of phrases that allow you to make noises as you prepare to say something. For example, it is important to remember that. It is noteworthy that. It is not unworthy of mention in this regard to note that. It must also be borne in mind that. These may have a place in speech, which is almost always wordier than good writing. They can warm up the speaker's sentence. But in writing they take up precious space. They're symptomatic of a verbal tic with which some writers are afflicted. The good news is that if you can recognize the tic, it's easy enough to rid yourself of it. Some before and after examples. Example A. Before. It is respectfully submitted that genuine issues of material fact remain such that defendant's motion for summary judgment must be denied.